Mr. Oh, never mind.
All right, good morning. This is Chair French. We are now on the record and video streaming, and I'm calling the evidentiary hearing to order. My name is Andrew French. I'm Chair of the Kansas Corporation Commission, serving as presiding officer for this hearing. I'm joined by my fellow commissioners, Dwight Keene and Annie Keither. This is docket number 25 CONS 3040 CMSC, captioned in the matter of the petition of Daylight Petroleum LLC operator to open a docket pursuant to KSA 655-605A regarding a fluid leak in Section 16, Township 30 South, Range 16 East, Wilson County, Kansas. As we always do, we're going to begin with the entries of appearance, and I will start with counsel for commission staff.
Good morning, Chair French. Kelsey Marsh on behalf of Commission staff.
Good morning, Mr. Marsh. And for operator Daylight Petroleum.
Daylight Petroleum appears by its attorney, Keith Brock.
Good morning, Mr. Brock.
Good morning.
All right, we'll now move to notice. Does staff have any recommendation regarding notice of this hearing?
Yes, notice of this hearing was contained in the presiding officer's January 22nd order setting an evidentiary hearing in this docket for today's date beginning at 9 a.m. via the Zoom video conferencing platform. The presiding officer's order was properly served on the parties. Additionally, the operator published notice of the evidentiary hearing in the Wichita Eagle and the Wilson County Citizen between January 29th and January 30th, 2025, in compliance with KAR 82-3-135. I would also note that the operator and its counsel are in attendance today. Staff recommends that notice is proper and the commission has the jurisdiction to hear this matter at this time and place.
All right, thank you, Mr. Marsh. Are there any objections to notice? Hearing none, and based on staff's recommendation, I will find that notice is proper. The commission has jurisdiction over the proceeding at this time and place. Let's turn to preliminary matters. And before I ask the parties for any, just some procedural items for me. Some reminders. First, because we're doing this over Zoom, if you do have any technical issues, please just ask to go off the record. We can go into recess and resolve that technical issue before we go back on the record. Second, we do ask witnesses and all participants to keep your microphones off or muted when you're not scheduled to talk. And if everyone would also please mute your cell phones, other phones in your offices, electronic devices, that would be appreciated. Third, so the parties are aware, if the commission does need to consult among ourselves for something like an evidentiary ruling, we may go off the record and enter into what's called a Zoom breakout room to discuss that, and then we'll return and come back on the record. Fourth, this is a reminder we always give because we're doing this on Zoom. Please be very careful to identify exactly what documents you're referring to when you're discussing pre-filed testimony or exhibits. We should have copies of everything on hand, and we should be able to follow along as long as folks are clear in identifying what they're speaking about. So with that, let me ask if the parties have any other preliminary matters they would like to take up at this time. And I do know there were some sort of pre-written objections, evidentiary objections flying around. I have, and I think the commissioners have all had the opportunity to review those objections. Would the parties like to address those in a sort of a bulk fashion on both sides at this time, or would you like to address it during each witness?
I'm fine with either, Chair French. I think it's whatever the commission's preference is.
I'm really agreeable to either one. I mean, my intention is just to kind of state my reasonings one time. Whether it's at the first witness or now, it really doesn't matter. It doesn't matter to me, but I won't make you hear it 3 times.
Well, I appreciate that. I don't think this is going to surprise anyone. I have reviewed both parties' objections, and at this time, I'm not going to sustain any of the objections. It's not to say that your objections were wasted, but what we're going to do is we will accept all of your written objections. I will have them marked as commission exhibits. John may have to help me if we want to do Commission Exhibit 1 and 2, I think we got 2 separate documents from staff. I presume that they just want the last document as an exhibit. What we'll do is we'll mark those as exhibits, and we will let your arguments go to the weight of the evidence, but we won't be excluding any of the parties' testimony on either side, basically. So I hope that speeds things up a bit. Of course, you are free to renew your objections as we take up each witness, but from my perspective, that's not necessary because we are going to accept those written objections into the record. You can consider that your objections are noted, they are on the record. We are going to take them into account as to the weight of the evidence. So no need to renew your objections, but you are welcome to if you want to. So if the parties either one would like to add to their objections or speak to their objections now, I will give you further opportunity. Mr. Brock, would you like to add anything?
I would like to explain my 2 objections just because I feel like they're material in this particular docket. And so I understand exactly what the commission's saying, and I'm not trying to argue that. I just would like to be heard if the commission would indulge me.
Please go ahead. And of course, this is recorded. So whatever you say will be part of the record.
Okay. So I really have 2 objections that are just reiterated multiple times that have been incorporated. The first one is that the opinions that have been offered by several of the staff witnesses, particularly 2 opinions, in my opinion, do not meet the legal criteria for expert testimony. The whole purpose of expert testimony, there's 2 parts to it, is the first, the expert has to be qualified as an expert through education, experience, etc. But the second test, and this is the test that I believe has failed, is the reliability of the testimony. And if we remember back in law school, remember the Dalbert factors that are applied. And if in this case, the staff's witnesses, they are professionals, geologists, but they have not applied any geological science in order to reach the conclusions. The purpose of that gatekeeping function is to make sure that the evidence that's entered into the record has actual evidentiary value and is not just an unsupported opinion. Looking at the Kumo Tire case, the court explains that it's to make certain that an expert employs in the courtroom the same level of intellectual rigor that characterizes the practice of an expert in its relevant field. In that case, they excluded the expert testimony, finding that there's no indication in the record that other experts in the industry use that approach, and also that the parties didn't refer to any articles or papers to support it. Just reciting really quick the Dalbert factors is basically that the theory or practice has been tested, that the theory or method that they're using has been subject to peer review, that there's whether or not there's a high known potential for the rate of error in the standard or method. And then the second is that are the standards whether there are standards controlling the manner in which they applied that method, and then finally, whether that method is generally accepted within the industry. We'd submit that the methodology used isn't supported by any of these factors. And the reason that I wanted to be heard is because in this particular case, the 2 areas really are material to this docket. And so it will become a sufficient or a competent evidence question if the commission bases its ruling upon those opinions, whether or not the evidence that supported them was competent. And so that's the only reason I take that time. The second objection is really only to Mr. Hoffman's testimony. And Mr. Hoffman's testimony is full of legal arguments, statutory construction. It states staff's position to the commission. All of those things would be appropriate for the staff to do in its brief, but those things are not evidence and shouldn't be allowed to be admitted into evidence. He's an attorney. He's not an expert in the field. He doesn't have direct involvement with this. It's essentially him explaining to the commission his position and why he took it. while that may be useful in a brief, that's not evidence. And so that's the basis for our objection to that. And those are really the only two objections, and I won't make you hear any of that again, but thank you for the indulgence.
Thank you. Mr. Marsh, do you wish to speak to your objections, or I have pulled up the documents and I am going to share them before we move on to make sure that I've captured the correct documents. But first,
Sure.
would you like to speak to yours? Mr. Myers, go ahead.
Chair French, John Myers here. It's that second document that I think
Yeah.
is.
I think there was an email from operator on February 19th yesterday, and then there was a later email from staff later in the afternoon yesterday. Those are the two that I have documented. Yes. Okay. Go ahead, Mr. Marsh.
I won't belabor the commission's time. I think, the objections speak for themselves. And I think, a lot of the objections that Keith has brought up could be applied to his own witnesses as well. So, that being said, we're fine with proceeding.
Okay. As I mentioned, I am going to briefly share these documents just to make sure we have captured the correct ones. So let's see. All right. Do you all see my screen? Do you see an email from Mr. Brock?
Yes.
Okay. Mr. Brock, does that look like the correct email that you sent noting your objections?
I believe so, Mr. Chairman.
Okay. John, we will mark that as Commission Exhibit 1. And then, Mr. Marsh, do you see now your email on the screen noting your objections?
Yes, Chair French.
And John, we will mark this as Commission Exhibit 2. With that, I am going to stop sharing. And unless, anybody wants to see anything else on my computer screen. With that, I think we have handled the evidentiary issues. Are there any other preliminary matters that the parties would like to address at this time? All right. With that, we will move on and discuss the procedure for the hearing. Parties are typically going to be allowed to make opening statements if you wish. And then after opening statements, we have examination of the witnesses. After the direct examination of each witness, we'll give an opportunity for cross-examination, commissioner questions, and then we will allow redirect. Any further examination will just be at the discretion of the commission. Following witness examination, we will allow closing statements, and we will arrange for the potential filing of post-hearing briefs if the parties believe it's necessary, and then we will conclude the hearing. So we will now move to opening statements. I understand that the parties did not establish any particular time limits for opening statements, but given the amount of witnesses that we have, hopefully you all can keep opening statements somewhat brief, but I don't plan to be strict in enforcing any particular limits. So with that, we will start with Mr. Marsh for commission staff.
Thank you, Chair French. On July 29th, 2024, Daylight Petroleum submitted a petition to open this docket. Daylight's reasoning for petitioning or opening the docket was a request to determine whether being required to locate and plug a well constitutes economic waste as defined under 55 for K.S.A. 55-601 and 55-602. The short answer to that question is no. Chapter 55, Article 6 of the Kansas Statutes Annotated, excuse me, is titled Crude Oil or Petroleum Production and Sale. There's nothing in the title or language of this statute that suggests the economic waste discussed therein applies to locating and plugging abandoned wells. Additionally, K.S.A. 55-701 and K.S.A. 55-702 provide important context as they also discuss waste. Article 7 of Chapter 55 of the Kansas Statutes Annotated is titled Production and Conservation of Natural Gas. 55-702 specifically states economic waste shall mean the use of natural gas in any manner or process except for the efficient light, fuel, carbon black manufacturing and repressuring, or for chemical or other processes by which such gas is efficiently converted into a solid or liquid substance. There's no mention of locating, plugging an abandoned well being economic waste in that statute. And I think it's safe to say that the same could be applied to 55-602. Based on the law, Daylight's petition fails to raise a sufficient legal basis in order to be granted any relief under these statutes. Daylight provides a false narrative that staff is attempting to force them to tear down a building in order to locate and plug this abandoned well. However, Daylight does not provide any evidence that supports that false narrative, and staff is confident that the well can be located and plugged with minimal impact to the building. Since staff has never indicated that the building needs to be torn down, I think it's fair to question why we are even here. While this is certainly not an ideal scenario, the cost to locate and plug this abandoned well will not be near the cost that Daylight attempts to scare the commission into believing. Thank you.
Thank you, Mr. Marsh. Mr. Brock.
Thank you, Mr. Chairman. If the commission would allow, I'd like to share my screen just to display a short PowerPoint.
Yes, go ahead. If you have any trouble, we'll see if we can troubleshoot, but you should be able.
Is that sharing?
Yes, we see it.
I have two screens. Is it the correct one? I'm sorry.
It looks like a PowerPoint presentation to me. It says Daylight Petroleum LLC and the docket number.
I always have a fear I'm going to show the wrong one. So
yep.
Thank you. Okay. Okay. So in terms of the nature of the case, as Mr. Marsh said, this case began when produced fluids started seeping up through the floor of a commercial building, essentially coming up through the concrete around where the electrical conduit had entered the building. The parties did a series of injection tests, and it was determined that Daylight's Olenhausen number 6 injection well was in communication with that breakout. Injection into the Olenhausen number 6 has been discontinued, and the breakout stopped visibly at the surface when that injection was discontinued. Daylight has not resumed production, nor is Daylight asking for permission to resume production. So this wouldn't be a big deal, wouldn't be a unique case, but for the fact that this breakout is underneath the commercial building. And so there are some unique facts about the commercial building that the commission needs to be aware of. The first is that the replacement cost of the building is over $100,000, or I'm sorry, over $1 million. The second and perhaps most important thing to this proceeding is that that building is heated by an in-floor radiant heat system. Another factor is that that building is used to repair heavy equipment, meaning that if the floor is cut and any repairs are made, that there will be extremely heavy weight driven over those repaired areas. The commission will receive expert testimony indicating that if any portion of that floor is cut, this in-floor heating system cannot be adequately repaired, that there's a high chance of initial failure, but also a high chance that it will fail at some point in the future. And so therefore that building can't be repaired without replacing the entire floor and the entire in-floor heating system. The next thing that's important is that this building owner will not grant Daylight permission to conduct the operation that staff is ordering it to do. Daylight doesn't have an active lease on this property, and so it can only act within the scope of the permission given to it by the property owner. And this property owner has refused Daylight permission to cut into this floor, citing that there would be irreparable damage to its building. In addition, this landowner has hired an attorney, and they promised litigation if this building is damaged in any way. So because of these unique factors and sort of these extremely high-end costs associated with dealing with this, Daylight has gone to great steps to try to resolve this situation without damaging the building. To date, at the time that the pre-filed testimony was submitted, Daylight had already spent well over $100,000 searching for the possible abandoned well under this building. But all of these efforts failed to locate an abandoned well. Daylight cut out the concrete driveway with the permission of the landowner, because the in-floor radiant heat didn't extend to that area. They dug a monitoring pit. They dug back underneath the building as far as they could do safely and without damaging the building. They also had a contractor come in with a hydrovac, and they hydrovac'd all along two sides of the building that weren't covered in concrete and underneath the building as far as they possibly could to search for a possible abandoned well. That didn't locate an abandoned well either. Finally, Daylight hired a third party to perform a ground penetrating radar survey over the area through the concrete floor to look for a potential abandoned well, believing that if abandoned well exists, this ground penetrating radar should pick up the surface casing and production casing associated with it. This did not detect an abandoned well either. Finally, Daylight had someone run a magnetometer over the area that basically searched through the floor and the adjacent areas, trying to identify the metal well casing and surface casing that would be present if there was an abandoned well. This step also didn't fail to identify an abandoned well. Finally, Daylight hired a reputable third party, K.S.A Engineering, to help them try to find ways to locate this well and protect fresh and usable water at the same time. Daylight then drilled 4 groundwater monitoring wells, penetrating the entirety of the Table 1 groundwater formation. They also installed 4 shallow piezometers to test for surface contamination. They performed various injection tests. They've plugged a total of 7 other wells nearby. They provided this quarterly water monitoring, analysis, and sampling, and then they've consulted with any other expert that they could possibly find that might have an answer to this situation. The point being that they did all that they could to try to see if they could find an abandoned well without exceeding the landowner's permission, without causing damage to their building. So the conclusions of all this is that after all the money spent, all the efforts taken, there has been no abandoned well located beneath the building. Through the groundwater monitoring wells, we've also determined that at its highest level, the chloride concentrations are extremely low, even suitable to be used for livestock purposes at their current rates. The groundwater present is so minimal that it likely could never be used for any commercial residential purpose in the future. When they were initially drilled, one of them produced only 2 gallons of water. When the experts try to purge the well, trying to remove only 30 gallons of water from the wells, they completely run dry and won't recharge. So the likelihood of anyone ever being able to use this water is very low as well. In addition, Daylight has taken every possible step that either it or commission staff could think of to try to locate this well, both acting within the scope of its permission given by the landowner and that it could find as a possible solution. In essence, at this point in time, staff is ordering Daylight to take steps that it legally doesn't have the right to do, to trespass onto someone else's property and start damaging an improvement on there when the owner has expressly told them that they do not have permission to do that and will be sued if they do. In addition, the conclusion is that there is in existence at this point a groundwater monitoring program. This program has verified that fresh and usable water is not being impacted. And in the future, if there were any discovery that fresh and usable water were impacted, these wells can be used to remediate and address any concern if and when it does arise. But that isn't the case at present. But after all of this, KCC staff is still adamant that Daylight begin cutting the floor and looking for this abandoned well. And so, feeling that Daylight was between a rock and a hard place, on one side, the landowners telling them it'll be a trespass, on the other side, KCC saying, forge ahead, Daylight feels it has no other option but to seek an order from the commission trying to find a reasonable resolution to this situation. And so that's basically the dilemma that Daylight is being placed in. This is one of those things that I feel like the commission needs to look at the entire process. If we look at only the step that's right before us, pretty soon both of us are going to be down a path that neither one of us wants to be on. So there's really two legal questions that are involved. The first is, who's responsible for plugging a well if it can be found? So once a well's found, that question becomes a pretty easy question. That's the only question that staff is looking at right now. But the more important question is, who will be responsible for rebuilding or repairing this landowner's building? That is not a legal question that is simple to answer at all. In fact, there's no statutes, regulation, lease, or anything else that's in place that would require Daylight to rebuild someone's building, even if it were responsible to plug an abandoned well if someone could find one. And so then the analysis would have to go to a negligent argument. Is Daylight negligent merely because it injected into an injection well at authorized rates and pressures pursuant to a permit that this commission granted? Then next, the question would go to a realm of reasonable foreseeability. I know that's a question that it's been many years since I've looked at since law school, but this is what would be involved in this case. When Daylight injected returned produced water to the formation from whence it was taken, was it within the realm of reasonable foreseeability that a $1 million building would need to be torn down and rebuilt? These are the legal dilemmas applicable to Daylight, but there are also dilemmas applicable to the commission. And these are the things that I want to make sure that the commission understands. Daylight does not have permission to go onto this property. And so that means that the commission likely would have to have one of its agents do that under 55-182. Under that specific statute, it says that an agent is not responsible for damage when acting as an agent of the commission, except for damages to improvements. So that would imply that whoever the commission hires to do this work would clearly be responsible for repairing a building. Then the next question goes to whether the K.S.A. assumes vicarious liability for employing that agent to go out and do that work. There's also a question about whether the destruction of that building would be an inverse condemnation, would be a taking by the commission through its official act. My point is not this is not intended as a threat. This is intended to show the complexity of this situation and why we needed to put it in front of the commission before it got out of hand. What we have here is a perfect law school exam question. It has torts, agency law, constitutional laws, all of these things. But the difficulty is that there is no clear answer to any of these questions. And in any of these cases, everyone who could be responsible ends up getting brought into that suit by the landowner. And essentially, we'll all be playing a high stakes game with this law school exam question, predicting whether we can answer it the same way as whatever judge it's assigned to. So because this is the result and this is the path that these actions lead to, Daylight filed this docket in hopes of taking an off-ramp before this situation gets here. So what's the purpose of this docket? If the commission can find a way to balance its two duties to protect fresh and usable water while also preventing destruction or the change in construction of this commercial building, all of those issues go away. None of those law school exam questions have to be answered. None of us have to make arguments in there. The whole situation is just resolved. In this docket, the commission has two competing duties. The first is the prevention of waste. We will, in our briefing, we'll lay out why this constitutes waste. The waste is not an increased expense incurred in plugging. The waste is the destruction or change in construction to this commercial building. The commission has prior opinions that it has issued indicating that destruction or change in construction of a building constitutes economic and surface waste. There's also court cases that have reviewed this commission's opinions that also found that destruction and change in construction to buildings constitutes surface and economic waste. We'll lay these out in our brief. The second one is obviously to protect fresh and usable water. And the commission can fulfill that statutory directive in any way that it sees fit. I understand that the ordinary process is by locating and plugging an abandoned well, but this is a unique situation, and I don't think anyone can argue that it isn't. Groundwater monitoring is a commonly accepted practice across the entire nation in all sorts of areas. And whether the commission accepts that as an alternative or something else, the commission needs to balance these two duties in some way. And if it can find a way to avoid the destruction or damage to this building, the situation's resolved. And so we filed this docket in order to ask the commission first, what should be done? What should we do with this situation? This thing is so unique, we don't know what to do. And so we filed that with the commission, hoping that, hey, if we can decide what needs to be done, we may never get to the question of who's responsible. And that whole argument will just resolve itself. So that's why we're here today. That's why Daylight initiated the docket, and that's what we're hoping the commission can accomplish. I thank you for listening to me, and that's all I have for my opening statement.
All right. Thank you, Mr. Brock. All right. We will now move to the examination of witnesses. We are going to begin with staff. So, Mr. Marsh, if you are ready, you may call your first witness.
Thank you, Chair French. Commission staff calls Ryan Hoffman.
Good morning, Mr. Hoffman.
Good morning.
Before I let you go with Mr. Marsh, I'm going to get you sworn in. Do you swear, or please raise your right hand for me. Do you swear or affirm the testimony you should give today is the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you. Please proceed, Mr. Marsh.
Thank you, Chair French. Please state your full name and title for the record.
Ryan A. Hoffman, the Director of the Conservation Division for the Kansas Corporation Commission.
Are you the same Ryan Hoffman who caused to be filed in this docket rebuttal testimony consisting of 13 pages and 3 exhibits on January 31st, 2025?
Yes.
Do you have any corrections to make to your testimony?
No.
Do you swear the answers contained in your pre-filed testimony were and are true to the best of your knowledge?
Yes.
At this time, staff moves for Mr. Ryan Hoffman's pre-filed testimony and exhibits to be admitted into the formal record.
Are there any objections?
We just incorporate I think I was Exhibit 1, Commission Exhibit 1.
Very well. Noting that objection, which I have previously handled, the reference testimony will be admitted.
Thank you. Commission staff tenders the witness for cross-examination.
All right, Mr. Brock, please proceed.
Thank you. Good morning, Mr. Hoffman.
Good morning.
Can you list for me every proposal which commission staff has made in this situation to Daylight in order to address the breakout in a way that staff believes will protect fresh and usable water without causing any damage to the commercial building?
I think that would probably be more appropriate for Troy Russell, as he would be more involved in those negotiations.
I guess I'm just puzzled because a big portion of your testimony went toward staff's reasonableness of dealing with Daylight. But
Sure.
now,
Well, in response to that, then I guess if I said it in my pre-filed testimony, then that's what we're talking about. If you think about how long this matter's been going on and the amount of time and options, I think staff has been fairly reasonable. And to be clear, staff has never demanded that the building be torn down.
So the question then was, list each proposal that the staff has made that doesn't require the building to be damaged.
And I told you that
Okay.
I don't know every proposal that staff has made. That would
Right.
be more appropriate for staff who does the proposing.
Okay. So would you agree that essentially commission staff is ordering Daylight to enter private property that it does not have a valid lease upon and damage a building that's owned by a third party who's expressly refused Daylight permission to do that?
No,
You believe they have given Daylight permission to do that?
no, I wouldn't. You asked me if I would agree if we're asking them to trespass onto another property and destroy a building, and that's not what we're asking.
What are you asking?
Asking to collaborate with us to help locate that abandoned well so that it can get plugged without damaging the building as much as possible.
And so I guess that goes to my first question. What ways has staff offered to address this situation that do not involve damaging the property?
Has
Well-
the answer, objection.
Overruled.
Well, as you can read in the testimony, there's been the ground penetrating radar. There's been the stuff you laid out in your opening about the pit and the hydrovacing. There's apparently a magnetometer that I don't think we've seen those results. But nonetheless, I think that timeline brings you up to when you filed this docket. It sort of cut off any further potential options.
And when you agree that this docket was filed because commission had sent a letter basically threatening to bring the matter before the commission if Daylight didn't do something?
Well, yes, that letter did have a deadline, but it wasn't the first letter. And after the first letter, we extended because Daylight was cooperating and working with us.
And so this may be a question for Troy again, but if you can answer it, I'd like for you to. Is there anything that staff asked of Daylight in order to try to permanently address this situation that did not involve damaging the building that Daylight refused to do?
Not to my knowledge,
Okay, thank you.
but I don't think staff has asked them to damage the building either.
So let's just shift gears. I don't have a lot of questions for you, but I just want to shift a little bit. So let's clarify. Daylight had submitted a proposal through its witnesses in this docket concerning the KDHE VCPR program. And so that's not the question. I'm just painting the subject matter, I guess, of what I'm going to ask. Is it your understanding, or let me ask it this way, do you understand that Daylight's proposal concerning the VCPR program does not involve the commission relinquishing any authority or jurisdiction?
I don't understand how that would be possible, given that the statute says we have, the statute I'm referencing would be 74-623, says we have exclusive jurisdiction over the oil and gas industry, including the pollution and remediation from oil and gas activities, pollution cleanup. So I think we would have to enter into some MOU or some other program where we would have to agree to let KDHE administer that program over the oil and gas pollution.
But as you indicated earlier, this is just a voluntary program. And I guess all I'm wanting to clarify is that Daylight is not asking the commission to give up any authority or any jurisdiction at all. Do you understand that part of the suggestion?
I guess maybe I see it differently, because if they do that program, then we are essentially out of the picture.
I guess that goes to our, I mean, we're going to get into the legal weeds about it. I guess I was just trying to clarify intent. I won't go further down that. Do you understand that the purpose of suggesting the VCPRP program was so that an environmental use control could be placed on the property that would effectively run with the title to the property in hopes of preventing a future breakout from occurring?
Yes, sorry, you couldn't hear my head shaking up and down.
Thank you. And do you also understand that a further purpose of the VCPRP proposal was to provide both Daylight and the commission with additional help and resources, both to protect fresh and usable water, but also to monitor and oversee this groundwater program?
I guess I look at it differently, and I don't know that we as the commission staff needed the help. We have 41 contamination sites throughout the state where we do long-term monitoring and remediation. So
Okay, so just to clarify, the objection is that you don't believe that the KCC needs any help. So is that what you're saying?
well, I think so. I think again, our preference would be to locate the abandoned well and plug it to eliminate the threat.
Shifting gears a little bit more, how many employees does Daylight have?
That I don't know.
Do you know how many corporate offices that they have?
Nope.
Do you know anything about the nature of their operations in other states?
Only what I think you have provided.
Are you familiar with Daylight's current financial position?
No.
Are you familiar at all with Daylight's corporate structure?
No.
Are you familiar with Daylight's track? My screen froze just for a second, and
Keith, if you can hear us, you are breaking up and you're frozen. You may want to turn your camera off.
I don't know for sure.
We are not hearing you right now, Mr. Brock.
Did that fix it or?
We can hear you now and I can see you now.
Okay. So they're redoing the internet in Ottawa, and so I apologize, but I don't believe that it's in our system, and I don't know
Okay.
what I can do about it. So
Yeah, the only and you seem to be fine now. Seem to be a momentary blip. The only suggestion I would have is if it does happen to be a bandwidth issue, you can always turn your camera off. And that seems to make, at least you can continue with audio. But we'll hope that it just doesn't happen again. But you can proceed, Mr. Brock. Unless you're frozen again. All right. Why don't we go?
So
We're going to recess for just a moment to resolve this technical issue. We are now off the record. All right, Mr. Brock, can you hear me?
I can hear you, Commissioner.
Do you want to try to proceed with your camera off for a few moments, or would you like to, just in case it's an issue with the Zoom platform, do you want to try to leave the Zoom and re-enter it?
Yeah, I would be, I'd be willing to try either one of those things or both of them.
Why don't you leave and come back just to make sure that you don't have some issue connecting with Zoom? I doubt that's the issue, but why don't you do that just to make sure we have our bases covered, and then we'll try to proceed camera on, and then if that doesn't work, we'll have you turn your camera back off.
Okay, thank you.
I hate to force you to have your camera off. Well, go ahead. I'll let you leave, and hopefully no issues re-entering.
Clock is coming back in now.
Okay, thank you. All right, Keith, I see you're back. If you're able to, all right. Why don't we try to proceed? Go ahead, speak for me to make sure we've got your audio.
Yeah, can you hear me?
We do hear you. Okay, what we're going to do is we're going to go back on the record, let you continue your questioning. If we have, further connection issues, I will have you turn your camera off. I apologize for that. But okay, at this time, we are back on the record and Mr. Brock is proceeding with his examination. And it looks like we are frozen again. Mr. Brock, if you would turn your camera off and we'll see if we can reacquire your audio.
Okay, can you hear me now?
We do hear you. And if we have further issues, what we may do is just have you call in on the telephone.
Absolutely, I'd be happy to do that.
Please, we are still on the record, so please proceed with your cross-examination, Mr. Hoffman.
Okay. Mr. Hoffman, right as I cut out, I had asked you the question, do you have any personal knowledge of I had asked if you were familiar with Daylight's track record for regulatory compliance in other states. I'm not sure if you answered it or not, but I couldn't.
No, I'm not, Keith.
Okay. Do you have any personal knowledge of the nature of the transaction where Daylight sold 54 of its Kansas leases?
Nothing beyond what you've shared.
Do you know what the sales price was?
Not off the top of my head, no.
Do you know if properties outside of Kansas were involved?
I do not.
Do you know when the negotiations for that transaction first began?
Again, not beyond what you've provided in that email.
And so just to clarify, without having any direct knowledge whatsoever, you still testified under oath the operator is attempting to divest itself of interest in the state of Kansas in order to walk away from an issue involved in this docket. And you further allege that Daylight's actions were designed to enable Daylight to reduce the capital available to address the problem it created.
Yes.
I have no further questions.
All right, thank you, Mr. Brock. We will now move to commissioner questions. Commissioner Keene, do you have any questions for Mr. Hoffman?
Just a few, Mr. Chair. Good morning, Mr. Hoffman.
Good morning.
How widespread, Ryan, is the KCC use of monitoring wells?
You mean in lieu of, I mentioned we've got 41 projects statewide where we monitor pollution that's related.
I understood that. Right. Let me maybe re-ask that in a slightly different way. I'm trying to really beat in on this thing. How does an environmental threat become or morph into a monitored contamination site? How does that happen?
Generally speaking, most of the ones we have are not related to wells. They would be like old historic pit, evaporation pit type things where you've got an entire aquifer that's been contaminated. There are a few that we have monitoring wells around old injection wells that have become sinkholes and where we couldn't really access the well anymore.
So again, let me try to put maybe a little better beat on this thing here. So what are the various reasons then or purposes for utilizing monitoring wells? What's behind it?
Well, it's just in those cases we're monitoring the contamination to see if it's getting worse or not. In some cases we have injection or not injection wells, but we use our monitoring wells as interceptors for chloride plumes, and then we will take that chloride out and dispose of it in one of our disposal wells, and we will have monitoring wells downstream from that to make sure that we are effectively capturing the chlorides.
What is there about this circumstance that, and I guess in your opinion, and I shouldn't be drawing conclusions about your opinion, so let me rephrase that. Why would this particular circumstance not qualify to become a contamination site with monitoring wells?
In large part, It's because I don't believe that we've exhausted all options. And also this site is different in that we don't have, or we have somebody who is responsible for the contamination in those areas. Those are mostly legacy issues that the state was handed.
Well, this would be a case where the state and the operator are handed environmental circumstance, are they not? With some questions about the source.
Well, again, I think we're not there yet. I think it's premature to say that it's been handed to us.
What additional steps do you believe the operator should take or should have taken that they haven't?
Well, I think that's more laid out in Troy's rebuttal testimony about how there are other options. He feels there are other options that we can pursue to try to find that well.
I appreciate that, but I'm trying to tie this back to the question about whether or not this could potentially become a monitoring site.
Well, and that's what I'm saying is I think that Troy answers those in his rebuttal testimony about what steps we could take before it becomes to that point, before we would give up.
Okay. I don't think I have any further questions at this time. Thank you.
Commissioner Keither, any questions?
Not at this time. Thank you.
I'm pausing because I'm struggling with whether my questions are for you, Mr. Hoffman, or whether they're for Mr. Russell, probably in the same vein as Commissioner Keene.
Well, if you want to give him all the hard ones, that's perfectly fine.
I think that's what's going to happen. Well, let me just ask you, and you can go ahead and defer it. But if you can just speak globally about your discussions as staff and why you believe that what Daylight has proposed as far as groundwater monitoring is insufficient. Do you feel like the threat to fresh and usable water is imminent? I mean, from what I gather from their testimony and Mr. Brock's statements today, I mean, they seem to say there's very minimal impact on a very small amount of groundwater, seems to be very localized. What causes staff to find that insufficient to just discontinue the injection that's causing continued pollution and monitor the site? If you could just globally address that, since you are the director, and then I can follow up with specifics with Troy.
Well, there are two concerns, and one of them is just because we're not injecting into that well and pushing chlorides or contamination into the usable water doesn't mean we haven't created a pathway for that usable water now to then be lost forever. It could go back down the abandoned well. It could go through that channel back over to the injection well. And it may not be a tremendous amount of water, but I would say thanks to the commission giving me the opportunity to be involved in all these water issues, I can tell you that water is kind of a big deal. And even losing a little bit of it is important. We should protect and not try to lose that fresh water. Second of all, if we know there's an abandoned well under this building now, that essentially forecloses any future activity, oil and gas related, around this building. So it's not just the water. I mean, you want to talk about waste there, we would essentially be like drawing a quarter-mile circle around this abandoned well, and there would never be injection allowed around it.
And has staff taken into consideration the likelihood that to solve this issue permanently, that there would have to very likely be damage to the improvements on the land?
I don't know that we're as foreclosed on that subject as the operator.
Okay. So it is not staff's position that this needs to be permanently remedied, regardless of damage to the improvements, at least yet. It is staff's position that there are further actions to be taken before we make that assessment.
Correct.
Okay. I think that's all I have for you, Mr. Hoffman. I did see Commissioner King go back on camera, so I may have prompted a question.
Actually, you did. Mr. Hoffman's response to your question prompts my question, which I was going to save for other staff witnesses, in particular, Mr. Russell. But Brian, I'm going to have to come back and double back here a little bit because I may have misunderstood you, but I thought I understood you to say that you know that there is an abandoned well under this property or building. And my question is, how do you know that?
Well, number one, I trust my staff who's been doing this for longer than anybody. And when you see something come up, when you see oil and brine come up out of the ground out like that, and it's related to an injection system, there's got to be a conduit. And they can raise seeps, they can raise faults, but they provided no evidence of any of those. It's not uncommon for us to find wells when somebody injects into them or fracks into them or anything. Even on this property, we've discovered wells because of their injection activities or their fracking activities. So am I 100% certain? No, that makes me think of the movie Tommy Boy and the quote about the butcher. You know, you can never be 100% certain, but you trust the person who does that work. And I trust my staff when they say, we think there's a well there.
I will pursue this in much greater detail with Mr. Russell, but I still have to ask a follow-up question. Are you absolutely certain? I mean, you know how dynamic events can be below the surface, where things that you might not at first blush believe could happen actually seemingly upon further investigation or guesstimation do happen. For example, is it not possible that there could be an abandoned well either off property or a quarter of a mile or a half mile away, which somehow was energized by the use of that number 6 well, and through some subsurface channeling caused this thing to appear underneath this building? Is that not a possibility?
It could be a possibility, but we won't know unless we continue to look for the potential of a well.
Okay. I was just trying to explore all the different steps that you've taken out onto the plank, and I think I've done that for now. So I'll reserve all my other questions unless something else comes up immediately for Mr. Russell or other staff witnesses. Thank you, Mr. Chair.
Well, you've given me time to think of an extension of one of my questions, and if this is an unfair hypothetical, you can caveat your answer as much as you need to, Mr. Hoffman. But you know, we talked about that staff's position is not to necessarily damage the building or tear down the building. Staff's position is there are more steps to take. Let me ask you a hypothetical. What if it becomes clear that there is still a threat to fresh and usable water? There is still seepage, but the well has not yet been found, and it becomes clear that the building does need to be, let's go all the way to the building does need to be removed to discover that source. Would staff's position change, or would staff's position still be that the operator needs to move forward and find and plug the well?
I would almost disagree with the way you phrased your question a little bit, in that I don't think anywhere in our testimony do we say that we would want them to tear down this building. And frankly, I think part of it comes to maybe a disagreement about the construction of that floor and how it can be repaired or not. But I think our position would be to do as little damage to that building as possible. And frankly, our preference would be to avoid any.
Can you foresee a hypothetical situation where we do no damage or a little damage, and then we still have an issue
What do you mean we still have an issue?
that we have not discovered the source yet?
It's entirely possible.
And that would not change. And then at that point, staff's position would not change. The issue with the source would still need to be discovered and still need to be remedied.
Well, I think in all fairness, in answering a hypothetical, I can't say for certain how staff would feel because I don't know what little steps we would have taken, what the evidence would have revealed. It's one of those things where I won't know until we're there.
I appreciate I kind of asked you an unanswerable question at that point. So, all right, Commissioner Keen or Commissioner Keither, any additional questions for Mr. Hoffman at this time?
No.
Okay. With that, we will move to Mr. Marsh for redirect.
Thank you, Chair French. I don't know that I have much redirect questions. I guess, Director Hoffman, you mentioned effectively downward drainage possibly occurring with if there is an abandoned well beneath the building. I mean, could that also have an impact on oil and gas bearing zones?
Yeah, it could potentially flood them out.
And then, I mean, I know Keith asked you questions about, Daylight divesting itself of its interest in Kansas. I mean, would you say that selling all of your leases in the state is an indication of divesting yourself of your interest in that state?
Yes, and it's one that unfortunately we've seen before where an operator would, in an effort to try and limit their liability, would get rid of what they could before they left.
And in those instances, whenever operators do that, I mean, do the obligations they leave behind get put on the state?
Yes.
Okay, thank you. No further questions.
All right. At this time, we've completed all of our questioning. Mr. Brock, do you have any burning need to do additional cross?
I have four
Okay,
questions.
please proceed.
I mean, so this is kind of outside of your area, but you testified to it, so I'm going to ask you about it. You testified that there's a risk of downward drainage into this producing formation through what you think might be an abandoned well under the building. Is that correct?
That is correct.
What is that producing formation?
It's the Bartlesville.
In this area, will the Bartlesville accept water by gravity, or does it have to be under pressure in order to inject it?
In order to inject it, yeah, you would have to use pressure.
In order to get the formation to accept water, will it flow by gravity, or do operators have to put it under pressure in the Bartlesville producing formation?
Well, in the formation, but not to go down the wellbore. I mean, gravity, it'll go down the wellbore.
You testified that it could damage the producing formation. It could be loss of the water down the wellbore.
Right.
And so my question is whether that formation will accept water if it's not put under pressure.
And I answered that and I said, no, it wouldn't,
Right.
but it would still be lost because it would go down the wellbore through the channel that was created.
So you testified that you don't know there's an abandoned well. Is that correct?
I said that I said 100% certainty is, I believe, my language, Keith. I said, I'm not 100% certain there is.
And then you said that operator has not proven there isn't. Is that correct?
I don't recall.
I guess I'll just ask the direct question. Is it your position that in order to impose a penalty on an operator, it's the operator's burden to show that a well doesn't exist? Or is it the commission's burden to show a well does exist before they can actually force someone to deal with it?
Well, if we're talking outside the scope of what you filed here and how we would normally go about it under 55-179 when we have produced fluids come to the surface, that's generally enough for us to say we have a responsible party, and that party is then the one that's charged with either plugging the well or proving to us that we're wrong, at least assisting in the investigation.
So, I guess that's more of a legal question. We'll just deal with that in briefing. I probably shouldn't have asked you the question. You made a statement that you said that staff disagrees on whether or not this floor can be adequately repaired.
Yes.
And just so that I'm clear, all of your witnesses are geologists and oil field people and lawyers, and I didn't see any background for any of them in commercial building construction. Is that right?
That is correct. But we haven't seen any design of the floor. We haven't been provided any blueprint or anything that says exactly how it's designed.
And so, just so I'm clear, the geologists, the oil field producers, the lawyers believe that the floor can be repaired, even though an expert witness who is skilled in commercial construction claims it can't.
Well, what I would say is, based on the evidence in the record, we don't believe we've been provided with anything that says it can't, other than an opinion.
Shifting gears to the last topic, you were talking about operators leaving the state and leaving the state with responsibilities, and you indicated you'd seen that before. You remember saying that?
Yes, I do.
In any of those situations, did you see any of those operators employing ground penetrating radar, hydrovacing beneath a building, spending hundreds of thousands of dollars trying to comply with the commission's orders? Did you see any of that?
Not to this extent, no.
And in any of those situations, did you see those operators proactively initiating a docket in front of the commission to try to resolve the issue?
Well, I guess maybe you can phrase it as proactive, and I would look at it in a different way. But no, I've never seen an operator file a docket like this.
Those are all the questions that I have.
All right. Thank you, Mr. Brock. Because I allowed recross, let me just give one opportunity. If any commissioners want to ask additional questions. Seeing none, Mr. Marsh, do you have need for any redirect? Mr. Marsh, I don't think we've got your audio. You might be double muted somehow.
Can you hear me?
We do hear you now.
Okay. I mean, Keith asked the question about an operator being proactive. Do you think this was an instance of an operator being proactive, or maybe an instance where operators wanting to try to frame things the way they wanted to frame things?
I believe that it is outside the scope of how we would normally proceed, and that there are advantages to proceeding this way for the operator.
Okay, thank you.
All right. I think we have concluded Mr. Hoffman's examination. Thank you for your testimony today,
Thank
Mr.
you.
Hoffman. You may virtually step down. I'm going to give everybody a 5-minute break just because we've been going for a little over an hour now. We'll just take a break until 10:15, and then we will begin with staff's next witness. So we are now off the record and in recess until 10:15. All right, do we have everyone back? Mr. Marsh.
Yes, Mr.
Okay,
Chair.
I believe we left off after staff's first witness. Yeah, I heard Mr. Brock there. So we will go ahead and proceed. Staff, you may call your second witness.
Thank you, Chair French. Commission staff calls Troy Russell.
Good morning, Mr. Russell. I'll have you try out your microphone real quick.
Good morning, Chair French.
All right, I see you. If you would please raise your right hand for me. Do you swear or affirm that the testimony you shall give today is the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you. Mr. Marsh, your witness is yours.
Thank you. Can you please state your full name and title for the record?
Troy A. Russell. I'm the District 3 Supervisor and Professional Geologist.
Are you the same Troy Russell who caused to be filed in this docket direct testimony consisting of 8 pages and 6 exhibits on November 1st, 2024, and rebuttal testimony consisting of 10 pages and 2 exhibits on January 31st, 2025?
Yes, sir.
Do you have any corrections to make to your testimony?
I do have a couple minor. On my direct testimony, the work address should say 137 East 21st Street, Chanute,
And
Kansas.
what page and line number is that?
I'm sorry, page 2, line 2.
Okay.
And then on the same direct on page 4, line 8, where it says to discovered of the lease, it should say leak.
Okay, thank you. Do you have any other corrections?
Not to my knowledge.
Right. With these corrections incorporated, do you swear the answers contained in your pre-filed testimony were and are true to the best of your knowledge?
Yes, sir.
At this time, staff moves for Mr. Troy Russell's pre-filed testimony and exhibits to be admitted into the formal record.
Any objection?
We would just incorporate Commission's exhibit number 1.
It's noted. The reference testimony will be admitted.
Okay, staff tenders the witness for cross-examination.
All right, thank you. Mr. Brock, the witness is yours.
Good morning, Mr. Russell.
Good morning, Mr. Brock. I miss seeing you here.
I know. I was kind of excited. I don't know that I've got to keep my tie on if I can't use my my video.
Yeah.
All right, let's get into it. So since we've got some time. So I had tried to ask a couple questions to Ryan, and he didn't know I'm sorry, Mr. Hoffman, and he said that you would be the person to ask. So I'd like to start with those. Can you list for me every proposal that staff has made to Daylight in order to address this breakout, which staff believes will also protect fresh and usable water, that do not involve causing any damage to the commercial building?
Well, to completely eliminate any damage to the commercial building, we would still continue with, the GPR survey they did, I think showed some signs that, maybe we should further pursue that. Since we've decreased the injection into that zone and that communication with that well, and maybe pinpoint that. If we could get a closer deal, then maybe we could go beneath the floor. I think with the amount of fluid and how quickly it communicated, and when we were injecting into old housing number 6, that there is a pretty good decent chance that we could utilize a spooler to wash down this well bore and plug it that way, and potentially avoid significant damages to that building. If it's we would have to consult with some engineers as far as how far back could we excavate underneath that building to attempt to locate it, or at that point where we would simply try to pinpoint or get a much tighter area of where the wellbore is, where we would have to enter in through the floor by removing a portion of that floor, the concrete. some other, the thermal anomalies to see if we could see that while we were putting water in and removing that. But there were several investigative things that we did not see the magnetometer survey, which I do not know how, if there's no casing in the well bore, which I suspect there is not, or at least not completely to surface. That may be difficult, but there are things that we could go deeper into.
And at the time that Daylight filed this docket, had you told them that you wanted to do these other things, or were you insisting on them cutting the floor?
I've never insisted that they cut the floor. We just wanted to further their investigation. We got very little communication back from them after that last deal. I think you can reference in one of my emails, I'd requested kind of a status update, and they had kind of just jumped on the narrative that monitoring wells were going to suffice, and we're not, that's how we would like to proceed without proceeding on these other things.
So just that I'm clear, are you saying that you told Daylight that you were not going to require them to cut the floor, you were only asking them to do additional digging? Is that your testimony?
No, my testimony is that there are a number of other things we could do before we would have to result into that. But I have had very little communication with Art or K.S.A concerning, I've never had the opportunity to sit down and tell them, say, oh, nope, you got to go cut that floor. That conversation has never occurred.
What did you tell them to do?
Well, they proposed that they do these non-invasive methods like the GPR survey and the I don't think they did any thermal. They say or state that they have done a magnetometer survey, which I've not seen. But at that point, they had not offered up any more options as far as proceeding with let's now that we've reduced the flow, and that first GPR survey showed that anomaly they attributed to some kind of a high fluid under there, but I don't think we've run it or done it since they've reduced or shut the injection in, which may give us a tighter reading or a better reading, or it's definitely worthwhile to explore that avenue, prior to just, we have not recommended that, okay, we're just going to start tearing out floor till we find something.
So to be sure that I'm clear, I'm asking specifically whether you or any member of your staff told or requested that Daylight take some further steps that did not involve cutting the floor, and they refused to take them and initiated this docket instead.
We inquired about thermal. We never got a response back. The magnetometer survey was brought up by Rolando Moreno. We did not know they had done that or see those results until this docket was filed, and we seen it in the pre-filed testimonies.
And I guess I just want to make it clear, just because you can't see my voice, I was trying to choose my words. Like I don't know how that comes across without seeing my face, but I was trying to speak slowly to choose my words. And so if it didn't sound that way, it wasn't my intent. So with the NOVs that were issued, they simply set deadlines for Daylight to find a well or face commission action. In summary, is that accurate?
I believe that is what the NOV stated, and to encourage, we had not had any substantive conversations with them since that, other than, that the narrative was that the monitoring wells do not show, in their opinion, did not show any impacts to fresh and usable waters within table 1. And we sent back an email that said that we disagreed with that and why, and then did not hear back on any other possible actions that they would be willing to take.
So did you or any of your staff ever call up Daylight and say, hey, I'd like you to perform some more ground penetrating radar?
No, after I sent the
Right.
email about requesting a status update and what our thoughts were on their proposed solution of the monitoring wells, we did not get a response to that email. So at that time, I assumed that in the past, when we had set those in, we quickly got communication back, aligning out or discussing possible proposals. And each time that we had done that, we had extended those deadlines. It went from a 30-day to a 60-day. And then, the reason we agreed to the monitoring and allowing that was our consideration of the pressure that the building owner, Mr. Tinsley, was bringing, because it is my understanding through those discussions that he required that building, and the reason it's heated is so that he can park his bulk cement trucks in there in the winter and keep them above freezing. So that's why we said that we could probably extend that through April or May of 2024 to allow Daylight sufficient time to locate this wellbore through these other technologies.
And so just to clarify, did you or any member of commission staff ever pick up the phone and call Daylight and say, hey, I'd like you to conduct some more injection tests to see if we can find this well? And Daylight refused.
No, I did not call him. And I guess my answer is still the same. When I sent the email in my exhibits to return to Rolando asking for a status update, and then we sent email stating what our position was and what we thought of the results of the sampling that had taken place in the monitoring, was that we did not agree that there was no impact in table 1, and then we never heard anything back. And I made no other contacts other than that after those NOVs went out.
And just to be clear, did either you or commission staff ever pick up the phone to Daylight and say, hey, I think we can potentially locate a well by doing some digging outside the footprint of the building, and I'd like you to try that? And Daylight refused.
No, those conversations would occurred prior to their initial excavations. Initially, when this first was brought to our attention and they called in a complaint to us that they thought they had a breakout well and they had crude oil and brine surfacing out the conduit channel in the concrete floor out the building, then they were very cooperative and brought in the hydrovac, as they've mentioned, and did the observation pit, and then dug channels on the sides of the building or trenches so that we could see if there was something. We all hoped there was something easily that was maybe coming across on top of a unconfining layer or something like that, moving, and just happened to Daylight underneath that building, but that did not appear to be the case.
Had a question in my mind and I lost my train of thought. Oh, I know. So the idea of using ground penetrating radar, is that unique in this context?
Can you give me some more context of what you mean by unique? And
Do you commonly see Eastern Kansas oil and gas operators using ground penetrating radar to try to find wells?
No, we have not had to, and that was one of our primary interests early on, is that I believe, this is a technology that probably will be useful in the future, that we would want to have in our toolbox.
And did Daylight propose that, locate the contractor and do that, or was that at staff's request?
No, that was at their proposal, and they consulted and asked if we would be open to that, and of course we were. I mean, the conversations always were, and I think it was phrased, and forgive me if I'm wrong, I think maybe I first heard it with conversations with you, was, they just wanted the opportunity to think outside of the box. And I believe my paraphrased response basically was, of course, we would welcome that as long as the objectives remain the same, to to put every effort into locating the well bore and to plugging that well bore if possible.
So the idea of employing a magnetometer, was that something Daylight investigated and came up with, or was that something that staff requested?
No, I believe that proposal came, I think probably from Daylight, maybe through K.S.A, but it was from that combination.
And the idea of hiring a third-party expert to try to provide expertise and guidance to find a solution, was that proposed by Daylight, or did staff request that?
That was from Daylight.
Can you give me one specific request that you made of Daylight, or one specific proposal that staff made to Daylight to address this situation?
Can you repeat that?
So we've went through the steps, and you've indicated that all of these things were Daylight's ideas. They investigated them, they proposed them, they voluntarily carried them out. I'm just asking you if you could list any of that outside the box thinking that staff proposed.
That outside the box thinking proposed, well, whatever that was from Daylight, not from us. We welcome, we have conventional means, and we did that. We they did checks. We made sure all the MITs and all the area injection wells that were within the quarter mile had them retested to make sure. We looked at some of the abandoned wells that were, or I shouldn't say abandoned, inactive wells within the area too, that they checked to see fluid levels, from which then they proposed they would do a monitoring of the fluid level checked once the injection was turned back on. It was staff that requested and was adamant about them restarting injection on old housing number 6 so that we could determine if there was impacts on any of these other wells, and also to see, if we could get a better flow pattern and volume to get that repeated to come out into the observation pit after it was excavated.
And so the proposal to resume injection, that's the only proposal that you can think of that staff made to investigate the matter?
Well, on top of that, we also made the suggestions of doing the exploratory trenches while they had the hydrovac there to see if we were getting any other communication from the peripheral of the building or from other sources outside that. And they were never able to confirm that there was any fluid movement in the shallow subsurface that would be moving from outside the footprint of that building from the north or the east or the west.
Okay, so you proposed injection tests and you proposed the hydrovacing trenches. Is that all?
Then I believe we were the ones that made the reference to possibly if they could utilize thermal. Our thinking on using the thermal would be that there would be a temperature differentiation in the fluids coming from formation.
Is there anything else?
That's off the top of my head. That's all I can think of, Keith.
And so just to be clear, Daylight did perform the injection test that it was asked to perform, correct?
Yes.
And Daylight did conduct the trenching with the hydrovac that it was asked to, correct?
Yes.
And I think Daylight's witness could speak to the thermal. Did you independently investigate thermal about whether that would be able to, in essence, see through the concrete floor?
No, that was one of the options that when one of, I believe it was either with a conversation or email with Rolando that was discussed as would that be a possibility given, we could get the thermal detection, with a, caveat, we understood that depending, what that would do as far as with the thickness of the floor and how that heat would radiate, if it could pinpoint back to a center or if we'd something of that nature.
And so just so that I understand, or I'm characterizing it correctly, I guess, it sounds like that's more of an idea that was floated as opposed to an avenue that staff was really wanting operator to actually physically perform?
No, there was never, well, we never did mandate it. We offered it as possible, solution to look at. At the time this was going on, this was an issue we believe was brought on by the operator's injection. And I think that's fairly clear, but that we were just offering up as much assistance as we could as far as technical assistance.
And I'm going to try just to cut right to the chase and see if we can kind of end this line of questioning. But Daylight's position is that they did everything that staff had asked them to do in order to try to locate a well. They voluntarily proposed additional methods that are not customary and paid for those to do it. And it was only once it came up to the point of having to damage the commercial building that Daylight initiated this action. Would you agree with that?
Would you, and I apologize, I was thinking too, would you kind of repeat that?
So Daylight is essentially contending that they did everything that staff asked them to do in order to try to locate an abandoned well. That they also proposed additional uncommon methods that they voluntarily implemented and paid for, and that they did everything that they were asked up to the point of getting to the place where the commercial building would have to be damaged before initiating this docket or facing an NOV deadline. Do you agree with that?
No.
But earlier, when I asked you to identify specifically the things that staff had asked Daylight to do, you were only able to give me 3.
Well, at that point, we weren't telling them what to do. We were making suggestions and giving them the opportunity to pursue these technologies and to see where they could get with them and where they'd share. At the point, after a year, it became apparent that they were not going to, pursue information to get better data with the GPR. Well, there are other things they could have done, I believe, or that we would do if it had turned over to us, where we now were going to do these things that I think that we could do. They could have done more other than just to say, it's monitoring wells, we're done.
But you testified earlier, you never told Daylight about any of those things that you're talking about now, correct?
I did. All I told them about is what they talked. And after that, there was no communication with us. And at that time, we weren't working with them under an enforcement type action. We were trying to help them and assist them as best we could because they had caused this breakout underneath the building with their injection well. So we were giving them the opportunity to address it without having to resort to an enforcement action.
And this is an open-ended question that I maybe shouldn't ask, but I'm going to. If operator was doing everything that you had asked him to do, why would it have turned into an enforcement type action and away from a problem-solving type of situation that you described?
I would have welcomed more communication. The individual which I had the most contact with is Rolando Moreno. I do not see that he is here today, or the staff worked with in the field. Individuals mentioned in Levi's exhibits, but they're not here. But we would be more than willing to sit down and talk about these options. But we need to see some tangible efforts to do this. There was comment, referenced in Levi's to him that Daylight wasn't interested in looking under that concrete floor anymore. And I think the email I sent to Mr. Moreno was very open-ended to give every opportunity to get back and ask, do you guys see what we see in the data? Do you see something we'd like to do further? None of these things occurred.
So you're referring to the emails. Can you point me to one specifically where you were asking Daylight to do something or take further actions that did not involve cutting the floor?
The only last one I recall was when we sent asking for an update or status update on what Daylight's plans were moving forward. After that, we did not get one, and that indicated that there would be an NOV letter that it would be generated that would give them a deadline to locate and address this abandoned wellbore.
So the approach turned to an enforcement type action like you've described before.
Yes, it was headed that direction just to try to engage and get them to engage in a more substantive conversation on how we could proceed. But the impression that I got through these communications and through these things was that they thought that the long-term monitoring was the solution.
I think we've gone around in the circle. I'll move on from that. So I had planned to share my screen, but with the issues that I'm having, I'm gonna just see if we can cut all this and get to a very direct question, and we'll see if we can avoid some of that. So in looking at your rebuttal testimony, and I can give you page and line numbers if you want to, but there's about 4 places that you make a reference, and I'm going to ask you if I'm correctly understanding what you mean by those 4 things. So
I have my rebuttal pulled up, so if you would give me a page number and a line, that would appreciate it, or maybe John.
So on page 2, line 20 of your rebuttal, you essentially say, our hope is to locate and plug the well. It's just a simple statement. That's all I'm referring to. And I'm just going to show you where I'm going with this. And if you want me to back up and go through your testimony, we'll do that. But I think what I'm looking for is something very basic, and so it may not be necessary. So on page 2, line 20, you say, our hope is to locate and plug the abandoned well. On page 6, line...
Objection. I think just a partial quote, instead of giving the whole line, mischaracterizes Mr. Russell's testimony.
Like, I'm willing to let him go back and forth. I'm just trying to show him what I'm after. I think is very surface level. I really am not trying to trap him. I'm just, but we can.
Well, if they're not trying to trap him, then quote the entire line of testimony.
Mr. Marsh, I see what you're saying. If the other people are following along, we can see what you're saying.
All right, thank you.
But I'm going to overrule it now. I'll let Mr. Brock ask his question. I think he's trying to frame a question here. If you feel the need to clean it up on redirect, we'll certainly allow that.
Yeah. And to be clear, Troy, or I'm sorry, Mr. Russell, we will back up and look at these if you want to. I'm just trying to get directly to the question I'm going to ask and see if you can answer it. So page 2, line 20 of the rebuttal, it says our hope is to locate and plug an abandoned well. Page 6, line 14 of the rebuttal, it says our goal is to locate and plug the well. Page 8, lines 2 through 4 of your rebuttal, you say, even if pollution is not occurring as alleged by operator's testimony, it does not take away the fact that operator caused an abandoned well to break out and is responsible for plugging it. Then at page 10 of your rebuttal, you again say, the KCC's job is to prevent pollution, not to monitor it. And so this is just framing the question. So this is the question, leading up to it. It appears to me from all this that there is no scenario that does not involve ultimately finding and plugging an abandoned well that would satisfy staff, even if the breakout has been stopped. Is that correct?
I believe that we have not exhausted all the resources that we should allocate to eliminating this point source. I don't know that I do not agree with the characterization that the breakout has stopped. The channel, the conduit to which it is allowed to be could, several other factors. There's still a possibility that we could have issues with that. at issue with, to address about, could we have downward drainage with the Bartlesville, take that gravity or not, not most likely, but, it would probably go through that channel. And if they produce that number 6 or other activities within that, it could draw those fluids down and out and through those channels, and eventually over time, maybe cause some issues. I mean, in general, it's not a preferred deal to mix fresh waters with brines. The chemistry doesn't mix well and can affect permeability and cause other problems for the production of that. But I just do not think we're to the point where we can just say we can't get this without destroying the building. I don't, my hope would be that we would not, I would not recommend ever that we go in there and raise that building to the ground in order to, as our first, method of attempting. I think we can be successful with some other methods in locating this.
So you think you can be successful, but none of those were proposed to Daylight. Is that correct?
Daylight never sat down and asked to have that conversation. I mean, you're kind of putting it like I was keeping this a big secret, hoping that this issue wouldn't be resolved. I would like nothing more than this to be resolved so that, we mitigate any damages to Mr. Tinswell, and that he's, relatively happy after we're done, and that Daylight's able to continue operations and continue to produce these leases to their full potential.
I'm not sure if the question that I led up to actually got answered, but I think
if you repeat it, I'll try harder.
Yeah. So it appears to me that there's not a scenario that does not involve ultimately locating the source of this breakout and plugging it that would satisfy staff, even if the breakout is stopped. Is that accurate?
I would say that is the highly preferred outcome.
Okay. And is it also true that that's been staff's position consistently throughout this process?
Yeah, staff in our things with this and the, we investigate these type of things a large amount, other than with this particular building. I mean, we've located, and they've actually in the past plugged wells underneath residences and residential places. But our first inclination is to get to the point source and eliminate that point source. That, in our opinion, that is the best overall outcome. We don't need any more remediation sites, contamination sites.
And so is that the outcome that you were insisting upon with Daylight through this whole process?
No, I'm not insisting. That was our preferred outcome, and that I felt they had not exhausted every avenue to bring that to fruition. And to simply say that we were demanding they destroy that building is inaccurate.
Did you ever suggest to them an outcome or a scenario that wouldn't involve ultimately locating and plugging a well?
Had not got to that point where I think that was a conversation we need to have yet. I think if we'd brought that scenario up, then they would have quickly said that's where we're at without any further investigation.
I think we've eliminated. I won't go through the testimony. I think you've answered what I've asked. So I appreciate the indulgence there, shortcutting through the testimony references. Were you on this hearing earlier when Mr. Hoffman testified?
Yes, sir.
When he said that staff agrees or disagrees that this floor of this building cannot be adequately repaired. He disagrees with the expert testimony. Did he have that opinion, or was that your opinion, or where did that come from?
I cannot speak for him, but I would cast enough doubt upon that I would at least seek, second or third opinion to determine. I do have some familiarity with the floor and the heat. It's how I heat my shop.
And so, I mean, if we shortcut all of this, is that really what it boils down to? That staff believes that floor can be repaired and therefore there's no harm in cutting it, and the expert claims that that it can't be repaired? Is that the crux of this kind of impasse that was reached?
No, I would prefer that, we still have options to pursue, to locate before we would have to sit down and start talking about cutting a section of this floor out. There's a chance that this well bore is close enough to the edge of the building that maybe we could access it from beneath and do so safely. In the event that we would say, okay, it's, we are not going to be able to access in a hypothetical scenario. It's located, more out to the middle. We cannot safely access it beneath, and we would definitely want to seek, I think I would talk to some other contractors and with experience in these type of things and determine if that could be done. I mean, I'm aware of, instances that makes me say, well, let's talk to some more experts. I'm not saying I'm the expert, but I know of instances where, I have a lot of friends in agriculture that build buildings of this size and bigger that have had, whatever issues and had required to come in and cut out a section of floor and replace it. Now, not all of them had the PEX in it for the floor heat. So I'm not saying that, and I'm not saying I'm an expert. I'm just saying it is worthwhile to explore other opinions and contractors to check this out. And if it ultimately falls to the commission to address this well, those are conversations that we would have and seek out to get as much information as possible before we would proceed.
Do you have any knowledge of how many opinions or from who either Daylight or this building owner got that said that this in-floor heating system couldn't be cut?
I was not privy to any of the conversations with Mr. Tinsley. I will agree and say with you that, he was not happy about this, did not really want any part of this. So I don't know how much of that opinion is to discourage this from happening or what. So, I know it sounds like there's Mr. Tinsley and this one, Mr. Wintgen. That's all I've heard from, or not even heard from, but that's all I've seen or read in testimony.
Okay, well, we'll ask Daylight what they did then. But you're aware that Mr. Tinsley, the building owner, has refused to give Daylight permission to cut any portion of its floor of the building, correct?
I do not know that directly. I do know that the characterization, when I only had the one opportunity, that he is adamantly opposed to this at this time or at that time. I've not talked to him in over a year.
So if we assume that the evidence presented about cutting the floor was true, and that if that floor is cut, it cannot be adequately repaired. If we assume that that is true, wouldn't cutting that floor of the building constitute permanent damage to the building?
If we have exhausted all other avenues to proceed, and that came down to say that was the only option and everybody was at least agreement that's the only way forward, and it's true they cannot repair that, then that would be damage to that building, irreparable damage.
And so how would doing that also achieve the commission's duty to prevent waste?
I will refer that to Mr. Haas as far as the definition of waste. I'm not an attorney. I mean, my understanding, at least how we've always looked at it, was waste in the production of oil and gas. I'm not familiar with the other that you guys discussed and talked about as far as what may or may not be included in that, in our regulations.
And I guess I'm not trying to get into a legal discussion about the definition. I'm just trying to ask you if staff is contending that they are taking actions which do prevent waste. I mean, I don't believe that you think waste applies, and so you're not contending that staff is balancing that duty in some other way. And all I'm asking you to do is confirm that staff doesn't believe that it applies and is not balancing the duty and insisting that the floor be cut.
Well, I believe that the state, I mean, we've invested tens of millions of dollars in plugging abandoned wells. Some of them had a very high cost. We plug wells in the river, lakes, other buildings, not of this size that I'm aware of. And if you looked at it under that narrow scope of a limited amount of time, you would maybe question that investment on certain things. But I believe that is recouped in the future, protecting these fresh and usable water zones. There's a reason they incorporated Table 1 into the rules and regulations. And it wasn't just state, it was academia, industry, state, all professionals. They were able, from my understanding of where it came from, all had input into why we need to incorporate these. The reference that this aquifer or these waters within this Table 1, I think it's important to know it's not a homogeneous zone, that entire 150 feet, but that it's a minimal or irrelevant use. I have issue with that because, we were at the KDHE Well Technology to give a talk on brine intrusion, but there was a number of water well drillers that were talking about the technologies they were using to make low yield water wells viable, whether through underground or above ground storage, or where they would be able to pump those wells that were low yield so that they would have water on hand to access on demand rather than trying to access that water on demand directly from the wellbore. So what may be of little value today may be of significant value 10, 15, 20 years down the road.
So my question involved the destruction of this commercial building, and I'm not sure what part of your answer spoke to the destruction of the or the damage to the commercial building.
I think if we could not find a way to do this without destruction of that building, then that would be, you'd have to really sit down and decide, what the cost was to what the benefit was and all those scenarios. It would definitely be a very, very, very last resort, and there would have to be a lot of, further detailed conversations on then what would entail and how we could do that. But, I before I tear that building down, we could do some more planning, try to drill a well closer to it and communicate over to it and plug it that way.
Let's shift gears to your conclusion about whether or not this breakout is in fact an abandoned well. So isn't it true, and we can display it if we need to, but on August 7th, 2023, in an email, you indicated that there was evidence to suggest that this might be abandoned well, but the investigation will continue until the source is determined, and if an abandoned well is discovered, it will need to be plugged. Do you agree with that?
Yes.
But in your testimony before the commission now, you stated that, in essence, that you believe there is an abandoned well located beneath the building.
Yeah, at this time, I believe, and even then, the preliminary investigations I've not seen any other plausible source for those fluids that were pushed to the surface that were tied in with that injection on that old housing number 6.
What changed between the August 7th, 2023 email and today that caused you to shift from saying that there is evidence that indicates it could be in a well to now being able to state that there is a well?
Just for the sake of, what is the date on that email you stated again?
August 7th, 2023.
Okay. I do not believe we did the injection test until the end of that month. So we didn't have that information yet.
So that's what had changed.
That's what really reaffirmed it. I mean, when you look at the pictures of the initial investigation of the crude oil and the milky colored brine waters coming to the surface, that's a strong indication. But, you know, we were, still in the investigative part of our investigation, I guess, early stages.
And so the factors, well, I guess let me just clarify on that last statement. So the reason that you couldn't say on August 7th, 2023 that this was an abandoned well is because you were still in the early stages of your investigation. Is that what you just said?
Correct.
Okay. And so this is on your direct testimony, page 6, line 22 through page 7, line 5. You set forth the reasons why you're basing your opinion that this is in fact an abandoned well beneath that building.
Can you repeat? I'm on my direct testimony. Can you repeat the
So
pages?
this is your direct testimony, page 6, line 22 through page 7, line 5.
Yes, I'm with you. So I apologize. I'm at that testimony you asked, and so your question is?
So in summarizing the testimony in that block, you list 3 reasons why you concluded absolutely that it is your opinion this is an abandoned well. And those reasons are that there's a pressure connection between the Olenhausen 6 and the flow of the observed fluids in the monitoring pit. The second reason is that there were discoloration on maps that Julie Schaefer located. And the third reason is that samples from the pit had similar chlorides to the Olenhausen injection. Are those the only 3, or am I correctly characterizing your testimony that those are the 3 reasons that you are basing your opinion on?
Yes, those are the primary reasons.
Are those the only reasons?
Well, I'm not saying we'll come up with more at a later date, but I think at the time of this testimony, those are the 3 most significant.
And so on the first reason, the connection between the Olenhausen number 6 and the observance of the fluids into the monitoring pit, would you agree that the last time that was seen was on July the 14th, 2023?
Do not have the date with me. Is that when they closed the pit?
I don't want to put words.
The date they closed the pit would have been the last, we would not have had the opportunity after that to observe them.
I believe the field reports attached to your testimony say that July 14th, 2023 was the last date that the Allenhausen 6 ever injected.
I understand that, but I don't, when they closed that observation pit would have been the last opportunity. We would no longer have had any other opportunities to observe what was going on underneath that concrete floor.
But if the Allenhausen number 6 wasn't injecting anymore, would you have been able to see communication between that well and the observation pit at a later date?
Well, I would not have think so, but I don't know how long it would have took. I mean, it seemed to communicate fairly quickly and subside fairly quickly once they stopped injection. Does that kind of answer your question?
Yeah, and so you're not saying here today that there was some observation that you saw after July 14, 2023 that you felt connected the Allenhausen 6 injection to that pit?
I don't think there was other communication, as a direct result of injection after they shut the injection down.
And so moving over to the maps that you referenced that Mrs. Schaefer found, she sent those in an email on July the 6th, 2023. Do you agree with that?
And are you talking about the black and white arrow imagery, or all of them in together?
The maps that you're referring to that you indicated that she found that supported your opinion that this was in fact an abandoned well.
Okay.
Would you agree that those were sent in the email on July 6, 2023?
Is that exhibit TR1? I don't know, 15 through.
So I can give you a page if you want to look. It's Mrs. Schaefer's direct testimony, page 4, line 14 is where she references the date.
On her direct?
That's what I have in my notes. I can check real quick.
Page 2, line 14?
Page 4, line 14.
I'm sorry. Yes.
And then your third reason was that samples from the pit had similar chloride to the Allenhausen injection system.
Yes.
And would you agree that those samples were taken on July 17th and July 19th, 2023, respectively? The portion that provides that would be Levi Burnett's testimony, page 13. He has a report there.
Okay. When you say page, you mean page? I got 8 pages of Levi's direct, and then
I'm sorry, I wrote it. It's page 13 of the PDF file, so I could find it easily. I was planning to be able to show it to you.
understand.
Let me see if I can get it open and. So at the top of the page, it's page 4 of 18 on his exhibit LB2.
Okay. Bring it down there. B2.
And there's a really long paragraph on the, well, wait a minute. Let me see if there, okay, no, it's his dates right there where he's talking about taking samples, July 17th and 19th.
And that was page 4 of 18 on LB2?
Correct, yeah.
Yeah, 717.
So I guess the point that I'm making with all that is for these 3 reasons that you're currently basing your opinion that we are in fact dealing with an abandoned well, you had all of this information when you sent the email on August 7th, 2023. But at that time, you indicated that there was evidence to suggest a well, but we'd have to keep searching for it and see if we could find one, essentially. You agree with that?
I don't know if I agree with the characterization. I think, I have very little doubt we have an abandoned well. We just have not got it pinpoint located.
But you agree with the dates and you agree with the statements.
With the dates, yes, I made those statements.
So based on those three factors that you're relying upon, is there a recognized, you're a geologist, is there a recognized geological principle or method that you applied to these three factors in order to reach your conclusion that this is in fact an abandoned well?
I don't know if you're looking for a textbook explanation or, looking at, just throwing out hypothetical what ifs, because I have not seen anything from Daylight to indicate they have come up with such a, in their conclusions.
And to be fair, Daylight's experts are saying that there is no way to know what this is beneath the building unless it's found. You're stating, though, that this is in fact an abandoned well. So that's what I'm asking you about.
The fact that of my confidence in this, I guess, would be, I don't know about your geologic principles and methods, get into that, but is experience, years of experience in investigating breakout wells and subsequently those that we either plugged through the state fee fund or fee fund programs or coordination with operators. We took produced fluids from a well producing in that zone in this group of leases, and then they put those fluids back down, injected them down the Ownhausen number 6, or the subject injection well, and then we had communication into that observation pit in a relatively short amount of time. Those chloride samples in the waters from that pit that communicated, are very close proximity to what the chlorides were in the fluids we put down. And so geologically speaking, I do not see any other venue or pathway from which that it is likely that those fluids came from formation and at surface at this location in that relatively short amount of time, other than by an abandoned wellbore.
Can you cite me to any work papers, studies, textbooks, any authority of any kind that indicates that if you find pressure connection and produced fluids at the surface, and there is a discoloration spot on an old map, that there is in fact an abandoned wellbore?
I wouldn't put it onto the discoloration of the map. That's more of a corroborative piece of evidence at the time when we were just trying to assist them with, help finding a potential location to start looking and start our investigation. I am not aware of any scientific papers or technical papers that have been published on the subject.
Thank you for that. So one more additional line, and then I'll be done. Do I understand correctly that there were 2 other abandoned wells on this property that were basically cut off below the surface and buried?
I would like you to, I believe you're referring to the Johnson 6 and Johnson 7.
You're probably right. I know that there were two wells that I thought I saw in your report that they were buried, had a metal plate and a rock on top of them. I honestly don't remember the numbers, but I'm sure you're right.
Well, can you repeat that question for me, please?
I'm just asking, do I understand correctly that those 2 wells were found?
Yes.
How were they located?
Well, if we refer to Levi's Burnett's field report that prior, I believe, Mr. Johnson met Levi out on site and helped them pinpoint an area they should look. And then
And
they were
just so-
subsequently found.
And just so that we're clear, these weren't just buried. There was a metal plate laid on top of them, which would indicate that someone intentionally cut them off below the surface. Would you agree with that?
That is my understanding, that there was a plate welded on top of the casing. And they were cut off, I believe. I would, refer to that field report for exactly, but I believe it indicates 2 to 3 foot.
And this one doesn't necessarily go to what we're trying to figure out, but I'm trying to figure out what happened with that. And you said that Mr. Johnson told you where those locations were at, correct?
Did not tell me. That conversation was with the field staff, ECRS Levi Burnett.
But he knew right where they were.
It appears that they got them very close, because I believe it states in there when you read that they had some trouble trying to locate them from, whatever coordinates were available for those wells until he met Levi in the field, and we were able to locate that with, I believe Levi utilized our magnetic detector to detect those.
And is this the same individual who originally built this building?
I cannot confirm that. That is my understanding.
Okay. And he's also the same individual that was the prior operator of the Johnson lease. Is that correct?
I believe that is correct. Or one of the prior operators.
Do you know what specifically he may have told KCC staff? As I say, I'm not trying to trap you. I know very little about this, and I'm learning as I'm asking you. So this is not a trick question.
As much as I hate to, I would defer those direct conversations to Levi.
Okay. And so Levi was a specific person he was talking to?
Yes.
I'm sorry, when I say he, I mean this Mr. Johnson.
Yeah, the conversations, my understanding from the reports I've read is that this conversations occurred between Levi Burnett and Mr. Johnson.
Did he admit to cutting him off?
I don't want to answer without going through the field report and looking at that. Otherwise, I would defer that to Mr. Burnett, who actually had the conversation.
Do you know if he identified any other potential wellbore sites on the lease when he was out there doing that?
Not to my knowledge. And,
Did staff ask him about whether there were any other potential wellbore sites on the lease that had been buried?
Not that I recollect in conversations with staff. It's been a couple of years. It's not referenced that I know in these field reports. I know they've had other breakout wells. I don't know if there was some help or indication of that. I don't know if even that was maybe communicated to Daylight staff. I'm not sure how that loop in conversation went.
Okay. And as I say, I wasn't trying to trap you. I was trying to learn what you knew about those conversations. Those are all the questions.
These are, I shouldn't say more, but we intend to have more conversations. So with Mr. Johnson.
Yeah. And that you're looking for the same information that I'm looking for when I'm asking about it. So those are all the questions that I have for you on Cross, Mr. Russell. Thank you.
All right. Thank you, Mr. Brock. We will now turn to commissioner questions, and I will begin with Commissioner Keen. If you have any questions for Mr. Russell.
Just a few. Thank you. Good morning, Troy.
Good morning, Commissioner Keen.
Your cross-examination by Mr. Brock was pretty extensive. So some of the questions I had there have been asked and answered. some of them have been maybe not asked and answered as fully as I might ask them. So I don't really mean to be repetitive, but I want to go back through and ask you a few more questions. I'm going to start with some details here, and then we'll get to the broader question. What's the approximate depth of the Bartlesville in this particular area?
I believe it's referenced in Julie's field report and some of her documentation, but I think what they call the upper and lower, it's around 820 to 890. So, 820 to, roughly 900.
Okay. Do you know what the approximate distance is from that number 6 injection well to the building?
I believe the exact distance is given in one of these maps or some of this documentation. I want to say, it's well within a quarter mile.
Okay. But it would be more than, say, 330, 660, more than a location away?
I believe it'd be more than 330. I can, we have maps. I think I'll go through and keep track of all these exhibits, but there is a map that shows the own housing number 6, the injection well in question, and where the observation pit was located, where the fluids were first observed on that side of the building. And we did a quarter mile from that observation pit, and it captured that. So I would say you're probably more like 660.
Okay. Do you have any ballpark idea of what the rough size of the building is? How many square feet?
I have read in there somewhere, I believe it's 80 by 100.
80 by 100.
I believe they probably addressed that in Mr. Wintgen's testimony.
Okay. Okay. Pardon me, I didn't mean to talk over you, Troy.
No, I was just saying, I think that I have seen the dimensions of the building while reviewing various testimonies. It's not in mine, but I believe that information is present today. And I think it's 80 by 100.
Okay, that's helpful. Thank you. So, my understanding from your testimony, and that's through a number of questions that Mr. Brock asked of you from different angles and all, but my understanding of your testimony is that you believe that there is an abandoned well under this building.
Yes, sir.
Yeah. And I wouldn't even begin to second guess the 3 reasons that you gave for why it is that you believe that would be the case, or that there is evidence, in your opinion, from this fluid flow that it comes from an abandoned well. I'm going to accept that as a given for the moment. But so going back to a question I asked, perhaps unfairly, of Mr. Hoffman, in your opinion, there's no other way that this could be a well other than one underneath the building or in the close proximity to the building. That it couldn't just be that the fluids from that number 6 injection well were channeling through maybe a really circuitous route that came to show an outflow at that particular point.
That was our sincere hope initially, I think, by both Daylight and us. We went to all the inactive wells and locations that we were aware of to try to, eliminate that or make that dead, but we could not show any communication from the own housing number 6 injection well to any of these other inactive wells. At that time, I was just looking, they monitored the fluid levels over a period of time while they were injecting the well. The second time, to get the communication to the observation pit. There was a series of shallow trenches that were drilled, on the north, east, and I believe west side of this building to try to see if we could intercept or see any evidence of the type of fluids, crude oil, brines that were moving shallowly through and just happened to come in and hit the utility trench of this building. They excavated the utility trench on the outside of the building, I believe on the north side. There's Dickman, but we we're looking. I mean, if further deals go on this day, you know, there's a chance there's a lime about 10 or 11 foot down consistent that, you know, if it was moving, we would see it on top of that. We could maybe do some more exploration of that, but the speed in which it communicated and started coming out from under that floor to the observation was seemed to be pretty direct, and we have not, you know, like I said, through the look at those other inactive wells that were in line between this, where it came out in the building and between the injection well, we could not correlate any impact to those wells.
Well, I appreciate the granularity of that, Troy. I'm going to be maybe a little repetitive here, but I think it lays a foundation. With this next question, I'll be a little repetitive. Again, if you would, from your perspective, what prompted the NOV?
But the lack of action and communication with them, it seemed that after, you know, in the winter, late fall winter of 2023, you know, we had what I would consider fairly good communications, or at least interaction with field staff of Daylight and our staff, and the gentleman that I probably communicated the most with was Rolando Moreno, but Levi and Julie had also extensive contacts with their field operational staff, which is listed in their, you know, their field reports. But what we agreed to was the implementation of these monitoring wells to allow them more time to conduct further investigations underneath the floor. We had requested, I believe, the next multiple times, you know, repetitively requested to be notified when any activities were going on, so that if we had the opportunity, we could have staff be present during this. That was kind of difficult at first to get that. Was not aware that they had run a magnetometry survey until the hearing was initiated. They had talked about possible technology of that sort to utilize, but they had not shared that with us. And the last communications that I recall just basically was, you know, we're just going to address this with monitoring wells. There's no impact to table 1. You know, we're done. So we hope was that that letter NOV would initiate, you know, let's get communication going again and get this investigation back on track, and I think we can proceed and get this, you know, get this located and go from there.
If I tie, thank you for that. If I tie that level of detail you just provided with the response that you had to an analogous question from Mr. Brock, as I remember it, summarizing it basically, is it fair to say that it's possible, I'm not even going to go probable, it's possible that there would be no need for an NOV had there had been improved communication and engagement with the operator? Had you not been concerned that it moved from a period of inactivity to perhaps moving down towards some point of resolution, whatever that might be, and that there was a need for a deadline?
Yes, sir.
Is that a fair summary, or I don't want to put words in your mouth?
No, yes, sir. It is, yes.
I have 2 more lines of questioning, and I'm going to ask the most obvious one first. Troy, in your opinion, what additional steps need to be taken by the operator at this time?
I believe we should be able to have a meeting or discuss and get as much information on the table of what we know, what we don't know, discuss the points that we disagree. You know, I think it's a significant disagreement that between if we're having impacts or not, and really we need to define what an impact, what we're looking at, what they are. But then look again at some of these technologies. I think the GPR survey was promising, and I think that maybe I would like to see additional surveys done under these different circumstances since they have shut the injection down on the old housing. It'll be difficult at that point, because that observation pit, was closed and just kind of unilaterally closed. We didn't get much input into that because we would like to have been able to utilize that again. And then, it was indicated in an email that they would install a shallow monitoring well in that location, so at least we could still potentially collect fluids in the future. But that was not done. And then and I believe it was filled in a matter of concern for the concrete floor of the building, because they did undercut it, 2 or 3 feet, but they filled that pit completely with cement, or they may have another name for it, but to make it so, I think their concern was that it did not have any subside any, once they were gone. They didn't want to, cause any damage to that floor. But that's that will take some work to get that where we could utilize that again. But I think there's more data that we can accumulate to locate this wellbore. If we can locate the wellbore, then decisions can start being made or determined how best can we get to it. Is it possible to approach it from beneath that floor? And, is it still point where, hopefully we could, spool down it without doing that to get to, to get it taken care of and get it plugged. But, until we can get a further definitive location on that floor, then, then we'll have to make those decisions at that time. And I think if we could identify within very close proximity of where that wellbore is, and then we start looking at our options of, can we go underneath? Do we need to cut a, just a small 4x4 section out of the floor, 6x6 section? Do we attempt to drill another well closer and communicate with this well and try to get cement to it that way? There's still some options left that we need to explore before we just give up.
All right. Again, I appreciate the granularity of that response as well. My last question, and I'm really not looking for anything terribly expansive here, just some basic info for the record. Are there any monitoring wells in use by the KCC in District 3?
Yes, and I know you didn't want expansive, but I would like to elaborate. I think
Yes, please.
Primary difference when we have these sites, generally it's brine intrusion within shallow groundwaters, and always within table 1, whatever the table 1 depth where they're located. The monitoring wells are utilized to help us. We start making isopac maps and to track chloride concentration so we can, lead us to that point source to plug. Many of them we've already plugged extensively, a number of wells. At one site in particular was old cable tool holes, no casing, no nothing. We scraped down to the shallow sandstone to find well bores, but we found those locations by evidence of old pits and fire brick and stuff related to cable tool drilling during that era. But a lot of the monitoring wells are also to determine the efficacy of what we've done. Or have we plugged? Do we think we've got all the wells plugged? We look at the drill patterns for that time period and how many times it's been drilled up through there, and the number of wells we plug, and then that starts reflecting into those samples, so we can determine, we still got some high numbers, on this end of the project. We need to go look a little harder to the northeast or to the southwest, or to try to see where those help us locate these point sources. It's never in District 3, we don't have anywhere we would say recovery wells where, it's such an extensive aquifer that, we have to do recovery and disposal to trap that plume and contain that plume. We're trying to trace it back to that point source. And in every instance so far we've had so far, it has been old, historic, abandoned well bores that just were no records of.
Thank you for that answer as well. And here's the reason I asked it. I'm trying to conjure up, and it doesn't take a heck of a lot of effort, the most horrible hypothetical I can think that is going to be confronted going forward. There's going to be an abandoned well. It's going to be roughly in about the middle of the building. No casing, or most of the casing near the surface has been pulled. Abandoned to be sure, but just to make sure that they capped it off as some of the old plugging activities did, they threw some tools or junk down in the hole before they walked away from it. Is the hypothetical getting horrible enough yet?
Yeah, no. Several of the other old wells they plugged that they find that not related to this, as they got them damn wood plugs in there that just float up and down with you.
Yeah, or some other kind of a Mickey Mouse thing that really makes plugging it as you wish you could and with an ideal situation very problematic at best.
My hope and thoughts on it right now, and right now it's just, my opinions from experience. I don't have that. I think due to the volume of fluid and the communication we have, that we can get down at least 50 foot past table one. Is there something in the hole that's going to bridge it and keep us from getting to 820, 850, whatever? Very well may be. But is it something that we can get cement past? If we can't, our options for fishing will be limited because, not only do we not want to destroy the floor, we don't want to start taking roofs off and stuff like that to rig up a rig. But I think we have a high probability chance that we can, at least get a good top plug in it, 150 plus 50.
Yep. You've answered the question I asked in the three following ones, so I have no further questions for you. I appreciate very much the details of your answers, Troy, and your anticipation of the environmental concerns that I have. I have no further questions. Thank you, Mr. Chair.
All right. Commissioner Keither, any questions for Mr. Russell?
No.
Well, Mr. Russell, you answered a lot of things I was wondering about through Commissioner Keene's examination of you. Maybe I'll ask you a more general question. I know you went through with Mr. Brock some of your reasoning why you believe this is an abandoned well, and he took you to your direct testimony. But I honestly was looking more at your rebuttal testimony, sort of. I think it was pages 3 and 4. Yeah. Mostly on page 4, but 3 through 4, where you kind of laid out, in addition to those reasons in your direct testimony, you kind of laid out why some of the other alternatives to you didn't seem plausible. So maybe a general question. I mean, you seem to be pretty confident based on your experience and the evidence you've seen that this is an abandoned well. It's not some other natural source. Could you try to quantify that confidence? I mean, is it slightly over 50-50? Is it 80-20? Is it 95?
90-10.
90. Okay, that is actually very helpful for me. And I do appreciate your willingness to try.
It's a tremendous, I mean, I think both sides really want to resolve this the best way possible. I think, this is most likely scenario is that there's an abandoned well, and when we talk with staff, we have very good technical staff. And you know, we've discussed this at length with the program managers, all of the program managers, whether it's the fee fund, compliance, UIC, and environmental, but to great lengths that this, because you don't want to be wrong on this.
This is John Myers here. We're going to, Commissioner Keen, it appears as if Chair French is frozen. I would suggest that you have us go off the record.
Okay, let us do that. We will go off the record, see if we can correct the technical issue with Chair French. So we're off the record for the moment.
John, do I have a couple minutes to take a quick break?
We will go off the record for let's do 5 minutes, John.
Okay.
We'll try to come back at about 11:45, more or less. How about that? Okay.
Okay.
Recess till 11:45. John, were you able to locate the chair?
Yes, I'm in communication with him. His Wi-Fi went down. He was trying to get logged back on, alternatively to call in. We could potentially, it's not the ideal time necessarily, but potentially we could break for lunch.
I was just thinking that actually. Can you bring us back online here, John?
There you go.
There we go. Yes. Actually, I think it looks like we have about everyone but the chair.
Yeah, I mean, we could proceed without the chair as well. I mean,
I really would prefer not to do that. He was in the midst of asking some questions on cross of Mr. Russell. I think if he's back on, then he can decide. Otherwise, I was going to pick lunch. But
I'm here.
Okay, we're back out of recess. We're going to go back on the record, and I will return the reins to Chair French.
Thank you, Commissioner Keen. I apologize. You guys can send your complaints to AT&T. It's a home Wi-Fi issue, not a Zoom issue. Okay, so we are back on the record. Let's go ahead and see if we can get through with Mr. Russell, and then we'll take a lunch break. Mr. Russell, the last thing I heard you say was that you had a very fine staff. I don't know how quickly folks realized that I had left the building. If you're prepared to continue, you may. If not, I'll try to remember what my question was.
I probably need to hear the question again so I don't just ramble on.
Well, I think I was just asking you to ballpark, what you thought the likelihood was of an abandoned well. And I know you said, it was 90-10. And then I think you were trying to explain that a bit.
Yeah, I have a high degree of confidence, and I was just explaining that we have had numerous conversations amongst, the program managers and the ECRSs that have been directly involved with this over the past year and a half, and just a high degree of confidence with the information and knowledge we have now, and have a pretty good idea. We've already been developing scenarios in the event that we are asked to step in.
The other thing I wanted to clarify was, I believe Mr. Brock asked you, do you have a specific formula or calculation or method that you used to determine this was an abandoned well? And I think I understood your answer to be, look, my opinion here is informed by my education, my experience in the field, and extensive discussions with my staff. Is that correct?
Yeah, we do not have, there's no cookbook formula that would tell you, X moves to Z in exactly this amount of time, and this is the volume return you would expect, because there are a lot of variables,
Yeah, I appreciated some of. Oh, go ahead. I'm sorry to cut you off.
It is not unusual for. It's commonly referred to in the industry when they under what we call water flood or repressurization, secondary recovery, when they'll, especially in the higher density areas where they'll channel out, and when they say that, what they mean is all the water they're putting in is basically going to one other producer well, and that is not desirable. They want to get a radial push, so it's pushing fluids which contain the oil to various producers. And it's hard to calculate that. I mean, because you're not using looking at permeability or porosity or things like that so much once that artificial channel has been created.
Yeah, I appreciated that discussion you had with Commissioner Keen and sort of the specific reasons why you didn't think channeling was what was taking place here specifically, from a higher level.
But I do think it's channeled. I'm sorry. I think there's from the old house number 6, it's channeled to an abandoned wellbore beneath the building. That's what we think, what I think.
Yeah, I guess I was understanding that you had dug trenches and you didn't believe it was somehow channeling
Shallow within.
at a shallow channel. Yeah.
I think for clarification, it's not unusual too that, maybe we have another wellbore abandoned, but maybe the top 15, 20 foot has a good cement plug and the fluids can come up to that, but they can't come up to the surface within that wellbore. They will travel out horizontally on another, generally it's a limestone layer or something that they will travel underneath or on top of that, and then maybe encounter some other a pond or a shallow water well or something of that nature that allows it then to go ahead and make it to the surface. Where we would have multiple players instead of one direct cause and effect of inject here and a direct channel to an abandoned well.
So I want to lean on your experience just a little bit. And thinking back over all the years, you've been at the K.S.A and working with the industry. I take it this issue, it's not the first time you've seen this, where I think you called it a breakout well, where you've got injection and then you have oil that starts coming up out of another area. And like has been documented in the testimony, that can come up through an old abandoned well that wasn't plugged. It could come from geologic faulting. I mean, in your experience, what's the most common way that you've personally seen that happen?
Up abandoned wellbore. I've not seen the only, we've had natural, we're coming out on hillside, say a UIC well, an injection well. It fails at some depth, 60, 70 feet, 100 feet, whatever. And it's at an elevation such that it can come out into the formations and then daylight on the hillside or some other location where that particular outcrop or that particular lithological unit outcrops. That limestone outcrops out there on the side of this hill, and the failure in the casing is such that it traveled along that top till it went to the outcropping or where the hillside was, so that's where it daylighted instead of up the wellbore. But that's generally with a casing integrity issue, a shallow and injection well. I've not have any experience or seen where we've had injection that just communicated to the surface through some naturally occurring faulting or some odd bedding plane or something structurally.
So not even just related to this specific site with the specific geology we're talking about here, but throughout your whole district, you just have never seen that where it just naturally comes up, unless there is some specific landform like an outcropping.
Right. The fluid specific to the zone being produced, making it back to the surface, I've not seen that come from formation, from depth to the surface through some other, geological structural related reason.
So I guess I just I just kind of read your testimony to say, look, I've got these reasons why I think it's an abandoned well in your direct testimony. And then your rebuttal testimony basically goes through what we just talked about, that there's really, in your opinion, you've considered some of the other possibilities, but none of those are plausible in your opinion. And that's essentially what you're trying to say?
Correct. Okay.
I don't think I have anything else for you. Again, I apologize for making y'all take a break in the middle of my questioning. We'll blame technology. But I don't believe I have anything else for you. So I cannot tell if any commissioners, Mr. Keen or Commissioner Keither, do either of you have any follow-on questions to mine before we go to redirect?
Yeah. None for me either.
Okay. We will move to Mr. Marsh for redirect.
Chair French. Troy, I think you basically already kind of covered at least this first part, but you know, in this situation, we had oil and brine that were coming up through the cement of the building, correct?
Coming up through the conduit pathway, I mean, yeah, it's not leaching through the cement, but yes.
I want to pull up exhibit LB2, page 2 of 8 or 10 of 18, excuse me. Troy, can you describe what this picture is?
That is the crude oil and brines that were coming up in the pathways created by the utility conduits through the floor of that shop and then out the overhead door on the south side.
Okay. Is there any information that you can gain or gather no, that picture or the oil that's in that picture?
You know, looking at the picture, and in our opinion, it's indicative that's you know, can't come. It's oil that's probably coming from the reservoir and from the formation, and not, you know, oil that's been sitting somewhere in an old pit or anything of that nature.
Okay. And what would you say is the most common way for oil or brine to be brought up to the surface?
To a wellbore.
And how many wellbores are in District 3?
Tens of thousands. I don't have an exact number. You know.
Yeah.
100,000.
Sure. You know, and a lot of Keith's questions revolved around, you know, staff's providing solutions to Daylight or Daylight providing solutions to staff. Whenever you encounter situations like these, is it really the staff usually propose solutions, or does the staff allow the operator to propose a solution, will review that solution to make sure it will adequately address the situation?
Preference is to give them the desired outcome we desire and allow them to utilize whatever they want to attempt first by their own decision. You know, and when I say the desired outcome, what we want, because, you know, if we give them the desired outcome and then start telling them do this, do that, do this, and it fails, then they want to come back and claim that we were the reason it failed or this or that. So, you know, initially what we're going to do is give them what we want for the desired outcome, and then we would like to hear what their proposals are to achieve that desired outcome.
Do you believe that Daylight has shared all of the data that is collected with staff?
I have not seen the magnetometer survey. I think there may be, you know, maybe, you know, I don't know why. The GPR survey, you know, we got some detailed, but the final plot or drawing was relatively crude. I would thought maybe they would have entailed more detail. So I cannot say that I'm 100% confident they have.
Is that information that you think would be helpful to staff to have, or data that would be helpful for staff to have?
Well, I think all information that either side has would be beneficial for everybody to have knowledge of and have an opportunity to discuss, you know, what that data may entail or what, you know, how we could develop options for moving forward.
I know Keith asked you questions about when the old housing number 6 was last injected into. And I'm going to pull up exhibit JS2, page 2 of 17 and 3 of 17. Make sure I got the right screen. Troy, does the pages of these exhibits indicate that injection occurred at that well after your August 7th email?
Yeah, those dates are the end of the month, yes.
Okay. And that's whenever the injection test was conducted on the Olnhausen lease and the Johnson lease.
Yes.
And I remember that, Keith talked about Johnson's number 6 and Johnson number 7 well that were cut off below the surface. Were those two wells on Daylight's license?
Yes.
Okay.
That's
think-
that's how they knew to look for them, because they were on their license, and it I think it was impacting the area of review, and they couldn't find them.
I believe in one of your responses, I can't remember, it was the chair for answer, Commissioner Keene. You talked about that staff has been looking into researching methods that could be used to locate this well if it becomes our responsibility. Can you elaborate on that at all?
Yeah, we've just had scenarios in program managers meetings. You know, I've asked them to get together and start presenting proposals on how we would proceed. And first thing would be, we would need to do a lot of communicating. We're going to have some kind of dialogue with Mr. Tinsley, the building owner. And then, we need to decide, I think one of the things we'd want to pursue is additional GPR survey, based on the changes in the injection into the Olnhausen number 6, and if that, there was some comment on there that maybe the high fluid prevented further resolution of the anomaly that was found or referenced. I think that anomaly poses a lot of interest and would warrant further investigation, either through additional GPRs or any other technologies we may come up with to see. And once we can kind of determine that, then we can make some determinations of how we would, if we could proceed further to gather more information from beneath the building. Been brought up, is it possible that we would have some kind of, if we excavated near where the original observation pit was, is there any technologies that would allow us to look underneath that floor from the side? Can we get in there and see if we can pick up, a well bore or anything else, whether it's got casing in it or not, but if we could project from the side into to get see if we can locate something.
Thank you. I don't have any other questions.
All right. Thank you, Mr. Marsh. Mr. Brock, do you have any quick recross?
I do. I'm sorry, Mr. Chairman, but I've got some.
Okay, you're standing between us and lunch.
I know. Mr. Russell, you had testified in response to Commissioner Keene's questions that basically the NOV in June of 2024 was prompted because there was a lack of action and communications on the part of Daylight, and that they wouldn't take further steps. Do you recall that testimony?
Yeah, I recall the testimony. I don't know about the characterization of it, but yes, I recall my testimony to Commissioner Keene.
Well, if I mischaracterized it, how would you characterize it then?
I think I don't mean it so harsh as that, the lack, but the communication, and it was intended that we needed to have some benchmarks to meet these deadlines. We needed some deadlines to get things moving and reestablish, I guess, a working communication cooperation, because I feel at that time that they had resolved that this was just going to be a monitoring well solution, their proposal, and I do not agree with that at this time.
And so their actions sort of gave you no choice but to issue the NOV with the deadline. Is that essentially correct?
Yeah, and yes.
Okay. Isn't it true that you first issued an NOV with basically identical language to this one on August 10th, 2023, only 2 months after this breakout occurred?
Yes, we did, and we had a lot of communications, and I think from that, we granted, I think what eventually amounted to, 30 days within that letter, a 30-day extension, and then a 60-day extension, and then ultimately till, I think it was loose word, but that, we would give them till late spring, early summer to address the building owner's concern about being able to have a place to park his commercial vehicles or bulk cement trucks, whatever, that prevented them from being outside and freezing.
I guess just to cut to the chase, your first NOV with this deadline was issued August 10th, 2023. That was before Daylight even finished conducting the injection test that you were requesting, before they performed the ground penetrating radar study, before they employed the magnetometer, before they plugged the other 3 wells, before they drilled the monitoring wells, before they, you understand where I'm going. You indicated that staff was essentially forced into this situation by Daylight's inactivity, but you started the NOV process on August 10th, 2023.
Yeah, but there are occurrences or infractions that require a response from that, and that is the best way we have to document and to make sure we get the ball rolling, because there's nothing preventing. If we don't have that deadline, I could get 60 days down the road and they're still dragging their feet, and now I got to send an NOV giving them another at least 30 days. So I'm 90 days, 120 days down the road. Whereas if you send that and get that out there on paper and say, hey, we want to work with this. If you not start, but if you are cooperative and working on this, we will grant extensions as long as we're making progress.
So you indicated that staff was basically having meetings and researching methods and presenting proposals to conduct additional search for an abandoned well. Is that correct?
Yeah, after the last NOV, I believe, and then once from the last few emails we got where we indicated that we weren't in agreement with their conclusions or their findings of their sampling, and that there was no impacts, then at that point we decided that we should probably start preparing for some scenario, or get more detailed plans in place or information to either share, or that if we were appointed to address this, that we be prepared.
Why wouldn't you share those ideas with Daylight and ask them to perform those operations?
They did not communicate with us. I mean, I sent that email and told them we did not agree with their conclusions, and I never heard back from them. And it ain't like Daylight's the only activity we're doing. I mean, we are conducting numerous activities within the district all the time. And, I would like to see some, be proactive initiative. I mean, if I had received an email saying that somebody did not agree with one of these things or what we were doing, then I would reach out and say, well, let's discuss this. Let's see what we can do to move forward. The next thing I heard, we were doing pre-file testimonies.
How would someone tell you that they didn't agree with an approach if you never bothered to tell them what your approach was?
We told them that we did not agree with their analysis of what they're doing. That conversation then would have took place subsequent to that. Never even got the opportunity to get to that point.
Moving on to the pit, you'd referenced that the monitoring pit was closed basically unilaterally. Isn't it true that Rolando sent you an email before the pit was closed informing you that the pit was going to be closed so the landowner could resume access to the doors, and on 2 separate occasions, and you I mean, you didn't say, no, we don't want it closed. You didn't object. You basically said, sounds good, keep us posted.
No, the conversation was, and in his email, he states that he will put in a shallow monitoring well in that location so that we would at least still be able to monitor or to collect samples, and that was not done. And that is specifically stated in his email that they were going to do that.
So now are you saying now that they did not close the pit without authorization or without approval?
It was not authorization approval, is that our position was that we thought that was a very valuable method of observing what was going on. And then when they decided it was understood, okay, you don't want to disrupt the business, but they were going to install a monitoring well so we could get much of the same information we would have been able to get just leaving the pit open. And they did not do that. There is no monitoring well there that was indicated that they were going to input.
I'm even trying to find the page. All right, I'm going to share my screen. Can you see my screen, Mr. Russell?
Yes.
So this is TR7. The page that we're looking at is page 39 of 46. This is attached to your rebuttal testimony. And this part,
yeah, I see that top part.
okay. And so then you see Daylight plans to backfill the observation pit so that the business owner can utilize this building to full capacity. So that's Rolando sent that to you on August 29th. This is you sending back to him on September the 5th. Thank you for the update on Daylight's plan of action. Then you're talking about, sending out an NOV letter. Then again on September the 7th, Rolando sends another email. As of now, our plans for filling the observation pit have not changed. On September 7th, you send an email back. Thank you for the information. Looks promising. I mean, it doesn't look to me like they unilaterally closed this pit. Would you agree?
No, I want to see the email where he indicated that they would implement the monitoring well.
And we can talk about that with Mr. Benjamin, and we'll raise it with him and he can speak to it.
Yeah. Because I think, and I don't know, we must not have them, they don't have them. Didn't do a search of phone records, but I think there was some communication verbally that, when we addressed our concerns about closing the pit, that's why they proposed putting that monitoring well in, but I don't have those records with me.
I'm just going to cut in real quick. I'm going to make the editorial comment that I'm not sure how fruitful the questioning is on, what's the back and forth here. I'm having a hard time figuring out how to apply that to the case. So Mr. Brock, you can continue, but just would urge you to be brief and help us if you want to make a proffer of what you're asking us to apply here. That might be helpful.
Understood, Commissioner. I was finished with the line of questioning anyways. I just felt that when staff alleged that Daylight unilaterally closed this pit, it implied that Daylight was not in cooperation. And my only intent was to show that this was communicated. This was not, a disregard for authority or anything else. That's all I was getting at with it.
Okay, thank you.
One last question. You had said either in response to Commissioner Keene or Commissioner French's question that you do sometimes see a breakout occur when basically fluid travels up an abandoned well, hits a plug or some other obstruction, and then basically surfaces somewhere else. You indicated that you do see that.
We have seen that in a few cases.
And there's no way to be sure that that isn't what's occurring here, correct?
Well, the monitoring of the fluid levels in the inactive wells, the number of active were there, did not indicate that. We did not have, to get to the surface underneath that floor, there would probably be a high probability that we would have shallow communication that, they dig the trenches up around the perimeter of the building to check. Before we would want to get to the point where you guys like to say we're going to destroy or raise the building to the ground, we could do that. We're not picking up any oil in any of the monitoring wells of that would indicate of a shallow pushing through there like that. You would expect with the oil that came out from under the floor into the observation pit that it would be likely that we would have intercepted anything that was coming across from another old wellbore like that. And I have not seen any indication of that.
One final question, then I'm done. How would someone ever prove that this was not an abandoned well? How much digging would ever be enough for you to decide that this is not an abandoned well?
Well, there'll have to be a point source somewhere. I mean, how did that crude oil get under there? What other source is there? How would we, I guess if we found the other point source outside this area that said, okay, it does appear we found what you alluded to, and it's coming up to this point and moving across, then this is our point source, and that's what happened afterward. It's moved over to there and it did come up, but I'm not seeing anything much at all that would lead me to believe there's not, and I don't know about how much digging. I mean, some of these questions we can't answer till we have more information.
I don't have any other questions. I appreciate you letting me have the time.
All right. Thank you, Mr. Brock. Any further commissioner questions? I see a no from Commissioner Keen. Nothing from Commissioner Keither. All right. We will move on to redirect. Mr. Marsh, if you have any.
Thanks, Chair French. I don't want to beat a dead horse here. I just think that the record needs to be complete and clarified. So I'm going to bring up Exhibit TR1, page 1 of 19.
I really can't hear for some.
Same thing. Mr. Marsh, do you have like some papers or something covering your microphone?
I don't think so.
Oh, you sound better now.
I have a lot of papers on my desk. Don't get me wrong. But
you do sound better now.
I wanted to bring up a few things just to clarify the record because I think they got glossed over during Keith's questions. Troy, on Exhibit TR1, there was a September, this is regarding the August 10th, 2023 letter. That letter provided a deadline, but also allowed for an extension to be granted, correct?
Yes.
Okay. And then I want to turn over to Exhibit TR7, page 39 of 46. In the second paragraph of that email from Rolando Moreno, they indicated that they were going to install a monitoring well in the observation pit, correct? Whenever they backfilled it.
Yes.
But that, to your knowledge, no monitoring pit was actually, or monitoring well was placed into the observation pit.
No, there was not.
Okay. Thank you. I just felt like those were glossed over and probably need to be, make sure they're included in the record, at least referenced.
All right. If you are done with your redirect, Mr. Marsh, I think Mr. Russell is finally relieved. Mr. Russell, we thank you for your testimony, and you may virtually step down at this time.
Thank you.
At this time, we've got a lot of witnesses left, so I'm inclined to just take a short lunch break. Let's do, well, we've got 39 minutes until 1 o'clock, so that's how long we're gonna take. We're gonna restart, and we're gonna go into recess now, and we're going to restart with staff's next witness at 1 o'clock. So at this time, we are now off the record and in recess. All right, I have 1 o'clock. Before we go back on the record, just want to make a quick announcement. Commissioner Keene has had an emergency meeting come up for this afternoon. It's an unavoidable conflict, but he's going to need to leave at about 1:50. I think Commissioner Keene, you said you'd be able to be back around 3 o'clock. Is that correct?
Or even before. I hope
Okay.
so. It's an emergency neighborhood meeting, so I'll do my best to get back as soon as possible. Anything I miss, I'll certainly make up for through the recording.
Yeah, wanted to make that clear for everybody. We do record these and we'll have a transcript, and so Commissioner Keene will be able to participate and review the record. But we didn't want there to be any mystery if you saw Commissioner Keene disappear, that he is coming back. So with that, we will now go. Well, before we go back on the record, Keith, I haven't heard you speak yet. Can you just confirm that you are back?
Yes, I am back.
Okay.
Thank you.
Very good. All right. We are now back on the record in this proceeding, and staff, you may proceed to call your next witness.
Thank you, Chair French. Commission staff calls Julie Schaefer. And if we can update the name, that would be appreciated.
Ms. Schaefer, while they're updating your name, let's go ahead and get you sworn in. If you would please, well, you have to, yeah. If you would please raise your right hand for me. Do you swear or affirm the testimony you will give today is the truth, the whole truth, and nothing but the truth?
Yes.
All right, thank you. Mr. Marsh, you may proceed.
Thank you. Please state your full name and title for the record.
Julie Schaefer, District Geologist for Conservation Division, District 3, K.S.A. in Chinook.
Are you the same Julie Schaefer who caused to be filed in this docket direct testimony consisting of 7 pages and 3 exhibits on November 1st, 2024, and rebuttal testimony consisting of 11 pages and 2 exhibits on January 31st, 2025?
Yes.
Do you have any corrections to make to your testimony?
Not that I believe.
Do you swear the answers contained in your pre-filed testimony were and are true to the best of your knowledge?
Yes.
At this time, staff moves for Ms. Julie Schaefer's pre-filed testimony and exhibits to be admitted into the formal record.
Just incorporate the commission exhibit number 1.
That is noted, and we will admit the reference testimonies into the record.
Thank you. Staff tenders the witness for cross-examination.
Mr. Brock, the witness is yours.
Thank you. Good afternoon, Ms. Schaefer.
Good afternoon.
So I don't have a lot of questions for you, just a couple. There's a portion of your testimony where you indicate that the correlation between the chloride levels and the formation containing the produced fluids and also the chloride levels that were found in the monitoring pit indicate that there would have to be a direct conduit between the producing formation and the surface. Do you know the portion of your testimony that I'm talking about?
I do recall. If you have a specific place in mind,
I'm just, did I characterize it correctly? That's really all I'm after. I'm not.
Okay.
Did I characterize it correctly?
Yes.
Okay. So if there were not a direct conduit between the producing formation and the surface, what would you expect to see in chloride concentrations?
I would suspect if it has had to travel laterally through some other media, limestone, bedding plane, anything like that, groundwater, it's gonna be a very reduced chloride concentration. This, as fast as it made it to surface, and with the not only produced brine water, but also oil, as fast as it made it, and everything that was in there, and the chloride concentration that it had, I would expect that is a pretty direct conduit.
And so what you're saying is if it wasn't a direct conduit, the chloride levels would be reduced.
Chloride levels would be, I would think, through filtering, it would be very much so reduced. And then also, I don't believe that you would have pushed those heavier oils through that media as well if it had to travel through various different paths.
And so would the amount in which it was reduced depend upon how much material it had to be pushed through and what material it had to be pushed through? Would that be true?
I think that can be true, yes.
So later on in your rebuttal testimony, you indicate that the only explanation for the difference between the produced fluids being 45,000 ppm of chlorides and the sample at this pit of being 41,000 ppm for chlorides is that it came into contact with fresh water. You recall that?
I do recall that.
But today you've testified that if there was not a direct conduit and it passed through some other media, that would reduce chlorides as well.
Well, as closely related as the parts per million concentration was, it passed through, it obviously passed through groundwater if it came up through table 1. And so it did dilute it some, but we put in produced fluids from that lease into the producing formation from that injection well, and what we got up is produced fluids from that lease.
So shifting gears a little bit, in your rebuttal testimony, this is on page 7, line 19. You were talking about potential contamination from poor industry practices. Not going to ask a lot about this, but I'll let you find it just so you can.
Okay, yes.
Okay. So you state that with any historical oil lease, this can be a possibility. And then you say, additionally, and then you go on to explain, additionally, if there were any evaporation pits, though, at the surface or surface releases of produced water, the impact would be seen at surface for long periods of time after the fact with vegetative damages, et cetera. Have I accurately characterized that testimony?
Yes.
So to summarize, you're basically saying that since with any site where there's historical oil production, there's a possibility of contamination from that production, but you would expect to see something on the site in terms of vegetative scarring or something else that would indicate it. Is that basically accurate?
In this regard, where you are asking, or where the question was about evaporation pits and surface releases and things like that, yes, you will see those on site, on ground surface.
And so what if you did see those on the surface? How would that affect what you would expect to find in these samples?
Well, I mean, if you were seeing this on surface, which we're not, you can look through the historical aerials. We would then collect soil samples and look for soil alkalinity in that regard. Most likely any fluids would be long gone.
But if you did see something on the surface, that could be an explanation for the chloride concentrations that we're seeing.
I guess I'm not following what you're referring to here. If I did see something at surface,
Yeah,
I mean, I seen something at surface in the observation pit. Is that what you're referring to?
Yeah, I mean, if we did see the surface scarring, the vegetative impact at this site, would you expect to find potentially chloride concentrations similar to what we found here?
The 40,000?
No, in the water monitoring wells.
Well, there would likely, I mean, I guess if there were scarring and you drilled a well and put a monitoring well in that scar, is that what I guess you're trying to lead to?
Yeah, that's what I'm asking.
It would be hard to tell you exactly what the chlorides in those wells would be, but it could be.
It could explain it if you saw that.
It could.
Okay, thank you. I'm going to share my screen really quick. Can you see my screen, Ms. Schaefer?
I can.
So this is attached to Troy Russell's direct testimony. It's page, let me find his exhibit number. TR1, page 17 of 19.
Okay.
And on this exhibit, I assume Mr. Russell's drawn a circle around what is a large discolored surface impacted area. Is that correct?
I actually drew that, but yes.
Okay. If we scroll down one page, that outline is shown again over the current, what the site looks like currently.
Correct.
And we scroll down one more and it shows it again. So looking at this, it appears that the entire area that was shown as being impacted at the surface is covered by a commercial building and an adjacent parking area. Would you agree with that?
I would.
And so any surface impact would have been destroyed during the construction, correct?
That is correct.
Okay. I have no further questions, Mr. Chairman.
I will state that that building was not built until I believe it was sometime between 2006 and 2007, and there are plenty of additional aerials that lead up to that point that have green vegetation growing.
Is there anything in the record that you can point to?
Just in my statement that says there is no indication of such damage in this area in either recent or historical aerials.
I have no further questions, Mr. Chairman.
All right, thank you, Mr. Brock. We will now turn to commissioners. Commissioner Keen, any questions?
Thank you, Chair French. Good afternoon, Ms. Schaefer.
Good afternoon, Commissioner King.
I must tell you, in all honesty, the depth of the cross-examination, redirect, and recross of Mr. Russell is such that, frankly, all the questions I've had have been answered. I have read all of your testimony. I appreciate it being in the record, but I have no questions for you this afternoon.
Okay.
Thank you.
Commissioner Keither, any questions?
No questions.
And I'm in the same boat as Commissioner Keen. Your testimony provides a lot of detail, but I don't think that I need any clarification of it at this time. So with that, we'll turn it back to Mr. Marsh for redirect.
Thank you, Chair French. One question, hopefully. Maybe two. Julie, whenever there was I know there was some geoprobe testing done at this location, but the geoprobe wasn't able to reach further down than 10 to 12 feet. Can you explain why?
Looking at drilling logs in that area, we informed them that there was going to be a hard interval. It's a sandstone interval at the 10 to 12 foot mark, and that the geoprobe was not going to be able to push through that. And so those that were supposed to be pushed to 25 feet were not. They were only pushed to that 10 to 12 foot. And so the data gathered from that was very minimal. And of course, those geoprobes are only left open for whatever it is, 24, 48 hours, something. I don't know exactly. And then they close them.
So is it reasonable to think that any surface contamination would be prevented from reaching the rest of table 1 due to that layer?
Yeah, and I believe I bring that up in my direct testimony in rebuttal, one of the two, that is the point of, Eastern Kansas geology is confining layers.
Thank you. No further questions.
All right, thank you. I don't believe, since we didn't have commissioner questions and Mr. K.S.A only had that one question. Mr. Brock, I'm assuming you don't need to do any recross?
I do not.
Okay.
No.
Very well. All right, Ms. Schaefer, we thank you for your testimony. You may step down virtually.
Thank you.
All right, we now turn to staff's final witness. Mr. Marsh, you may call your final witness.
Thank you, Chair French. Commission staff calls Levi Burnett. And if we can update the name, please. Thank you.
All right, looks like we've got Mr. Burnett now. Good afternoon. If you'd unmute yourself, I'll get you sworn in. All right. Do you swear or affirm the testimony you will give today is the truth, the whole truth, and nothing but the truth?
I do.
All right. Thank you, Mr. Marsh. The witness is yours.
Thank you, Chair French. Please state your name and title for the record.
Levi Burnett. I'm a environmental compliance regulatory specialist for District 3 out of Chinook, Kansas.
Are you the same Levi Burnett who caused to be filed in this docket direct testimony consisting of 8 pages and 4 exhibits on November 1st, 2024?
Yes, sir.
Do you have any corrections to make to your testimony?
I do not believe so.
Do you swear the answers contained in your pre-filed testimony were and are true to the best of your knowledge?
I do.
Thank you. At this time, staff moves for Mr. Levi Burnett's pre-filed testimony and exhibits to be admitted into the formal record.
Any
I would-
objection?
I would just incorporate Commission Exhibit number 1, and I would just like to add that on this particular witness, he's indicated that the fact that the Olenausa number 6 passing an MIT is the sole basis on which he believes there's an abandoned well. And so when we get into the sufficient facts or data, I think this one's even unique beyond the others, that one fact certainly doesn't meet the threshold. So I just wanted to voice that.
Well, we will.
Yeah.
Yeah, well, I'm going to overrule the objection, but we will note both the continuing objection and your additional objection for the record.
Thank
Mr.
you.
Marsh, with that, we will admit the reference pre-filed testimony into the record. And Mr. Marsh, if you wish to tender your witness.
Thank you. Staff tenders the witness for cross-examination.
All right, Mr. Brock.
Yeah, good afternoon, Mr. Burnett. How are you?
Good afternoon. I'm doing good. How are you?
Good. A good excuse to be in the office today instead of out in the cold, huh?
It is.
Well, I want to ask you some questions about some abandoned wells that were found buried on this site. Mr. Russell said that you were the one that had these conversations, and so
Objection. Is this relevant to the issue of the petition?
Let's
Absolutely.
let Mr. Brock restate the
Okay.
full question, and
All right.
then you can make your objection. Start from the beginning, Mr. Brock.
Yeah. Am I correct that there were 2 wells on this Johnson lease that were discovered that had been cut off below the surface, buried, and had a pipe lane, or I'm sorry, a metal plate laying over the top of them?
Objection. Relevance.
I'll let him continue to if he can try to establish relevance. I think Mr. Russell did defer some of these questions to Mr. Burnett. So
I was just trying to hurry us along a little bit, but now I'm slowing us down. So
very good. Go ahead, Mr. Brock. I'm going to overrule the objection for now.
Do you remember my question, Mr. Burnett, or do you want me to
If
ask?
you would give it to me again.
Is it true that there were 2 wells on the Johnson lease, and I may be wrong about the numbers, but I believe they were the 6 and the number 7, and they were found buried below the surface with a metal plate laid over the top of them. Is that correct?
That's correct.
How were those 2 wells found?
The previous landowner operator had marked them.
What was his name?
Johnson. I'd have to look back and get his first name on my.
Mr. Johnson? No, that's good enough. And you said he was the previous landowner and the operator of the lease?
As far as I understand, he was the previous landowner and a previous lease operator of that Johnson lease.
Who called him? Do you know?
I did.
And what prompted that?
Trying to get a good idea of where those well bores could have been located.
And did he indicate when you called him that he knew, or what? How did this? Can you just walk me through what transpired?
Well, I told him what I was looking for and asked if he could recall a close proximity where they would have been, and he said he would stop by that evening and mark them on the property so that we could come in and excavate, those locations and verify that they were there.
And where they found where he had marked them?
Yeah, relatively close.
Did he tell you how he knew that they were there?
Yeah.
What did he tell you?
This isn't word for word, but he told me that they were, I believe he said they were dug up and cut off because they were taking up space on what he needed for more parking or more area to stack equipment out on.
That was done by him?
He never told me it was done by him. He just told me it was done.
Did he indicate that there may be other wells that had been cut off and a plate put over them?
No, he did not.
Did you ask him?
No, I don't think I did.
So we're at this point, you're searching for a potential abandoned well beneath this building,
Right.
correct?
Correct.
And this landowner told you that he cut off two and buried them to make room for parking, correct?
Correct. Or somebody cut him off.
And you didn't ask him if he knew if there were others that.
Well, I filled him in on what we were looking for, what we were potentially looking for. And he explained to me that he had to dig where that building sits. He had to, it's the best way to put it. He had to build that material up right there where that building was going to sit. So he could have that concrete framed and poured. But he applied that he never noticed anything from when he was building that commercial building.
So if you didn't ask him, he just volunteered that?
Well, I like I said, I told him what we were looking for. We were looking for a potential. We had possible abandoned well under that building, and that's when he informed me that the work that he had done, the dirt work he had done on that property, and that he didn't recognize anything when he was doing that construction.
Do you personally know Mr. Johnson?
No, I do not.
Is there some, I'm just trying to figure out why he wouldn't have been asked if he knew if there was a well underneath this building.
Well, so my initial conversation was to locate the Johnson 6 and 7. That's what I was trying to get accomplished. If he tells me he didn't notice anything during construction of that building, at that time it was recognized as a possible well location or a possible leaking well.
Did you ask him where a well might be if there were one underneath that building?
No, did not.
In ordinary staff practice, if you were searching for an abandoned well and you encountered someone that may have information about its locations, wouldn't it be normal to ask that person where the well might be located?
Well, if you had records stating that you believe there was a well underneath there, some documentation, I don't know if it was at that time, if it was directly underneath it on the outside of border of it. There was no, at that time, there was no records.
I guess I mean, let's just walk through an example. If you're searching for an abandoned well on an operator's lease and you feel like that operator might know where that abandoned well is, wouldn't it be customary routine practice to ask that person who may have potential knowledge where it might be located?
Yeah, I mean, it could, if you have an idea to point him in the direction of a well name and number. The 6 and 7, I knew, or there's records of those wells being out on that property. To me, there was nothing to, I couldn't ask him in reference to a well name and number and, for him to give me an answer to.
I appreciate your honesty, Mr. Burnett. I really do. That's all the questions I had on that particular line. I have one other question on a different area. Let's just see if we, can agree that, would you agree that unless someone actually discovers the source of this breakout, nobody can definitively determine whether it's an abandoned well beneath the footprint, an abandoned well at some adjacent area, or some other cause? Would you agree with that?
You give me that question one more time.
Wouldn't you agree that unless someone actually finds the source of this breakout, that there is no way to know whether it's caused by an abandoned well underneath this building, an abandoned well somewhere adjacent to it, or some other cause that you haven't considered yet?
No, it's coming from an abandoned well.
And the basis for you knowing that is the fact that the Alwyn House in number 6 passed an MIT. Is that correct?
No. I mean, there's more to it.
Why didn't you write that in your pre-filed testimony?
Did I leave quite a bit out in there?
Is it basically the same reasons that Troy Russell listed earlier? I don't want to plow the same ground with you. And so if it's the same reasons, and your answers would basically be the same as his, then I won't go into that. But if there's something different that you would like to say, I'd like to hear it since you're, on the ground. I don't know if that's permissible. If I've confused you, I'll reword it, but I'm just trying to say.
If you would reword it.
So were you present earlier when Troy Russell was testifying and I was examining him about the basis for him believing that this was an abandoned well?
I was listening to something, yeah.
Are the reasons that he gave basically the same reasons that you would give me if I asked you those same questions now?
Possibly. I don't recall word for word what his response was, but
I'm just trying.
Go ahead.
I'm just trying to shortcut and find out if you know anything more than Mr. Russell did. And if your reasons would be the same, if the facts and explanations would be the same, I'm not gonna go through that with you. But if you know something new or unique that he didn't share, I need to ask you about those.
As to why I believe there's a well bore under that or nearby that building?
Yes.
Do you recall all of Troy Russell's responses?
I mean, I can summarize them. We went on for a really long time. Basically, he said that there was pressure communication between the Allen House and 6 and the breakout, that water samples between the Allen House and injection system and the monitoring pit were similar, and there was an aerial photograph with a dark spot that Julie had found.
Okay. Yeah. The direct correlation between the number 6 Owenhausen UIC well and the fluid coming up through that conduit line, or after the monitor pit was opened up, the brine, the crude oil, those are pretty good signs that you've got a well bore in, close proximity.
So there are no other reasons or explanations beyond those that I just kind of recited to you that you want to point me to?
Unless there's, some type of production line that's ran through there. I can't think of what's going to push crude oil and brine water out.
Those are all the questions that I have for you. I really appreciate your testimony. Appreciate you being honest with me and indulging me.
Thank you.
All right, we will now move to commissioner questions. Commissioner Keen, do you have any questions of this witness?
Thank you, Chair French. Good afternoon, Levi.
Hello, Commissioner Keen.
You're pretty much in the same boat with respect to my questions as Julie was, to be honest, because of the extensiveness of the back and forth and the cross-examination of Troy Russell. I really have no questions for you, Levi. I read your testimony. I appreciate that testimony. Thank you for your appearance.
Thank you.
Commissioner Keither, any questions?
No, but I'll agree with what Commissioner Keen said.
I'm in the same boat as well. Appreciate your testimony. Appreciate you being here to answer questions this morning, but I have no questions. So, Mr. Marsh, we will turn back to you for any redirect.
I guess I won't let them get off too easy and have one question left for a redirect. But Levi, you said that Mr. Johnson had indicated that he didn't know so well while doing the dirt work for the building. Is there any reason to follow up with someone whenever they indicate that they didn't see anything or notice anything?
I didn't see any reason to.
Okay, thank you. No further questions.
All right, I'm going to assume that did not prompt the need for any recross, Mr. Brock.
It did not.
All right. With that, we will relieve Mr. Burnett. We do thank you again for your testimony, but you may step down at this time.
Thank you.
All right. We've only been going half an hour, so let's keep moving. But I believe we have finished staff's witnesses. So we are ready for operators' witnesses. Mr. Brock, would you like to call your first witness?
I would, Mr. Chairman. And just to make a note, I would like to call this witness out of the order referenced in the pre-hearing conference. He has a scheduling conflict late in the afternoon, and I'm just trying to accommodate that. So we would like to call Mr. Winchen instead of he was going to be our last witness, but I'd like to call him first so he can be excused.
That's certainly fine with me. Staff, any objection? Are you prepared?
Oh, that works.
Okay, very good. Well, then go ahead. Mr. Brock, I guess you have already called Mr. Winchen. So Mr. Winchen, if you would turn your camera on and raise your right hand for me. All right, there you are. Please raise your right hand. Do you swear or affirm the testimony you will give today is the truth, the whole truth, and nothing but the truth?
Yes.
All right, thank you. Mr. Brock, you may proceed.
Mr. Winchen, can you please state your name and business address for the record?
Yeah, it's Justin Winchen. It's 1201 North 10th Street, Humboldt, Kansas.
Mr. Winchen, did you cause to be filed pre-filed testimony consisting of 9 pages and no exhibits in this docket?
Yes.
Do you have any changes or corrections to your testimony?
No.
Mr. Winchen, if I asked you the same questions contained in your pre-filed testimony today, now that you're under oath, would your answers be the same?
Yes.
Mr. Chair, sometimes in the past, the commission has wanted me to solicit education, expertise in order to fulfill qualifications. That's in his pre-file. Do you want me to go through that, or can we just skip?
No, if you've laid your foundation within your pre-filed testimony and there's nothing additional, then I would say that's all in the record.
Okay, I assumed that was going to be your answer, but Past experiences.
My modus operandi is everything written down is the same as if asked live. So
Perfect.
I think we're
Perfect.
good.
Had a commissioner call me on it one time, and lessons hard learned are hard to let go. So, since there is an objection to foundation for his opinions, I'd like to ask him a few questions about that, just to show it.
Why don't Mr. Brock, why don't we leave that for redirect?
Okay.
I've overruled the objection, so we're gonna allow the testimony in. If Mr. Marsh asks about those items in his cross-examination, I will certainly allow you to come back on redirect if that works.
Yeah, fair enough, Your Honor, or Mr. Chairman. So we would move for the admission of the pre-filed testimony of Justin Winchen, consisting of 9 pages and no exhibits.
Any objection?
No objection beyond what's already been provided to the commission.
All right, that is noted. We will admit the testimony into the record. And with that, Mr. Brock, you can tender your witness.
Yeah, we would tender the witness for cross-examination.
All right, Mr. Marsh, the witness is yours.
Thank you. Good afternoon, Mr. Winchen.
Good afternoon.
All right, I'm just going to jump right into questions so we can get you out of here as quickly as possible. On page 1, lines 3 through 5 of your testimony, it says that you've been retained in this matter by Daylight Petroleum, correct?
Correct.
So is Daylight paying for you to provide your testimony today?
Say that again.
Are you being paid by Daylight for your testimony today?
They said they'd reimburse me for time.
Okay. On page 1, lines 11 through 12 of your testimony, you state that your duties include project management and estimating, correct?
Correct.
Can you explain what all goes into making an estimation?
Well, with something like this, there's no plans or specs to go from. So basically, if I'm providing something of this sort to an owner for financing or maybe for grants, I'll take historic data from other projects that are similar, and I'll use that to come up with an estimate, which is what I did here.
Okay. So whenever you say like plans or specs, do you mean like blueprints, location, size of project, things like that?
Well, I've got the size of project as far as the building size, the amount of concrete, apron, those sort of things, and I count on doors and windows and so on. But basically, I take square footages off of similar projects, and I didn't, in order to have correct bid on concrete, you do have to have structural engineering and that sort of thing. So I used basically a similar building and kind of went with those numbers. Does that answer your question?
I think so.
Okay.
On page 3, line 5 of your testimony, you described this infrastructure as a red iron building, correct?
Yes.
So did your company build this building?
We did not build this building.
Do you know who did build the building?
I do not.
Okay. So I think it's safe to say you didn't speak to the people who built the building prior to submitting your testimony?
I did not.
Okay. Did you speak to the building owner at all prior to filing your testimony?
No.
Okay. Did you go out and inspect this building prior to filing your testimony?
No, I just used the pictures and the sketch that was given to me. I also looked it up on Google Earth to kind of verify some measurements, and I'm pretty familiar with the area. I happen to drive past this building quite often from the highway, at least, and know the general area. So I just looked at it from the road. I did not go up and speak with the owner.
Okay. Who provided the sketches that you referenced to you?
Mr. Brock.
Okay. So you did not look at any blueprints for the building before you submitted your testimony?
I did not.
Okay.
I don't think there is any to look at that I know of.
Okay. Um, I know somewhere in page 3, line 6 through 13 of your testimony, you say that the concrete floor would at least be 8 inches thick. So I guess my question is, you did not go out and actually measure the concrete floor or how thick the concrete floor was here, correct?
Correct. There's no way to measure that without drilling a hole in the concrete. So
Okay.
I was assuming based on the type of work that was done in that's what would be typical.
Okay. On page 3, lines 8 through 9 of your testimony, you state that the building was designed and is being used to repair heavy equipment such as bulldozers, correct?
Correct. That's what I was told.
Okay, because my question is going to be, how do you know what the building's being utilized for if you didn't speak to the building owner or anything else like that?
Just in conversations with Mr. Brock.
Okay. So is Mr. Brock your primary source of information for your testimony?
For the building description, yes.
Okay. On page 2, lines 30 through 31, you state that you've been asked to provide testimony concerning the cost, which would be associated with tearing down and rebuilding the building, correct?
Correct.
Have you seen any communication from the K.S.A stating that the building needs to be torn down?
No.
On page 3, line 22 through page 4, line 6 of your testimony, you state that it would cost a little over 1.2 million to tear down this building and build a new one, correct?
Correct.
And what was that estimate based on?
Based on similar projects that we've estimated and bid and won the bid, I used those square foot numbers to try to come up with that estimate.
Okay. And I believe in your testimony, you talk about obtaining pertinent prices in the area and time to complete work.
Say that again.
I believe in your testimony, you talk about obtaining pertinent prices in the area and estimating the time to complete the work. Is that correct?
Yes. Yes.
Did you include any of those pertinent prices in your testimony?
Yeah, I mean, as far as the radiant heat floor and that sort of thing, is that what you're?
Yeah, I mean, like the price per concrete, or
Yeah.
cubic
Yeah.
foot of concrete. I mean, is that included in your testimony?
Yes, it's included. Yes.
Okay, where do you point out like what the price of the concrete would be?
I don't have that broke down in the testimony.
Okay. And basically what I'm getting at is you didn't show the work that you show the math effectively that it took to get to that estimate for the building, correct?
Correct.
Why not?
I was just asked to give what the price would be, and I don't typically break it down when I give an estimate unless asked.
Okay. On page 4, lines 9 through 14, you estimate labor and materials needed. You estimate the labor and materials needed, multiplied each item by the cost of labor and materials delivered to and performed at the site. Excuse me, added applicable transportation and disposal charges, added estimated overhead costs, included a standard margin of error and margin for profit for performing the work. Is that correct?
Correct.
Okay. Don't you think that information might be pertinent to being provided with your testimony?
It could be, yeah.
Okay. I believe kind of towards the end of page 4, through the top of page 7 of your testimony, you describe that it is possible to go through the floor of the building, correct?
Correct.
Has your company ever had to repair buildings by going through a floor with radiant heating before?
We have not.
Have you spoken to anybody that's had to go through the floor of a building with radiant heating?
I've talked to plumbers about it, which is who would install that type of system.
Okay. So your company doesn't really have much experience with the process of going through a floor with radiant heating then, correct?
No, we don't. That's not something you typically want to try to do. It's pretty negatively effective on the building or on that system.
Okay. Are there multiple types of in-floor heating systems that there can be?
Really, the only ones that we've ever dealt with is like what I would consider a closed system. You have different loops, so you have different zones within the building. You can only run so many lineal feet of piping before you have to come back to the heat source. So typically we have different zones depending on the size of the building, but they're all, for the most part, generally the same.
Could there be a different type of radiant heating system in this building?
I guess there could be. I really only know of one type. But
Okay.
that's
And I'm not
commonly
trying,
used.
I don't know
Yeah.
much about it either. I was just curious if
Yeah.
there are multiple
Yeah.
types, because your testimony seemed pretty dead set on there being one. So that's why I was curious about it. You express a concern with making sure that the foundation is adequately compacted so that the floor does not shift or settle, correct?
Correct.
If a building has a leak underneath it, can that cause the foundation to shift or settle?
Yeah.
Why did you not provide an estimate for going through the floor of the building?
It's really difficult to try to figure out what that cost would be. It depends on the size of the hole. Number one, it's really when it comes to patching in areas, it's very difficult you have to expose each piece of pipe that you encounter or cut through. So it required to chip back the concrete carefully. A lot of these systems are tied to rebar, which makes it even more difficult to get it away from, get enough exposure of that pipe and to cut that rebar back, or anything, the concrete as well, to tie onto. And if you damage it at all, you just have to cut back further and keep going until you can achieve a decent amount of concrete or amount of pipe to tie onto. So it's virtually impossible to really figure out what that's going to take to do. And it depends on the size of the hole. It depends on the number of pipes you have to repair.
Okay, I think it's page 7, lines 12 through 13. You testified that if you knew exactly what the portions of the commercial building would need to be torn down and rebuilt, I could estimate the cost of demolishing and rebuilding those specific portions. Is that correct?
Yes.
Okay. I'm going to bring up Exhibit JS2, page 9 of 17. Mr. Wingen, are you familiar with this image?
No, I don't think I've seen that.
Okay. This was basically a rough sketch that was done by GSI Engineering that identified an area of high saturation that was 25 feet by 25 feet. I was just curious if they had provided that image to you to see what it would cost to repair like that portion of the building potentially.
I don't remember seeing that.
Okay. I think Mr. Benjamin's testimony talks about cutting out a 6x6, or starting out by cutting out a 6 foot by 6 foot rectangle and going from there. Did they discuss what it would cost to cut out a 6 foot by 6 foot rectangle?
Again, it's hard to put a number on that to know exactly what we're going to encounter, the number of pipes and what you couldn't really. I wouldn't put an estimate on it, because how many times do I have to chip it back because we've damaged a pipe trying to chip around it? The chipping hammer slips, cuts the pipe. Now we got to go back another 3 or 4 inches. So it's difficult to do that.
But did they have a discussion with you about a 6 by 6 foot by 6 foot portion?
I heard earlier discussing that, but I don't think we talked about that.
Okay. Have you looked into what the cost would be if staff was able to go beneath the building and not do any damage at all whatsoever?
If they went underneath the building, I don't think there would be any cost.
Okay.
If they're not,
Thank you.
they're not taking down any of the floor slab or taking down any of the building, I don't know what cost it would be on our part.
Okay, thank you. No further questions.
All right, commissioner questions, and I'm assuming Commissioner Keen has stepped away. Yeah, I don't see him anymore. Commissioner Keither, any questions?
No, thank you.
I have just one question. Good afternoon, Mr. Winchen. Thank you for your testimony. In response to Mr. Marsh, you mentioned that these systems do need to be zoned and you can only run a loop for so far. That makes sense to me. And I assume that's, part of the issue is once you've damaged a loop, that whole loop, is difficult to replace. But presumably, it would be easier to only replace, a single zone if you damaged, hopefully only a single zone. How many in a building this size? I think it was mentioned that it was 100 by 80 feet. How many zones would you guesstimate would be in a building of that size?
I think we can only go 200 lineal foot of pipe, I believe. There would be multiple. I don't know exactly.
But we don't know if it's 4 or 14 or
yeah, I'm going to guess in building that size, there'd have to be at least 6 or 8.
Okay. All right. That was just my question is, I think you can see where I was going with that is, if it was a localized item and you only hit 1 or 2 zones, presumably the other zones could be isolated. So just curious what we might be looking at.
It just depends on which way they were ran and how they were orientated. And you wouldn't really know that until you tore into them and then went back and tested those.
And hopefully they didn't weave them into a basket pattern.
Right.
Gotcha. I think that was the only clarifying question I needed. I don't, I understood your testimony and I appreciate it. So with that, Mr. Brock, do you have any redirect?
Very little. I just want to clarify a few things. Mr. Winchen, you had talked about reviewing sketches and information about the building that we had provided to you. Do you recall that testimony?
Yes.
What types of documents were those?
So I've got multiple pictures of the outside. Some of them show the inside of the building as well. And then there was just a hand sketch on graph paper showing the size of the building, the size of the apron, size of the office area, and then labeled out the number of overhead doors as well.
And was that attached to the county appraiser's records that outline the type of the building and so forth?
I don't know where exactly it came from.
So when you talked about coming up with your estimate and determining prices, it sounds like they'd like to know how you came up with your value. Do you have notes or something in front of you that you can explain that to us?
I do. I have somewhat of a schedule of values.
Okay. Walk us through that.
Okay. So on the shop area, do you want to break down each division and the price I had for each one, or just kind of how I broke it down without the monetary amount?
You explain however you came up with this value and whatever detail you feel is appropriate.
So I've got general conditions, which is, cost of some of the equipment, office personnel time, porta potties, dumpster, that sort of stuff, valued at $37,625. Have earthwork at $62,500. The concrete for the building, that's the 8,000 square foot of 8-inch, 900 square foot of 4-inch at $163,750. The site concrete, which would be 66,420 square feet at $81,000. The pre-engineered metal building, including the insulation, both the office and the shop area, which is 8,900 square feet, $387,500. There was 4 exterior walk doors at $5,550. Overhead doors, there's 3 of them for a total of $35,475. In-floor heat system, just in the 8,000 square foot shop area at $56,250. And then the electrical at $156,250. In the office area, as far as the finishes, the shell part was included in that price above. I've got aluminum doors and windows. There was 4 windows, 1 aluminum storefront door at $7,500. The interior finishes of that, $50,900. Then plumbing and HVAC at $62.50 a piece.
I think that's enough detail. If there's additional questions about it, I'll let them ask you. Talking about your experience with in-floor heating systems, has your company installed them before, built buildings that had in-floor heating in it?
Yes.
And so are you familiar with the systems then from that perspective?
Yeah, being a general contractor, we don't perform a lot of those tasks, as far as mechanical, plumbing, HVAC. We just supervise them. Obviously, part of our estimate and that sort of thing, but then we just supervise it being done. We don't actually do the process ourselves.
Did you did you inquire about the possibility of repairing in-floor heating if there was a portion of the slab?
Yeah, I spoke with a plumber about it, and he said that basically there's no guarantee on it. Once you get into a system like that and start cutting and patching, there's just no way anyone would want to try to warranty that work. And I would agree with you myself. There's just too much liability with the floor shifting or anything. You're kind of isolating all those pipes, and all of those connections would be right in line with the saw cut, where that's where you'd have shifting to concrete. If you did cut out a small portion, that's where you'd have your issues of settling or anything else. And that's also going to be right where those patched in connectors would be. So it's my opinion that they would not be a good, something I'd want on under my floor.
And you had talked about that you're unable to estimate the cost to cut out a portion of the floor and replace it. Going toward that, would it make any difference where on the floor it was located, or what portion of the building might need to be taken down? Like, just in scenarios, can you just walk me through why the location and the size makes a difference? Why it would affect cost?
On the floor slab, obviously, the more you cut out, the more of these connections you're going to have. So the larger it gets, the bigger the risk, because you're going to be getting to more pipes, obviously, because they crisscross the building, and potentially, different zones. As far as tearing down the building to have to stand any kind of equipment to take anything apart, if you would happen to be right at the edge of the building, in the middle of 2 column lines, or how much you guys know on buildings, we call them columns and haunches or rafters. And those are the main frames of the pre-engineered building. If you just have to take out the secondary framing, which purlins in the roof, and pull them back a little bit, pull some of the roof sheeting off, you know, the cost isn't all that great. Maybe you only have to go 15 feet in and take a 20-foot wide section of roof sheeting off. But if it happened to hit under a haunch, you would have to take that that whole frame line down, as well as the two adjacent bays, all the secondary framing, the purlins, and potentially the girts, depending on where it's at, to expose a much wider area, because you can't just leave it dangle in the air. So if it hit under a haunch, you're taking a 40-foot section of roof out, versus hitting, in the center, you're taking a 20-foot section out. So it's just hard to figure out what depends on where that hits, or if it hits right on a column where there's a column footing, then you're shoring the building up and tearing out that footing, which holds the building up, obviously, and you're tearing that out, which is even obviously way more difficult than tearing out an 8-inch concrete floor. So.
And so is with all of those open questions, is that why you can't estimate?
Yeah,
the
there's
cost
just
of-
no way to know.
Those are all the questions that I had.
All right. I'm going to assume no further commissioner questions. Mr. Marsh, any recross?
Briefly, if I may.
You
Mr.
may.
Winchell, you talked about, sorry, I jumped the gun there a little bit, Chair French. Mr. Winchell, you talked about reviewing sketches and documents from the county appraiser's office when creating an estimate for the building, correct?
Correct.
So
Or
why
whatever
was
was
that?
provided in the email.
Okay, so why were those documents not attached to your testimony?
I don't know. I didn't know I needed to, I guess. So.
Okay. And then you went through kind of the grocery list, I guess, of what it would cost to do certain things. Why was that not attached to your testimony?
Again, I was just giving a dollar amount like I would normally do on a project. We typically do not break down our estimates when we provide something to an owner, unless it's just asked from us. So.
Okay, but you did have the cost broken down, at least to some extent, in order to create your estimation, correct?
Yes.
Okay.
Yes.
And you said that you usually contract with a plumber to put radiant heating in the floor?
Yes.
Okay, no further questions.
All right. Mr. Brock, any final redirect?
No, thank you.
Okay, thank you. All right, Mr. Winchon, I believe you're done.
All right.
You may step down.
All right. Thank you.
Thank you for your testimony. With that, let's see. Oh, we've been going an hour. Let's take a very brief break. Let's take a 7-minute break, and we will reconvene at 2:10, and we will tackle our final 2 witnesses at that time. Is that all right with counsel for staff and operator?
Sounds good.
Yes, thank you.
All right, very good. We're in recess until 2:10.
Ready to go again?
Yep. All right. Do I have both Mr. Marsh and Mr. Brock back?
Yes.
And I see Mr. Marsh. All right. Mr. Brock, you may call your next witness. We are out of recess and back on the record. And now, Mr. Brock, you may call your next witness.
We would call K.S.A. Wheeler.
All right, Ms. Wheeler, will you please raise your right hand for me? Do you swear or affirm the testimony you will give today is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Mr. Brock, you may proceed.
Can you please state your name and business address for the record?
K.S.A. Wheeler, 2900 Northwest Button Road, Topeka, Kansas.
Ms. Wheeler, did you cause to be filed pre-filed testimony consisting of 31 pages and 2 exhibits?
Yes.
And do you have any changes or corrections to your testimony?
No, I do not.
If I asked you the questions contained in your pre-filed testimony today, now that you're under oath, would your answers be the same?
Yes.
Ms. Wheeler, have you reviewed the pre-filed rebuttal testimony that staff offered in this case?
I have.
Did anything stand out to you?
Yeah, there was a few things. There were
Objection.
Go ahead. What's the objection?
Well, I mean, generally, we're just here to introduce the testimonies aren't in the record, so I feel like this is just additional testimony that hasn't been provided up to this point, so.
Mr. Brock?
So I won't do it with my next witness, but essentially with staff's witnesses, they introduced their opinion in their direct testimony without providing any details as to the reason how they reached those, any basis. That was part of the reason for our objection, our evidentiary objection. And then they contained those details in their rebuttal testimony, which basically prevented us a meaningful opportunity to respond. And so this is our first time we have an opportunity to respond to this stuff that was first raised in the rebuttal testimony. And I will recognize that we're on a relatively short leash and I only have less than 10 areas that I want to ask about.
Well, I'm going to sustain the objection. This is the schedule that we set up. We do not allow additional rebuttal testimony to be presented orally. So I think we're going to leave it with the pre-filed testimony. If there is questioning on redirect that's directly related to cross-examination, of course, you can bring it up at that time. So I am going to sustain the objection.
Mr. Chairman, can there is an additional round of water samples that were collected after the date that our direct testimony was introduced, before staff's rebuttal was filed, but that's not in the commission record. And may I just introduce that to her, admit it? I won't ask her questions about it, but I would like that additional round of sampling to be made part of the commission record in some form or fashion.
Let's not handle that in the hearing on the fly. This isn't something I think I was aware of. I don't know if the other parties were aware of. If you want to introduce additional information, why don't you file a motion for a late filed exhibit after today's hearing, and staff can respond if they need to. Is that acceptable, Mr. Brock?
Just for her clarification, I may reference that exhibit at some point, so just for clarity purposes.
Okay, well, certainly if it comes up in cross-examination, then we can take note of that exhibit today.
Okay, thank you.
I mean, the reason that we didn't bring it up earlier is staff had indicated they were going to introduce this exhibit, and so it was our anticipation that it was already going to be in the record. It hasn't been introduced by their witnesses. That's why I'm asking to do it now.
I would certainly err on the side of having a more full record, particularly if the parties can stipulate that this is, evidence that has a foundation and is relevant, then there's no reason we can't make it part of the record right now, just as stipulation. Mr. Marsh, is it within your exhibits? Do you have it marked as an exhibit?
I don't have it marked as an exhibit. I don't know that I had the complete report, so that's probably partially
Mr.
why
Brock,
we didn't.
do you have the document marked as an exhibit?
It's the title of the PDF file is an exhibit name. I sent it to Mr. Myers and Mr. Marsh this morning.
Let me see if I can go back through my emails and find it. Potential operator exhibit. Is this document that you sent all one document, and is that the document that you're referring to?
Yeah, the title of the PDF is KW-3, and then it goes on to the rest of the name, but the KW-3 was an exhibit number.
I think it lost that nomenclature when it was sent to me.
Okay.
I'm guessing John renamed it. But yes, is it the let's see.
Says
the first page here. Let me just share my screen real quick, if that's okay with you, and you can verify that this is the correct document. Is this the document?
Yes, it is.
Okay. And this PDF, that's the only thing in this is this one report.
It should be several pages, correct?
It is, yeah, it's quite a few pages. I
Yeah.
think it is 24 pages. All right, well, we may wait until it gets brought up. Mr. Marsh, if you bring this up on cross, we'll name it as a staff exhibit. But I think I'll wait until now. But as I understand it, the parties are going to stipulate that this can be admitted into the record. So we'll wait till it gets brought up. But if that's the stipulation, then I've got no problem letting it in. But let's wait. Let's go ahead and Mr. Brock, if it's okay with you, I'll have you tender your witness for cross, and then it sounds like your document's going to come up at that time. And then if you need to do any redirect on it, of course, feel free.
I don't believe I've officially moved for the admission of Miss Wheeler's. Okay.
Very good.
Okay, I move for the admission of Miss Wheeler's pre-filed testimony consisting of 31 pages and 2 exhibits.
Any objection?
None besides those that have already been outlined.
Noted. The reference testimony will be admitted into the record.
Okay, we tender the witness.
All right, Mr. Marsh, the witness is yours.
Thank you. Good afternoon, Ms. Wheeler.
Good afternoon.
All right, kind of the same thing as Mr. Wintgen, was just dive right into questions. When was GSI hired to become involved with this project?
It was in August of 2023. Daylight Petroleum contacted us and notified us of the issue at hand with the water coming into the building.
Okay. What was the purpose of GSI being hired by Daylight?
To assist in finding the source.
What would you say that GSI's main role has been in this matter?
We've acted as their environmental consultant, provided guidance when it comes to groundwater contamination, fate and transport, migration of the chloride.
And I believe on page 6, lines 9 through 10 of your testimony, you say that GSI is in the business of monitoring groundwater impacts and performing necessary remediation. Is that correct?
That is correct.
Okay. Does GSI routinely advise or consult in locating abandoned well locations?
We have before.
But do they routinely?
I would not say it's one of our top services, no.
Okay. On page 2, lines 19 through 20, you state that Daylight immediately reported the situation to the KCC, correct?
Yes.
Were you there whenever this breakout occurred?
I was not.
So how can you say that Daylight immediately contacted the KCC if you weren't there?
In review of field notes and conversations with Daylight.
Okay, so your testimony is based off of what you were told by Daylight?
Yes, and we also had meetings with the KCC where those field notes were shown on the screen.
Okay, but you weren't there personally?
I was not.
On page 3, lines 1 through 2, you testify that neither Daylight nor the KCC has been able to locate any records indicating an abandoned wellbore exists below the building, correct?
Correct.
Did GSI look for any records?
We did. We
Okay,
searched the KGS, the WWC5 water well record. We searched the KGS website as well. We reached out to KGS themselves to know if there was any other location we should be checking.
Okay. On page 3, lines 3 through 4, you testify that there is no evidence of any kind indicating what the source of fluid beneath the commercial building was, correct?
Correct.
But didn't the injection test show that the source of the breakout was the injection into the Olmhausen Farms number 6 well?
The injection of the brine was causing the water to surface. But as far as a source, where the source is located, is it beneath the building? Is it not? That was not determined.
Okay. How much experience do you have with oil and gas wells?
My oil and gas experience deals predominantly with the contamination for the oil and gas industry and their processes. Hydrocarbons or chlorides impact surface soils, subsurface soils, groundwater, even surface waters. So it's definitely on the environmental impact side.
Okay. Do you have experience locating abandoned wells?
When we do phase 1 due diligence, environmental site assessments, it's part of an ASTM standard that we do look for. And sometimes we do use the GPR or metal detectors.
Okay. On page 3, lines 6 through 7, you testify that KCC staff has steadfastly insisted that the commercial building be torn down in order to determine whether or not a well exists beneath the building, correct?
Yes.
I think you also later stated or testified that KCC staff has insisted from the outset of the situation that the commercial building will eventually need to be torn down. Is that correct?
Yes, that is in context to the fact that the experts have informed us that in order to plug the well to go through the floor, it would destroy the floor. And if we were responsible for replacing the building back to pre-investigation standards, it would have to be torn down and rebuilt.
Okay. Well, and you previously stated or testified that GSI has not been involved in this matter from the outset, correct?
Can you clarify what outset?
Well, whenever this first happened, because this first happened in what, June 2023, and GSI wasn't brought in until a couple of months later. So GSI has not been involved from the outset of the breakout occurring, correct?
We were not on site when it happened, but they did notify us shortly after.
Okay. Can you point to any communication from KCC staff that says that the building needs to be torn down?
I cannot, no. It's just in the context as previously stated that they've repeatedly stated that the well needs to be plugged. And in my understanding, in order to plug the well that they state is beneath the building, the floor would need to be removed, which could damage the building and cause it to be torn down.
Were you here previously for all the testimony that was provided by staff?
I was.
Okay. So you were able to listen in and staff said that they didn't think the building needed to be torn down?
I did hear that, yes.
Okay. And that their intent was for try to avoid the building being torn down?
Yes.
So if that's the case, then how can you testify that staff has steadfastly insisted that the building needs to be torn down?
Because I made that statement before they said that today.
Okay. So that statement is really Daylight's position and not staff's.
Not staff's, not your KCC staff, or
KCC staff.
under the understanding that they had reached out to experts and discussed how they would have to cut through the floor and being told that the floor would be unrepairable.
Did you reach out to those experts?
I did not, no.
Okay. If the purpose of GSI's involvement was to monitor, groundwater pollution or impact, then why would GSI have been involved in conversations regarding the status of the building?
We had internal meetings and it just came up upon discussion. They weren't segregated out with Daylight Petroleum. I do want to say, I don't know if the date I mentioned earlier was correct. I believe I got my dates confused. The August date was the date we had the meeting with the K.S.A. Daylight Petroleum did call me shortly after the release had occurred, but I don't have that date on hand right now. Sorry.
So you said internal conversations, those internal conversations did not involve K.S.A. staff, correct?
I do not believe so, no, about tearing down the building, no.
Okay. On page 3, lines 9 through 10, you testify that you and your superiors strongly disagree with the approach of K.S.A., correct?
Can I look that up? Or could you
Yep.
share your screen just to get the,
I can. Just give me a moment. Page 3, lines 9 through 10. It says GSI Engineering LLC has been advising Daylight throughout this process, and both myself and my superiors strongly disagree with the approach K.S.A. is taking with respect to the situation. Did I read that correctly?
yes, that's in reference to not really negotiating or thinking outside the box. It was just reiterated repeatedly that the well needed to be plugged. The well needed to be plugged without proof that it was a well, in fact, a well beneath the building.
Why did your superiors not submit any testimony to that effect?
They were not asked to.
You talk about that disagreeing with staff as far as thinking outside the box. Staff allowed GSI to conduct a GPR scan on the building, correct?
Correct. After it was proposed by Daylight.
And allowed them to hydrovac underneath the building?
Correct.
And allowed them to research other methods that might allow the well to be located?
Yes.
So how does that not constitute thinking outside the box?
Because ultimately, when those did not identify an actual well beneath the building, the statement was that the well still needed to be plugged.
Okay. Would you say that staff has more experience in locating abandoned wells than GSI?
Can't really speak for everybody at GSI or all of K.S.A. staffs.
Would you say the K.S.A. deals with abandoned wells on a more consistent basis than GSI?
Yes.
Okay. On page 3, line 22, you testify that further investigation will be necessary by K.S.A. staff to determine if, in fact, the source of fluid is an abandoned well. Correct?
Correct.
And this situation was originally or initially called in as a potential breakout well, correct?
I cannot say. Don't have that.
Bear with me for a second. I'm pulling up what's been previously admitted as Exhibit LB-1. It states in the remarks, on June 6, 2023, Daylight Petroleum reported to the K.S.A. District Number 3 office that a possible abandoned well had broke out and was leaking fluids inside the commercial building located at 147-350-410 Road, Neodesha, Kansas. 66757 in parentheses, picture number 1. Did I read that correctly?
Yes.
When was the ground penetrating radar survey conducted by GSI?
In September of 2023.
Okay. And that survey did identify an area of higher saturation, correct?
Correct. And also identified a very large rectangular anomaly as well.
Any knowledge what that rectangle, or was there any analysis done as to what that rectangular anomaly was?
There's a lot of, as you can imagine, heavy equipment metal in the building, and as in addition to the heating coils in the floor, it could not be determined from the readings of the GPR what that was. Our GPR operator asked staff and the building owner, I'm not exactly sure, I believe it was the building owner, if he had any idea of what it could be, and he did not.
Okay. And then did GSI conduct the magnetic survey?
We did not.
Okay. Do you know who did conduct the magnetic survey?
I do not.
Have you seen the results of the magnetic survey?
I have not.
Okay. Do you know when the magnetic survey was conducted?
You would have to ask Art. I'm not
Okay.
aware.
That's fine. Even after the GPR test was conducted, you still determined that the cause of the leak was a blowout well, correct?
We were not sure what the cause of the leak was. There's a couple potential.
Share my screen for a second. Okay, this is a GSI engineering, looks like a memo dated December 29th, 2023. Highlighted as Exhibit A, correct?
Yes.
Are you familiar with this exhibit?
Yes.
I'm going to scroll down to page 9 of the exhibit in the paragraph. About the third or fourth line down, it says, due to the relatively low levels of chloride concentrations identified during this investigation, it is unlikely that the known release at the blowout well is impacting groundwater from within the table 1 interval. Did I read that correctly?
You did. I just want to clarify that a blowout well does not mean an abandoned oil and gas well.
What does it mean then?
There's other potentials we've discussed internally. Oil industry practices was pretty standard to do core hole investigations. Sometimes those holes were drilled to depths of approximately 500 feet. There was seismic holes drilled. Water wells, if somebody was interested in installing a water well for domestic use or livestock. Irrigation, there's exploratory lithology holes that were drilled, or potentially an old abandoned water well that was not plugged properly. So I guess that's our summary of a possible blowout well.
Okay, so it is a well of some sort then.
Potentially.
Well, but the things you listed, they were all wells, correct?
Core hole would not be a well.
Okay, but still a hole in the ground.
Correct.
Okay. So how's that different than a well bore, other than it just has a different name?
The construction would be different. Casing.
But still, it's a vertical line down into the ground, correct?
It is a vertical hole in the ground, yes.
On page 4, lines 2 through 20, you testified that it would be economic waste for Daylight to be required to locate and plug the well, correct?
Correct.
What is your knowledge of economic waste?
Again, this was stated in reference after discussion that if the well were to have to be plugged, if there was in fact a well beneath the building and it would have to be plugged, the floor of the building would have to be removed, and the cost of that to replace it would be significant, whereas monitoring groundwater would be more practical and money saving, not necessarily money saving, but efficient way to determine if this breakout is in fact impacting groundwater.
Are you familiar with the statutory definition of economic waste?
What was provided in Mr. Hoffman's testimony is what I have.
Okay. Is there anything in that definition that indicates an abandoned well of any sort is that locating and plugging a abandoned well of any sort is economic waste?
I would not be familiar enough with that statute to respond to
Okay.
that. That would probably be better for Art.
Well, since I got you here. This says 2024 Kansas statutes 55-702, correct?
Correct.
Okay. And on the second line, it says economic waste shall mean the use of natural gas in any manner or process except for efficient light, fuel, carbon black manufacturing and repressuring, or for chemical or other processes by which such gas is efficiently converted into a solid or liquid substance. Did I read that correctly?
I'm gonna object, Mr. Chairman. I think we should brief the statutory interpretation of waste. I don't think that's an appropriate subject for the witnesses to be cross-examined about.
Well, Ms. Wheeler's direct testimony, her testimony talks about that it's economic waste. Believe I'm allowed to ask her about the definition of economic waste.
Yeah, we can read what her testimony is, but I tend to agree that the application of that statute is a legal question, and I think it's probably better addressed in briefing than eliciting different witnesses' understandings of it. Unless you can establish that they have particular skill and knowledge in addressing those standards. I mean, I understand why the director of our conservation division might testify as to how he applies those standards, but I think that it's better to address that by briefing for the other witnesses.
And that's fine. It's just they brought it up in their testimony. So if they were going to say that something's economic waste, I think we should have the ability to ask them questions about that.
I'm going to sustain the objection.
Okay. Thank you, Chair French. On page 5, line 5 of your testimony, you state that the groundwater is already impacted with chlorides, correct?
Correct.
Do you have any data or samples that were taken from this lease before the breakout occurred?
We do not.
Okay. On page 6, line 21 through 22, you testify that based on the data collected from the monitoring wells, it does not appear that the release which occurred beneath the building is impacting groundwater, correct?
Correct.
However, on page 7, lines 8 through 11, you testify that based on the data gathered to date, it cannot be determined where the chloride concentrations in groundwater are from, correct?
Correct.
And later on page 7, line 12 through 13, you testified that not enough data, or that there is not enough data to establish a trend or decipher a source area, correct?
That is correct.
The monitoring wells that were installed on the property were around 200 feet apart from each other?
K.S.A. had instructed us that they needed to be installed 150 feet from the breakout location.
Okay.
The pit, I believe.
So
Cardinal direction.
And that was just a rough guesstimate, right? They weren't all placed 150 or 50 feet from the breakout.
As close to it as we could. That didn't impact his business. We didn't want to put one right in the driveway.
Okay. And I believe in your testimony, you talk about PDMW-3 being up gradient from the breakout, and correct?
It is in an up gradient direction, yes.
Okay. And so PMW-2 would be down gradient from the breakout, correct?
It could be at times. That's an issue with these wells is they're not screened properly in order for us to survey them in and get a groundwater flow direction. So at times, yes, I'm sure groundwater does run predominantly south, but there's times likely when the river is full that groundwater would have groundwater reversal impacts. And so, yes, southwest, I believe, would be the most predominant groundwater flow direction in this area.
The most recent chloride concentration of the up gradient PMW-3 well is 69.5 milligrams per liter, correct?
Yes, from the December 2024 sampling event. That's correct.
I'll go ahead and bring it up. so that we have it in front of us. Chair French, I guess I'll go ahead and ask that this be admitted to the record as KCC-2.
I don't believe there'll be any objection, but Mr. Brock, any objection?
No, I thought you had named the staff's objections as KCC-2 though.
I thought it was
Uh,
Commission 1 and Commission 2.
Yeah, Commission 1 and
okay.
Commission 2 for the objections.
Okay, I apologize. I just wanted to make sure we didn't have the same name. No objection to the admission.
So this is, Mr. Marsh, you said staff 2?
KCC-2.
Okay, KCC. Is it already marked? Because labeling it KCC is going to conflict with commission. Can it be KCC staff 2?
Yeah, that's fine. I'd already sent one exhibit to John and Keith, and I had it as KCC-1, so we may need to adjust that to like KCC-2.
Oh, let's just go forward as KCC 2. That's fine. I think we'll be able to tell the difference.
Yeah, that's the only reason why or the method behind my madness, I guess you could.
All right, if we've already got KCC 1, then let's go ahead and we'll admit this as KCC 2.
Okay. Ms. Wheeler, the upgradient well had a chloride level of 69.5, correct?
Yes, PMW3 had that concentration this last event.
And the downgradient well had a chloride level, most recently had a chloride level of 2,400 or 2,440 milligrams per liter, correct?
Again, and just to clarify, the well south of the building, PMW2, yes. However, due to not having a groundwater flow direction from surveyed in, I wouldn't want to state that is in fact downgradient.
Well, if one well is upgradient, when it makes sense that the well opposite of that one is downgradient.
PMW3 could also be considered upgradient as well, depending on the time of year. We don't have enough data yet to determine seasonal groundwater fluctuations.
So you don't have enough data yet, but you can say that pollution is not occurring?
We can say that pollution is likely not occurring due to the release beneath the building.
So why is a well that's 300 feet away have a chloride level that's 35 times higher than another well?
As stated in my testimony, the KGS bulletin was referred to. It's important, it's standard industry practice to use those bulletins when you are attempting to characterize a site, which you don't have any existing site data. It's really important to take those bulletins in full and to not remove outliers. They are hard facts. They are laboratory samples. They are a wealth of knowledge for lithology and groundwater quality, groundwater usage, but they're basically a list of what could be encountered, and that bulletin does document that there are elevated concentrations of chloride in these formations that we have our wells screened in. So while PMW2 does have the highest concentration of the 4 wells on site, it is also important to note it has the shallowest or the shortest screen interval. And of that screen interval, it is the one that is screened within the Dennis limestone, which is known to have elevated chloride concentrations.
Okay, we'll get to that in a second. On page 9, line 21 through 23, you testified that the groundwater concentrations identified in the 4 monitoring wells are only slightly above the concentrations documented in the 1960s by the Kansas Geological Survey, correct?
Correct.
And I think on page 11, line 6 through 7, you say that the chloride concentrations in these groundwater samples ranged from 40 parts per million to 1,250 parts per million, correct?
Did you say 40 parts per million?
Yes.
Okay, yes.
I'm going to bring up what's previously been marked as Exhibit JS-4. This is a table of the samples that were taken as part of that 1966 KGS Bulletin 183, correct?
Yes, that's correct.
Okay. Julie has done us the favor of highlighting the chloride levels. Do you see those highlighted in yellow?
Yes, I do.
Okay. The top one for the Chinook shell shows a chloride level of 24 parts per million, correct?
Yes, it does.
So that's below 40, isn't it?
It is.
And if I just go down the line counting, 10 of the 16 samples have a chloride level below 40 parts per million, correct?
You are correct.
So a majority of the samples have below the range that you have outlined in your testimony, correct?
I would have to go back to my testimony. Did I specifically state a certain member? Or was it within the bulletin itself that it states that?
Says chloride concentrations naturally occurring in these groundwater samples range from 40 parts per million to 1,250 parts per million. Did I read that correctly?
Yeah.
So the testimony that you provided is inaccurate in that regard, correct?
Unless it states it somewhere within the bulletin that I'm not recalling, that they do range from 40 to 1250. It would look like an oversight on my part, yes.
Okay. Now I believe Julie's testimony had the chloride concentration or basically look at the median concentration. Why did you not look at the median concentration compared to the concentrations taken from the samples at this lease?
I mean, even on our side alone, we do have a few outliers. So it's important to take in all the data and compare it. If we just start taking out data that doesn't make sense or is outliers, then we're just manipulating it to how we want it to look. She also compared the concentrations to hundreds of samples that she had collected, but she included rivers, streams, creeks, ponds, and hand dug wells, and those two cannot be compared.
Okay. I'm going to bring up what's been previously admitted as Exhibit JS5. This is the AGS bulletin for groundwater resources, source occurrence, movement of groundwater, correct?
Yes.
And if you scroll down to sanitary considerations, it says the analysis of water given in table 1 indicate only the amount of dissolved mineral matter in the water and do not show the bacteriological content of the water. However, high concentrations of certain constituents such as nitrates or chlorides may indicate pollution of the water. Did I read that correctly?
You did, and that can be relayed to our site here. The chloride concentrations we're seeing in groundwater at our site could be due to oil and gas past historical uses in industries from surface to groundwater.
It could also be due to the recent breakout, correct?
The breakout from directly beneath the building currently is the only breakout that we know is occurring, and I do not believe that the breakout beneath the building is impacting the monitoring wells, the groundwater samples collected from the monitoring wells.
Well, if it can be historical, it can also be recent events, correct?
Not if we're talking from surface to groundwater. It could take years for surface contamination to get down to groundwater unless there is some direct pathway from the surface to that monitoring well.
And if this hole doesn't have integrity, then it could be coming directly. It wouldn't necessarily be coming from the surface, would it?
We don't know that this hole doesn't have integrity, but if it did not, I would expect groundwater concentrations to be higher than what we are seeing.
Okay. Do you have a number?
I do not have a number. There's just too many different parameters that we'd have to take in consideration. We don't know where at in table 1, the release the figurative release is occurring. We don't know what zone and the permeability of that zone.
You were here for Julie's testimony earlier, correct?
Yes, I was.
And I guess GSI also conducted geoprobe or a geoprobe or at this lease, or conducted a geoprobe. I'm sorry, I'm not wording it right, but put a geoprobe into the ground that wasn't able to go further down than 10 to 12 feet, correct?
Yes, it's standard industry practice that when you're trying to identify a source, you want to start with the shallowest water bearing zone first. And that was our ultimate goal, was to identify what's in that first water bearing zone. So we did utilize a geoprobe.
And so you're aware, like you're familiar with Julie's testimony, that there's a layer 10 to 12 feet down that prevents or would prevent surface contamination from going further down to table 1, correct?
I did read that in her testimony, yes.
On page 9, lines 15 through 18 of your testimony, you state that if chloride concentrations between 41,000 and 44,000 parts per million were flowing to the table 1 interval, the chloride levels would be several times higher than what we were seeing. I think you reiterated that here just now as well. The range of chloride concentrations was 41,000 to 45,000 parts per million, correct?
From the 1004 injection well to the pit. That is correct.
Okay, so your testimony is inaccurate and should say 45,000 parts per million instead of 44,000 parts per million.
Yes,
correct?
that's correct. Yep.
When the chlorides are dropping down by approximately 4,000 parts per million, isn't that some sort of indication of dilution occurring?
Not necessarily. In this instance, the sample that was taken at Olenhausen 4, it's just one of the producing wells. The water that's injected at Olenhausen 6 is actually a composite of all producing wells. They injected that well, so there's going to be a variation in those concentrations. Also, the water was then injected to the producing formation and mixed in with brine that was already there. But we would see the same type of variation if we were to have a frac tank on site and we had brine water from each producing well, and we sampled those frac tanks at 3 different depth intervals because chloride does sink. We would expect to see variation in those frac tanks as well. So I don't agree that the reduction in 45,000 ppm to 41,000 parts per million is indicative of 100% surety that there is interaction in table 1 with fresh water.
Could it?
There is the potential, yes.
Okay. Kind of circling back a little bit, you talk about, you would anticipate the chloride levels being much higher. Would a core hole or water well or, any other sort of exploratory hole that you talk about be cemented in a manner that would protect fresh and usable water?
A water well would not. No, I can't tell you how they would have plugged those, especially if there's no record of them.
Okay, and since the well hasn't been found or located yet, there hasn't been any way to do any downhole testing to see what the integrity of that well looks like, correct?
Correct.
Okay. And I know that I think both your and Mr. Benjamin's testimony, you talk about how this could be due to faulting, correct?
That was Mr. Benjamin.
Okay. But then you also include that as a possibility in your testimony?
Mentioned faulting or potential seeps.
You did prepare a cross-section based off of these monitoring wells, correct?
Yes, I had 2.
And they were contained in your testimony?
Yes.
I think it says Exhibit B. I'm going to pull that up. And this is a cross-section of A to A hyphen. Has a line there.
Yep.
Does the cross-section outline any faults?
It does not.
Okay. And then I guess that's another zoomed of it. For cross section B through B hyphen, are there any faults in that cross section?
There are not.
On page 10, lines 1 through 4, you testify that fresh and usable groundwater becomes impacted from oil and gas activities in two ways. From one, top to bottom, or two, bottom to top, correct?
Correct.
So hypothetically, what if there's a wellbore that doesn't have integrity? Couldn't fluids migrate outwards or inwards from that wellbore?
Could what migrate outwards?
Produce fluids?
It could, but it would first have to come from the producing formation from below. So that would be bottom up.
On page 10, lines 17 through 19, you testified that contamination likely occurred many years ago when poor industry practices were common, such as evaporation pits, surface release of produced water, inadequate well completion techniques, and poor drilling practices, correct?
Yes. There's
Have
actually,
you,
go ahead.
oh, sorry. Is there anything else?
There's actually a document written by Don Whittemore that goes over this is a well-known common occurrence, talks about oil field and brine disposal at the surface. And it talks about how it can take decades to travel through confining layers such as shale and bedrock.
Okay. Have you reviewed historical aerial images of this area?
What was available on Google Earth, which wasn't a whole lot. I was not able to find that 1977 or 1958 aerial other than what they had provided anywhere.
Did you find any evaporation pits in those images?
I did see the dark shadowing that they had circled on the 1977 aerial. And then there was another darker area, but I can't say if they were for certain 100% evaporation pits.
Did you see any surface scarring or surface damage?
Just those dark scarred shaded areas. But this industry has been in operation since the late 1800s and early 1900s. So there is the potential that there was no historical aerials available to document such sources.
Have you reviewed well completion records for this area?
I have.
Okay. Is there anything in those well records that indicates that the well completions were inadequate?
For the ones that are available, I wouldn't say so. There's not very many out there. We did look for some domestic wells nearby. Just wasn't a lot to go off of.
Did you review rainfall records for this area?
I did, and stream flow as well.
Okay. Why'd you not include those records in your testimony?
They didn't really, I mean, they're available to everybody, and we all know that K.S.A. the site is located right adjacent to the river, so flooding is common in the area.
Okay. On page 13, lines 9 through 13, you state that the KGS bulletin for Neosho County water containing 250 parts per million of chloride is acceptable for municipal supplies and satisfactory for most purposes. Water containing around 500 parts per million chloride begins to develop a salty taste, and water with chloride concentrations as high as 4,000 to 5,000 parts per million can be used for livestock purposes, correct?
Yes.
I'm going to go back to Exhibit JS5, wherever I put it. And that's taken from, I've pulled up Exhibit JS-5, page 3 of 7. This is where you took that information from, correct?
Yes.
And it says chloride salts are very abundant in nature. Water containing less than 250 parts per million of chloride is satisfactory for most purposes. Water containing more than 250 parts per million usually is objectionable. for municipal supplies, while water containing more than 350 parts per million can be unfit even for irrigation and industrial use. Water with as much as 500 parts per million chloride has a salty taste. Did I read that correctly?
Yes.
So why did you not include the portion about water containing more than 350 parts per million being unfit for irrigation and industrial use?
It's pretty subjective. There's different crops that can take on more chloride than 350. I didn't feel like it gave a good enough representation.
Didn't you previously testify though that it's important to take the bulletin in full?
Yes,
So why did you not take it in full in this instance?
I should have provided the other source that states that some crops can take more than that.
Okay. On page 14, line 6 through 7, you state that the monitoring wells in this docket were not designed in accordance with industry best practices, correct?
Yes,
I think on page 18 of your testimony, you discussed the screen lengths in the monitoring wells and the issues with screen lengths. Is that correct?
I believe so.
Okay. I'm going to pull up exhibit. I think it's KW1. And that's the GSI report dated December 29th, 2023. This is your signature, correct?
Yeah.
Okay. Is there anywhere in this report where you state that these wells were not installed using best industry standards?
No, but we do go into detail about the lithology that they were screened in.
Okay.
Yep.
I believe that you talk about some of the screening and the deviation from work plan, correct?
Yes, that's correct.
Is there anywhere in that deviation where you indicate that or state that there will be predictably high levels of chlorides based off the screen levels?
No, at that time when we wrote this, we had sampled at multiple depth intervals using hydrosleeves. So the results would be more indicative of what was actually moving through the screen interval at the depth of those samples where they were collected.
Okay. And in the general summary of sampling documentation, there's nothing that says, hey, this well wasn't constructed using industry best practices, or the length of screen is going to cause a predictably high result, correct?
No, we justify why we screened PMW2 the way we did. It was the first well we drilled, and we did not encounter groundwater until approximately 4 feet before 140. Standard practice is to not have the entire water column, entire screen interval that large if you don't have water coming in. Why screen intervals that will not produce groundwater? But we wanted to follow as closely as we could to the work plan. So the next 2 wells do have that 90-foot of screen that was approved by K.S.A. And then it was requested by K.S.A. staff on site that we do screen PMW4 with the longer screen interval.
Okay. And that was an email from Julie Schaefer, correct?
She was on site at the time when that decision was made.
Okay.
With our geologist drilling the wells.
Was staff on site whenever the wells were, when GSI began drilling the monitoring wells?
I'm not exactly sure what time she showed up, but she was on site during the monitoring well installation.
And I think on page 14, you attached an abstract from a study completed by Peter Church and Gregory Granado to your testimony, correct?
Correct.
You did not attach the study in its entirety to your testimony, correct?
I thought I did. I probably just downloaded what was available off of the internet.
Okay. Is there anywhere in that abstract that indicates how long footages need to be for a screen interval to be adequate?
Without going back and reading through it, I can't say. It's pretty a standard practice depending on the contamination. You can determine, how much footage should you have above the water table. What area of Kansas are you drilling in? Is the water table likely to drop. Our Southwest Kansas wells will probably have a little bit more screen than normal. Is your contaminant a floater or a sinker? Do you need to have the water table intersected with screen above and below? Those kinds of things would all be taken into consideration.
I'm going to be bringing up what's been identified as Exhibit KCC-1. This letter says notice of violation across the top and is dated November 1, 2023, correct?
Yes.
And in this letter, staff gives its recommendations for the monitoring wells, correct?
Correct.
Is there anywhere in these recommendations that discuss the screen lengths?
It does state that the total depth, can't be deeper than 140, and the entirety of table 1 should be evaluated.
Okay.
But definitive screen intervals, no. But our groundwater our work plan, our monitoring well installation work plan did state that we would have 90-foot screen intervals with sampling at 3 intervals.
And if I scroll up to page 1 of 3 into page 2 of 3 of Mr. Russell's letter, it says, I also requested in my response that Daylight develop a monitoring well construction proposal to be submitted to district staff. Did I read that correctly?
Yes.
Kelsey, would you agree with me that plugging an abandoned well better protects fresh and usable water than not plugging an abandoned well?
I would have to see site conditions. This site in particular, I do believe the stopping of injection or even plugging of Olenhausen 6 eliminates a lot of the potential contamination with the monitoring well program in place.
Do you not on page 26, line 3 of your testimony state that if an oil production well is properly plugged, it should not pose a threat to groundwater?
I do.
Would you agree with me that it's better to protect fresh and usable water before it becomes polluted?
Yes.
How long is GSI committed to monitoring these wells?
As long as the client requests it from us.
So if the client leaves Kansas and no longer requests these wells to be monitored, GSI is not going to go out on its own to monitor these wells, correct?
That is correct.
Okay. The last thing I have is on page, I know it's part of your recommendations as well, but page 8, lines 6 through 8, you testified that Daylight could be directed to enter this site into the voluntary cleanup and property redevelopment program administered by KDHE, correct?
Yes, that's correct.
Okay, and you previously worked with KDHE, correct?
Correct, in the voluntary cleanup program.
Right. Are you familiar with that KDHE or that KCC matters are prohibited from being part of this project or being part of that program?
No, I was in charge of and responsible for reviewing eligibility on multiple projects, but I also currently have the former unit chief of the voluntary cleanup program working as my employee, as well as the BER, Bureau of Environmental Remediation director, currently working in our office. And there's been other sites entered into the VCP that have memorandum of agreements or exceptions with both agency of authority and agreement. The main goal of entering this site into the voluntary cleanup program is that it would then be eligible for an environmental use control to be put on the deed. And within that environmental use control, it was the idea, and I do believe we had brought this up at a meeting with KCC staff before, is the environmental use control is placed on the deed, and so it doesn't transfer from owner to owner. And with agreement between KCC and potentially KDHE, there could be a written restriction for injection within a certain area of this well or breakout.
I'm going to bring up exhibit RH3, page 1 of 3, and then kind of goes on to page 2 of 3. It says properties that are not eligible to participate in the VCPRP may have been contaminated by oil and gas activities regulated by the Kansas Corporation Commission. Did I read that correctly?
Yeah, so historically, the agreement is that if there's an operating lease, KCC is the jurisdictional authority. However, like I mentioned, there's been instances that if it's better for human health, environment, or cost efficiencies, there has been outside of the box thinking that I believe the bureau director would be open to.
I'm pulling up K.S.A. 74-623. This statute states that the State Corporation Commission shall have the exclusive jurisdiction and authority to regulate oil and gas activities, correct?
It does state that, yes.
And
Again,
that
this is an out of the box proposal, something that benefits both sides. Obviously, both parties want to protect groundwater, and we're running out of options as to what we can do to do that. And we to date have not identified a well beneath the building. So just trying to pass along ideas and proposals.
how does monitoring pollution prevent pollution from occurring?
Monitoring pollution, obviously, you have to have pollution, correct, to monitor it. Nobody's expecting for these monitoring wells to have 0 parts per million chloride. We all know it's a naturally occurring. But what these wells would tell us that would allow us to protect groundwater is if concentrations do increase, if a slug of contamination is washed out from surface to depth, or should another source become evident in the future, the monitoring wells would show us that, and we would be able to remediate that potentially at that time.
Thank you. I don't have any other questions.
All right. Let's move on to commissioner questions at this point. I see Commissioner Keen has returned. Glad to see you were able to rejoin us, Commissioner. Commissioner Keen, do you have any questions for this witness?
I have no questions. Thank you.
And Commissioner Keither?
No question, thanks.
Oh, I've got to ask something. The only thing I think I want to ask, so you've got different avenues of what you've testified on. You've obviously testified on a lot of the sampling results and interpretation of that, and but you've also testified on your opinions of economic waste and the potential existence of an abandoned well. And there definitely was some testimony that you presented in your written testimony that caught my eye. And I'll cut to the chase, and I'm not going to dwell on it, but I think you have a statement essentially saying, if I can find it, well, it's on page 3, line 11. You say there is absolutely no evidence an abandoned well exists beneath the commercial building. So we've heard a lot of testimony about that today. I think you probably heard Mr. Troy Russell testify that if he had to ballpark it, he'd put it at about 90% that's where this is coming from, based on sort of a variety of factors that they've looked at. Is it still your opinion that there is no evidence that there is an abandoned well underneath the commercial building?
I'd say that's in reference to documentation. There was documentation of, forgive me if I get these numbers wrong, but the Johnson 106 and the 107, and there was documentation and evidence that those did exist. They were found after searching for them. There's records of them. They were known, but to date there is no hard documented written documentation that states that there is for sure a abandoned well beneath the building.
Okay. So I guess you're drawing the distinction that we do not know because we have not actually observed it yet, we cannot say 100% that it is there. But it might not be your position that there is no evidence that would indicate that it would be there.
That's correct. That's
Okay.
a good way to put that.
If you were to look at all the evidence we have, whether it's circumstantial, it's data, would you say it's more likely than not that that is the source of the fluids that we're seeing?
I mean, there's definitely a communication pathway. What that pathway is exactly, I don't know. I do think additional testing would be beneficial to show, is there increasing trends?
We've talked about that there are other hypothetical possible sources. Do you think they all have equal chance of being the source, or would you say some are more likely than others in this particular area?
Due to on-site conditions, I think some are more likely than others.
And would an abandoned well probably be culprit number one if you had to ballpark it, understanding that it has not been observed?
Some form of abandoned vertical hole, yes.
All right, I will leave it there. Okay, if there are no additional commissioner questions at this time, we will move on. Mr. Brock, do you have any redirect?
Yes, thank you. So I'm going to go ahead and share my screen. Can you see this?
Yes. Sorry if I have to get really close to my camera, guys, but it's small.
Is it zoomed out or I mean, is there something I need to do on my end to make it bigger?
No, I'll just get close. That's fine.
Okay. So this is what was marked KCC-2. Can you identify what this is?
Yeah, it's our most recent groundwater monitoring report from December 2024 sampling.
Gonna just scroll down. I'll try to zoom in.
Okay.
Is that visible on your good? Okay. And so is this basically showing the chloride readings from all of the various samples?
That's correct.
Can you just walk me through what the most recent quarterly sampling shows, just well by well, and I'll highlight it and you can just kind of explain what you see with it?
Sure. So the top four are those geoprobe locations that we talked about. PMW1, we sampled December 12th. When we arrived on site, standard practice is to take static water level, and that will tell you how much water that needs to be removed from the well. You can do the calculations. So groundwater was measured at 45.6 feet below ground surface, and the chloride concentration for the sample collected at 139 feet was 821, which is a significant decrease from the previous event.
The most recent sample was a significant decrease?
Yes, from the September event.
Moving down to PMW2, I've highlighted the most recent.
So PMW2 is the well to the south of the building. It's the well that has the shortest screen interval. It's the well that when we do remove the 3 times the well volume, it often almost goes dry, showing that there's not a lot of permeability in the lithologic layers. The volume of groundwater is low, and it's just not moving very quickly. So oftentimes when we purge this well, we will have to go to another well and allow it some time to recharge. But you can see that the depth to groundwater was 2 feet deeper than September, and concentrations increased only slightly.
And so I guess just to clarify, in your direct testimony, you identified a correlation between the depth of groundwater and then the subsequent readings. Did the most recent samples appear to confirm?
They do.
refute?
I mean, we can see in this well, because it is the well with the least amount of water available. The less of volume of water available in the well, the higher the concentrations seem to be going.
And I know you explained it in your direct testimony, but why is that well, in your opinion, higher than the rest?
Again, it's got the least amount of screen interval, so it's allowing water to only come from the formations that it's screened in. We don't know what formations those are. With these long screen wells, the groundwater that is entering the well could only be from the Winterset, the Dennis limestone, which is where a lot of the naturally occurring chlorides is found. It could be that it's coming into the well from the bottom and going up. And with chloride being heavier than water, they will sink to the bottom. There's just not a lot of opportunity for any non-contaminated zone to enter this well, as opposed to, like, say, PMW4 that has the 130 feet of screen.
Okay, moving to the PMW, is there anything else you wanted to say about PMW2 before I move on?
No.
Moving on to the most recent sample of PMW3.
So groundwater dropped 10 feet in this well. Again, this well is located to the west of the building, between the river and the building itself. Groundwater has seen quite a bit of fluctuations with the depth here, but concentrations have remained relatively stable. The 262, as you can see, we did the stratigraphic sampling in the initial event in December 2023, where it shows that at 85 feet, chlorides were only at 60. However, at 139 feet, chlorides were at 262. This was also after the wells had been developed. You would develop a monitoring well after installation to clean out any kind of water that you had added during installation, to make sure that you are in fact sampling naturally occurring flowing groundwater within formations. So the depth to groundwater, it recharges well.
Then the final well.
PMW4 is the well to the east of the building. This one has, like I mentioned, the longest screen interval. You can see here during the initial event after development, we were able to do 3 different intervals because of the long screen. And you can see that contamination or higher concentrations were noted, in all 3, 25, 85, and 139 feet. Depth to groundwater from the last event is a whole 10 feet deeper, and groundwater concentration slightly decreased this past event.
Based on this last round of sampling, is there anything in it that causes you to question anything that you put in your additional pre-filed testimony?
No.
Based on this, is there anything in it that causes you to be concerned that fresh and usable water is being endangered?
Not at this time.
And just to be clear on the date, this report was issued on January the 6th. Is that 2025 instead of 2024?
That is correct. We were not quite in the habit of writing 2025 yet.
And so this would have been available to staff at the time they pre-filed their rebuttal testimony, correct?
Correct.
I'm going to stop the share. So a question was asked to you about something that Ms. Schaefer had included in her testimony about there being a layer that was 10 to 12 feet down that would have prevented surface contamination from migrating down to groundwater. Can you just respond to that? Is that a valid point? Is it not? Just what's your perspective on it?
We have several sites that directly disagree with that statement. We have sites across the state of Kansas, Nebraska, where we do see groundwater contamination does migrate through more competent lithology. In particular, I have a site in Latimer, Kansas. It's up near Harrington, where there is several layers of competent shale and limestone layers, and the contamination has been documented in all aquifers located in between those limestone and shale layers and within. So it's definitely a possibility that surface contamination does migrate through even more competent shale and limestones. We've seen it. We have a site in southwest Kansas where lithology may not be similar. However, the depth of traveling of the chloride contamination is significant. Over 130 feet chloride concentrations are I seen in groundwater. So no, I don't believe that just because we hit a sandstone at 10 to 12 feet, that contamination would not migrate through that eventually.
In response to the question earlier, you also referred to an article. I did not catch the name, but can you just elaborate on what you had said and what that article speaks to?
So Don Whittemore wrote it. He works at the KGS. He's well known to have plenty of chloride experience, and he documents that past disposal of oil filled and brine at the surface has caused substantial contamination to the state of Kansas water's resources, be it surface water, groundwater, etc. But he does have that statement in there that I think is important, where he states that the period of flushing, I may not get it exact, but the period of time it takes for the contamination to be flushed all the way from surface to groundwater, where you do have more competent lithology, shale and limestone bedrock, could take a better part of decades.
And so as it pertains to this site, what does that authority or paper or whatever it should be called, what does that tell you, or how does that help us to explain the site that we're working on here?
Well, this area is as documented in testimony, it's known to have been first utilized for oil and gas production in late 1800s and early 1900s. As we all know, we get better with age on our best management practices, and in the beginning there was little to none of how brine water was handled. We genuinely just don't know what was done with the wastewater, how it was handled, where it went. So differentiating between a potential breakout and historic oil gas industry practices is difficult.
And so in your pre-filed testimony, you had indicated that in your professional opinion, it was most likely that the chlorides we were seeing probably occurred from historic practices. Is that still your opinion after hearing all the evidence presented today?
It definitely is a possibility. The levels just are not very high. 2,000, 2,400, it's just not that elevated for what we see for contaminated sites, especially those impacted with the brine.
Can you speak to the volume of groundwater present and how that might impact the KCC's decision-making?
So this area is known to not have a whole lot of available water. The lithologic layers do not have high permeabilities. The groundwater does not flow very quickly through them. We see that, as I stated, when we go out and develop and purge the wells. We oftentimes have to go from well to well to well and allow them time to recharge so that we don't purge them dry. Use of this water in the future, you know, I can't attest to that, but it's not likely that it would be used for domestic purposes. There's just not a whole lot out there.
For this site, am I correct in saying that there was no, what I'm going to call baseline data collected to determine what the chloride concentrations were at the site before any known release occurred? Is that correct?
Correct. Yes.
And it appears to me that you and Miss Schaefer disagree upon what baseline should be used. Can you just elaborate on the differences in those two opinions and your thoughts on that?
We do have the documentation in the bulletin that there is elevated levels within these lithologic layers, the Cherryville or the Chinook shale and the Dennis limestone. It's known, it's documented, it's been written about, and it's just important to take that as a whole. And we see those outliers here on our site too, just showing that there's a lot of potentials. And honestly, we just need more data to evaluate what exactly we have, because we do not have that before the breakout sample.
And you had referred to Ms. Schaefer wanting to use what the KCC staff typically sees and the sources that she was basing those past experiences on. Can you please speak to that?
Yeah, but she refers to creeks and rivers and that they've collected hundreds of samples, and that's kind of her subjective baseline. But you can't really compare a surface water sample to a deep groundwater sample, especially when it's occurring in natural formations that do have elevated chlorides.
Would it be industry custom or common industry practice to apply an objective baseline or a subjective baseline?
An objective.
You had talked about it a little bit, that in Ms. Schaefer's testimony, she indicates that because the water sample taken from the Allen House number 4, I may have my number wrong, but it was one of the producers, was 45,000 ppm, and the water sample taken from the pit was 41,000 ppm, that reveals to her that has impacted fresh water. Can you, I know you had already distinguished the source and the commingling, but can you just address a little bit about variations, even within the Bartlesville itself? If you took samples from different wells, what is common?
Sure. I mean, similar, if we took different samples within the Bartlesville, top, intermediate, and deep, we would expect some kind of variation with chloride migrating downward. Similar to the frac tank example I gave, there's going to be some varying in the concentrations. The sample again was collected from one well and not the commingled mixed sample, and then it's injected into the producing formation. So 4,000 ppm is just not a lot of variation.
Would you expect to see that variation even within the Bartlesville itself?
Yes.
And so, in your opinion, is there any conclusion that can be reached by the fact that it's 4,000 ppm less in the monitoring pit than it was at the Allenhausen number 4?
I'm sorry, can you repeat that question?
I mean, based on the variations that's present, would you say that there are any conclusions that you can actually reach by the difference in the chloride contents?
No, not with the information that we have right now.
Based on these groundwater monitoring wells and the most recent round of samples, do you believe that fresh and usable water is being adequately protected by these wells?
When referencing the breakout beneath the building, the monitoring wells are providing points to monitor to evaluate the aquifer, but the building itself is preventing infiltration from that brine that was brought to the surface and entered into the pit and is found in the soils now. It's preventing infiltration down. It's going to prevent the rainwater from percolating through and taking that down with it. So with the building in place and the monitoring wells being monitored, yes.
So there's been some issue taken, essentially some points made about up gradient wells, down gradient wells, and you had indicated that there was no survey performed. But I just want to ask the question, in your direct testimony, isn't it true that these wells are not even screened in the same intervals? They don't encounter the same formations. Just elaborate on the differences and how that would affect the conclusions that have been drawn based on up gradient, down gradient in Ms. Schaefer's testimony.
So, there's always a regional groundwater flow direction that you can find from usually KGS bulletins, but for this site specifically, the wells, even the two that have the same screened interval, the PMW 1 north of the building does not intersect the Dennis limestone. The PMW 2 has significantly less screened interval, so you're not screening across the same groundwater bearing zones. We don't know exactly which zones groundwater is entering the well. So, there could be water coming in from below, coming up through the well. There could be water coming from the top of the well, down into the well. And we're not able to determine that. So even if we were to have the wells surveyed in, they would not provide the most accurate groundwater flow direction. And as I mentioned before, seasonal groundwater variation is highly likely at this site due to it being close to the river.
In Ms. Schaefer's testimony, she states that produced water was intercepted by 2 down gradient geoprobes. Do you agree with that statement?
I don't agree with that. The 2 geoprobes that we installed were to the the west of the building and the south of the building, and the other 2 were dry. And the water that we collected after allowing them to sit for, I think it was 48 hours, the water that we collected, had it been produced water, we would have seen higher concentrations than what we saw. I believe they were like 60 and I want to say 270. But if it was true produced water, the concentrations would have definitely been elevated.
And so just because I have the numbers in front of me, there were the samples taken from the geoprobes 71 and 260 part per million. Does that seem accurate?
Yes. Yep.
And the 2 samples we have of produced water are 41,000 and 45,000.
Correct.
Did you submit proposals concerning groundwater monitoring, design, things like that? Did you submit proposals to KCC staff?
We did not submit a proposal. I know we had called Ms. Schaefer and discussed, me and a staff member had discussed what exactly KCC was wanting from these monitoring events. Should we proceed with the 3 hydro sleeves or just 1 sample? And it was told to us that as long as we purged the well of 3 well volumes and had 1 sample, that's what would meet the requirements.
During your entire involvement with this, was there ever a situation where KCC staff asked you or Daylight to take some action in order to investigate the situation, remediate it, anything like that, that either you or Daylight refused?
Objection. That's outside of cross.
I'm asking about her experience with it.
Yeah, there's been several questions here that I'm having trouble relating how they related to cross. There's been several that are, opinion about written testimony, and then this one, I mean, Keith, if Mr. Brock, if you can tie it back to something specific, Mr. Marsh asked.
I thought he had went into a line of question at the beginning about staff allowing Daylight to do ground penetrating radar, staff allowing Daylight to do, I thought he went into a line of questioning about that. And so to me, I think it responds to that. Maybe I'm mixing the witnesses, but I thought he had asked Miss Wheeler that.
No, that is correct. Can you restate the question?
During your involvement, did you ever was there ever a situation that you observed where staff asked you or asked Daylight to take some action, either to search for a well or to remediate, and either you or Daylight refused to comply?
Yeah, that's outside of cross.
I'll allow it. I'll overrule the objection.
I cannot think of one, no.
Anything further, Mr. Brock?
I'm just looking at my notes really quick. I don't believe so, but I'm just shuffling my papers. I'm sorry.
Sorry, it's hard to tell when we don't get to look at you.
I know exactly. I believe that I'm done. I just want to take one last cruise through my notes to be sure. Yes, that's all. Thank you.
Are there any additional commissioner questions following that redirect? Commissioner King, did I see you waving your hand? Go ahead.
Thank you, Chair French. Ms. Winter, we've been wandering around and way down in the weeds for quite a while here. Some level of detail. I don't mean that as a pejorative reference, incidentally, but there's a level of detail. Let's go back up to about 30 to 50,000 feet. I've got two questions for you. The first is, and I was a little late to this, as you may know, because of another meeting I had to attend. What, in your opinion, is the origin or source of the oil and salt water that was found at the surface pooling near or next to the building?
The origin, I believe it's brine water in communication with the injection well.
Brine water, where did the oil come from?
The Bartlesville, more likely, or somewhere between the Bartlesville and the surface.
How did it make its way to the surface from the Bartlesville?
I think maybe you had missed this part. We talked about through a vertical hole in the ground, whether that be, an abandoned water well, domestic water well, stock water well, maybe an unplugged core hole that oil and gas industry had used long ago to document surface lithology, a potential seismic hole, or maybe even an exploratory hole utilized to identify if there were water-bearing zones for a water well.
How about an abandoned oil well?
Or potentially an abandoned oil well.
Yeah. All right. Here's another question for you. I'm kind of have to lean on your experience. I'm just a lay person. How do you explain the effect on this surface pooling by the operation of the number 6 injection well prior to its being shut in? There was obviously a reason why that number 6 well was shut in, and it was the thing that drew basically the attention of everybody. I think the operator, the landowner, the commission. How do you explain the effect that when the injection well was being used, that there was an action, there was a response that affected this pooling, as I understand it, next to this building? How do you explain that? What caused that?
There's definitely communication between the injection well and the breakout beneath the building. What exactly that communication exists about or contains, I don't know at this point. We saw when we shut down the injection well, the water stopped entering the pit. So there is obviously communication between those two. But what pathway is it taking? Can anybody be 100% sure? No.
Well, it strikes me that's one of the issues here. It's a big issue here.
I don't think we'll know until we find it.
Good point. So again, I'm not trying to belabor anything. How do you suggest we go about finding it?
I think that's where we were before this petition, what happened is we've done the GPR, we've done all the things that have been discussed earlier. I don't want to go back through and list everything again. And we're kind of out of ideas. We can continue to investigate and evaluate all potential resources and continue to evaluate possibilities. However, I think the NOV, and I don't want to speak for anybody else, it was just kind of you need to get the well plugged. When we had brought up the VCP before and potentially doing an EUC restricting pumping, it wasn't received very well. But I think, again, I don't want to speak too much for Daylight, but I do think they would be willing to exploring other potential possibilities. GPR, I'm not sure how effective that's going to be with all of the metal present in the building and the thickness of the concrete, the coils within the concrete. We don't know if this breakout is from some kind of well that had casing. The magnetometer may not have worked because there is no casing. There's a lot of issues at play here that need to be discussed and taken into consideration for sure.
Okay, I appreciate that answer very much. So prospectively then, if there's going to be an improved line of communication between the commission and the operator, who for the operator? Is it you as an agent of the operator or somebody else within the operator is going to be responsible for maintaining that line of communication?
I would not want to answer that on behalf of my client. I would let Art probably answer that question.
I'll ask it of him. Thank you very much, Ms. Wheeler.
You're welcome. Thank you.
All right. Any additional commissioner questions? I don't have anything further. All right, we tread a bit more ground there on redirect and commissioner questions. Mr. Marsh, do you have any brief recross?
Probably could, but we're fine. Just move on.
Thank you. Mr. Brock, we did have some commissioner questions there. Do you want to do any brief redirect?
I do not.
Okay.
Sounded very scared. I might say yes.
Thank you. I appreciate it.
Yeah.
All right. Ms. Wheeler, we do thank you for your testimony and you may step down.
Thank you.
Mr. Brock, you may call your last witness.
Yes, my last witness. We would call Arthur Benjamin.
Sheriff French, this is Art Benjamin. May I just have a couple minutes to go run to the restroom before we
sure thing. Sure thing. Let's take a 7-minute recess. Give everybody a very short break, and we will reconvene at 3:55. We are off the record and in recess until 3:55. Oh, sorry, I'm on mute. I see we have Mr. Benjamin. Do we have Mr. Marsh and Mr. Brock?
Yes.
All right, Mr. Brock, you may call your witness.
We call Arthur Benjamin.
All right, Mr. Benjamin, will you please raise your right hand for me? Do you swear or affirm the testimony you will give today is the truth, the whole truth, and nothing but the truth?
Yes.
All right, Mr. Brock, you may proceed.
Can you please state your name and business address for the record?
Yes, my name is Art Benjamin. My full name's Arthur Benjamin. Business address is 1221 McKinney Street, Suite 2880. And that's in Houston, Texas, 77010.
Mr. Benjamin, did you cause to be filed pre-filed testimony consisting of 24 pages and no exhibits?
That's correct.
Do you have any changes or corrections to your testimony?
I do not.
If I asked you the same questions today, now that you're under oath, would your answers be the same?
Yes.
I'd move for the admission of the pre-filed testimony of Arthur Benjamin consisting of 24 pages and no exhibits.
Any objections?
No objections beyond what's already been.
Yes, your continuing objection is noted, but we will admit Mr. Benjamin's testimony, reference testimony into the record.
We would tender the witness here, Mr. Chairman.
All right, Mr. Marsh, any cross-examination?
Yes, thank you. Good afternoon, Mr. Benjamin.
Good afternoon.
All right, kind of same story. We're running close to the end of the day, so I'll try to get through this as quickly as possible. When did you begin working for Daylight?
February of 2023.
Okay, on page 2, line 8 of your testimony, you state that Daylight reported a leak to the K.S.A on June 23rd, 2023, correct?
Yes.
Were you at the lease whenever this breakout occurred?
No.
Okay. On exhibit, would the leak have been reported by K.S.A with Daylight Petroleum?
Yes.
Okay.
He's our production foreman.
Okay. And did he contact ECRS Levi Burnett and inform him that a possible abandoned well had broke out and is leaking fluids inside a commercial building located on the Johnson lease?
I believe so.
And it looks like the breakout was caused by the Old House and Farms number 6, correct?
Yes.
And that well has been shut in since August 2023?
With the exception of the well, actually, yeah, that was after the injection test. So yes, it's been shut in since the injection test.
Okay. Why is that well out of compliance with the Commission's rules and regulations?
Why is the Olmhausen 6 out of compliance?
Correct.
At the moment, I was not aware that it was out of compliance.
Okay. You are aware that whenever wells are shut in, that within 90 days of them being shut in, they need to be either returned to service, plugged, or have a temporary abandonment application approved?
Yes.
And Daylight hasn't taken any of those actions in regards to that Old House and Farms number 6 well, correct?
No, we've had discussed abandonment of this well and other options with the K.S.A, and they had requested that it remain idle and able to be injected into.
Okay. But no temporary abandonment application forms have been filed by Daylight, correct?
We have not, no.
In your testimony, you state that the breakout may have been caused due to geologic faulting, an abandoned well, an undocumented core well, or a water well beneath the building, correct?
Yes.
Have you reviewed the geologic faulting records for this area?
I have not.
Okay. Were you present earlier whenever I was talking to Miss Wheeler about the cross sections? Were there any faults depicted on those cross sections?
There were not.
Okay. Have you reviewed water well records for this area?
Looking through what's publicly available, yes, but have not, it did not see any.
Okay. And did you review core well records for this area?
I was unable to find any.
Okay. On page 2, lines 19 through 20 of your testimony, you state that we do not know if in fact there is even a well there, and if so, where it might be located. And then I think later on page 3, lines 20 through 22, you testify that Daylight took extensive efforts in an attempt to definitively determine if an abandoned well actually exists beneath the building without destroying the building. Is that correct?
Yes.
Why did Daylight stop searching for the well?
At this point, we exhausted various methodologies in which we thought would help us find a potential well location. That being doing excavation outside the shop, attempting to hydrovac around the shop, some partial excavation from our observation pit underneath the shop, conducting GPR survey, conducting magnetic survey, and just also review of records, publicly available records, looking at aerial photos, historical aerial photos, anything that any resource that we could find. We were tried to use in finding it. At the latest point, we were requested by an NOV from the K.S.A. to install 4 monitoring wells, which we installed in December of 2023, and I have continued to conduct quarterly samples at the K.S.A.'s request, and have provided those samples. In the meantime, we have not. Yeah, we know of no alternative methods at this point that would be that could definitively identify a well location underneath the shop that we can conduct safely and find a potential well.
Okay. Now, Daylight, excuse me, has had multiple sampling and quarterly sampling done from the monitoring wells, correct?
Yes.
So why has Daylight not gone back and run another GPR scan or magnetic survey scan to see how those results compare to the results that were initially done in 2023?
So I believe Ms. Wheeler talked about the issues around with the GPR scan and the reliability of whether we think that we'll see any difference of data that's there. What was indicated with the GPR scan was we saw areas of what would be higher saturation, which is exactly what we would expect to see with a known leak underneath the building. We don't see how that would specifically change over time, being with the shop floor covering with no active injection in the well. We would not expect that the saturation window would continue to change, and just have not done another GPR survey, and it hasn't been requested.
So are you saying that the ground won't dry out over time?
Immediately beneath the shop would be it would take a longer time.
Yeah, but I mean, here we are, what, year and a half, almost 2 years later. I mean,
I think that's the scale that we're talking about.
Yeah. I know staff's mentioned thermal as well as an option. I believe there's emails from Rolando Moreno about potentially using thermal. Why has Daylight not utilized thermal in this area?
So early on, I believe we had very collaborative sessions with the K.S.A. and we bounced around a lot of ideas. various techniques of what we thought could bear fruit on finding potential information. Each one of these we continue to investigate further. The challenge with thermal is, I mean, ultimately we did not feel that it was going to be worth the effort, or we felt it would be very inconclusive, the results. What we have found with it would be, first off, there's a thick concrete barrier between us and the ground. Thermal would identify temperature changes. The fluid, we would have to reestablish injection, and the fluid that would be moving underneath the shop would already be at ground temperature, or near ground temperature, and we would have to move very large volumes of water, which in order to create a temperature differential that could even be potentially picked up, if at all possible. So we did not feel that a thermo scan would help us identify any definitive results.
Were you present earlier for Troy Russell's testimony?
I've been here the whole day, yes, sir.
Okay. I know that during his testimony, he talked about how, based off the amount of fluid and the short amount of time that it took for the fluid to reach the surface, that it seems like there's a direct conduit there. Did you discuss the thermal at all with KCC staff, or was that just an internal discussion?
That was in our brainstorming sessions. I know that you were even present in some of those meetings. So we discussed a variety of things. I don't recall the full extent of every single every meeting that included the thermal discussion. But I know that we talked about a variety of things.
But staff never said that thermal wouldn't be a possibility or possible way of locating the well, correct?
You're saying a KCC staff member?
Yeah, like KCC staff never indicated that the well or that thermal couldn't be used to locate the well, correct?
They never said that it could or could not be used.
Okay. And I know you mentioned that a magnetic survey was done, or a magnetometer survey was done. When was that conducted?
We ran that survey on the 9th of November, 2023.
Okay. Who ran the survey?
We did.
Okay.
So we purchased a tool. I would compare it to a fancy metal detector. And with that, in that survey, we went around the building. We had to we scanned the floor. What we're looking at is a meter on much like on a standard metal detector. There is no data collected or digital output. We confirmed location of the utility corridor. We confirmed that there is a lot of rebar in the concrete below the shop. Beyond that, there was nothing definitive.
Okay. Why did you not contact staff ahead of time before conducting the survey?
That was an oversight.
Okay. And why was the data that was gathered from that survey not shared with staff or with Ms. Wheeler?
There is no recorded data from the device. It's just a meter that moves.
In multiple places of your testimony, you state that KCC staff has been adamant that Daylight must begin tearing down the landowner's commercial building and searching for what might be an abandoned well, correct?
Yes.
Can you point to any communication from KCC staff that indicates that the building needs to be torn down?
The corollary was drawn from demands that the well be found and plugged. And we have at this point have come with no reasonable solution on how we could find the well without going through the floor of the building. And as we would go through the floor of the building, it becomes the slippery slope of you start to open up and explore and do some damage. If you open up a hole and you seem to get lucky and find the well, that's one end of the spectrum of possible scenarios. But in reality, we have no indication or no evidence as to where exactly we would look. It would be very likely that if we opened up a hole in the floor, we would have to then open up another hole. And if we don't find evidence of a well, we find evidence of contamination, we don't know whether to move north, south, east, west, or deeper in that hole. We would then make another hole and repeat and continue to go down that pathway until the amount of damage is insurmountable and irreparable to the point where we would need to tear down the building. So that is where the corollary in my commentary is come from. What they're requesting of us to saying we have to find and plug the well is that the only pathway we see will be tearing down the building. That is our only way that we can definitively find the well.
So KCC staff has never said that the building needs to be torn down, but that is
They
just
have said that you need to find the well.
assertion that Daylight is drawing based off of KCC staff saying, hey, this well needs to be located and plugged.
Yes.
On page 3, line 10, you state that potential responsible parties exist outside of Daylight, correct? Correct?
Yes.
Okay. Sorry, I didn't hear you. Yeah, said it. Daylight has not requested any parties be added to this action, correct?
That's correct.
And Daylight has not provided any information to staff that indicates there is another person who could be potentially responsible for this well, correct?
Other than the line of questioning around the previous landowner and previous operator and actions that they have taken, there's been no direct.
But those were for other wells that were on Daylight's well inventory, not this specific well, correct?
We don't know the specific well. That's
Right.
that's the crux of the problem.
Right. On page 3, lines 10 through 12, you testify that as a matter of law, Daylight cannot be found negligent simply because it injected at rates and pressures authorized by the commission. Is that correct?
Yes.
Do you have any sort of legal background?
I do not.
Okay.
That was more indicating that we were operating our injection well within the permitted limits of our injection permit from the KCC.
So why not just say that instead of as a matter of law?
I don't know.
Okay. On page 4, lines 6 through 7, you state that there was a GSI recommendation that Daylight proposed to use proposed the use of monitoring wells, and that KCC staff designed a monitoring well program to detect and determine any impacts to fresh and usable water within table 1. Is that correct?
Yes.
And do you remember the letter that I pulled up from Troy? I think you also referenced it. It's a notice of violation letter from November of 2023.
I do.
Okay. And in that letter, didn't Troy ask Daylight to propose a recommendation and that staff would also review that recommendation, but, come up with one on its own to make sure that the recommendations were similar or see what differences there were?
The direction that I'm referring to was the meeting that Ms. Wheeler had with Ms. Schaefer and where they were discussing the requirements that she testified to.
I'm going to bring up Exhibit KCC 1. This is a letter to Daylight from November 1st, 2023, correct?
That's correct.
All right. And at the bottom of page 1, top of page 2, it says, I also requested in my response that Daylight develop a monitoring well construction proposal to be submitted to district staff. Did I read that correctly?
That is correct.
Okay. And then in the bottom of page 2, top of page 3, Troy lists the outlines or recommendations of staff include including constructing 4 monitoring wells that were 150 feet from the source. And provided recommended locations, that the total depth of the wells would be no deeper than 140 feet, a minimum of 6-inch diameter, Schedule 40 PVC pipe, and additional wells to define contamination extent in any direction verified from sampling the initial round of monitoring wells. Did I read that correctly?
That is correct.
Okay. And I'm going to circle back to something real quick. I know that one of the notes that Levi had taken down was that well, let's start with this. Is there a Rob Tidwell that works for Daylight?
Yes, that's our production superintendent that covers Oklahoma and Kansas.
So why did he communicate to staff that Daylight Petroleum had no desire to explore underneath the commercial building's concrete floor?
He was probably speaking more along the lines of what his communications with the landowner. He was our primary contact directly with the landowner, and the landowner was very much against us doing anything that would have any intervention below that would cause any intervention that would go through the floor of his shop.
Okay. And on page 5, lines 1 through 3, you state that it would constitute economic waste to destroy a commercial building against the will of the owner of the building in order to look for a possible well, correct?
Yes.
If destroying the building is against the will of the landowner, why did Daylight not have him testify in this matter?
I don't know.
And since you're
I know that
present,
KCC had direct conversations with him too, and he expressed to us that he shared the same sentiment to the KCC.
Okay. And as you know, you previously saw staff testify. I'm getting tongue tied at the end of the day here. I apologize. That staff's earlier testimony indicated that they did not feel like the building needs to be destroyed in order to locate and plug this well, correct?
Yes, that was their testimony.
Okay. On page 5, lines 9 through 13, you testify that if the building must be torn down in order to look for an abandoned well, then staff will need to perform an investigation pursuant to K.S.A. 55-178 to determine if in fact a well does exist beneath the building, and if a well is found, the responsible party will need to be determined in a manner prescribed by K.S.A. 55-179. Hasn't staff already sent Daylight 2 letters that identified Daylight as a potentially responsible party for any well located under the building?
Yes.
Okay. On page 6, lines 3 through 4, you testify that KCC staff has been unwilling to consider anything less than an exploratory digging expedition beneath the building, correct?
Yes.
So if that's the case, then why did staff allow Daylight to run a GPR scan inside the building?
The commentary around the exploratory digging is at our current state where we're at. We have we attempted to collect additional data to see if we could identify a potential well location, but none of our data has shown definitive existence of a wellbore and a definitive existence of where we would locate a well. And outside of that, the only thing that the KCC would have us do would be to continue to plug or to locate and plug that well per the 2 NOVs that you were referencing.
But based off of staff's testimony today, I'm sorry, I cut you off.
And with that, I mean, we don't see any feasible options other than going through the floor.
So staff earlier today testified that they believe that there's other data points that can be collected in order to locate and identify that well. So do you still feel that way, that the only way to locate this well is by going through the floor?
We would be very open and willing to collect additional data, which is what we were originally proposing around collecting with our monitoring program that were installed at your request.
On page 6, lines 5 through 8 of your testimony, you testified that KCC staff's refusal to even consider the damage to the landowner through the loss of its commercial building and interruption of its business and the impact of these actions on Daylight when less extreme measures adequately protect fresh and usable water constitute economic waste. Is that correct?
Yes.
Okay. Are you familiar with the term economic waste?
With as much as my attorney has discussed with me about it.
Okay. If Daylight does not, well, if there, hypothetically, let's say there's a well underneath this building, and I think staff's pretty confident that there is, and that at least Ms. Wheeler seems to indicate that there's at least some sort of vertical, you can't see the pin I'm holding, but there's some sort of vertical conduit beneath the building. If that well is not located and plugged, then what future impact will that have on the mineral owners of the lease?
I don't think it would have any impact on production on a future lease or lease to be taken. Wells could still be drilled and produced in the area if anything was deemed reasonable. The area has already been developed with wells with the historical production. So I don't know if there would be deeper targets, things like that would be explored for. But with respect to injection in the area, I think that it would impact the ability to inject in the future. I think it would be very unlikely that any future injection permits in the area would ever be approved by your agency.
Okay, and is the primary method of recovering oil in this area through a secondary recovery, like through a water flood or some sort of injection?
Not necessarily. It's usually primary and artificial lift, rod pumping. In our area, there are disposal wells that are in deeper horizons, or there's injection wells that are in the same horizon. And in this, the Olnhausen 6 was a injector in the same horizon, was a a water flood.
Did Daylight collect water samples from the lease prior to this breakout occurring?
We never produced any wells from this lease. The neighboring Olnhausen, we would have had some series of water samples from the water production, things like that, from chemical testing and those type of things. But Daylight never produced any wells from the Johnson lease.
And maybe I should clarify, because there can be multiple types of water samples here, but water samples from table 1.
No, no.
Has Daylight taken any water samples from adjacent properties? From
table 1?
Yeah, in table 1.
No.
Okay.
Not to my knowledge.
On page 6, lines 7 through 13 of your testimony, you state that Daylight has caused other wells in this area to break out from injection into the Olnhausen lease, correct?
Yes, during completion activity on the Olnhausen lease, there was a breakout well.
Okay. So your field staff would have been pretty familiar with what a breakout looks like at that point, correct?
Yes.
Okay. And Daylight previously acidized and fracked into the Olnhausen Farms number 6 before it was converted into an injection well, correct?
That's correct.
Okay. On page 8, I think 5 through 11, you talk about observation pit that was dug on the south side of the building. Is that correct?
Yes.
And that Daylight closed that observation pit on September 21st, 2024, correct?
Yes.
So are you familiar with the email from Rolando to Troy about installing a monitoring well in that pit before closing it?
I am.
Okay, so why was the monitoring well not installed in the observation pit?
So the initial and from the email, we had proposed that we would close the monitoring pit and install. Close the observation pit and install a monitoring well. At that time, later learned that in order to install the monitoring well, we would close the proper way to do it would be close the pit, seal it up, and then at a future date go and drill a well and install it. When we closed the pit, there was no more contamination coming into the pit after the injection was stopped. We have not gone back and installed a subsequent monitoring well. It wasn't requested in the NOV that was subsequent to us closing the pit that did request additional monitoring wells in the area. And there was no mention of an additional monitoring well. I would say at this point in time, if it's deemed valuable, we will happily go back and put one in.
Okay. And since, I mean, there still could be a leak happening there, correct? It just won't have the same pressure since the Old Housing Farms number 6 isn't operating, right?
With how fast the leak started and stopped, with us starting and stopping injection on the Old Housing 6, I think the correlation is very strong that it's directly tied to that. Could there still be migration and leaking? It's impossible to say.
And there's no way to know without that monitoring well in place, correct? Or at least know for the south side of the building.
We saw no evidence of it with the observation pit, but yes, I think that's a fair statement.
On page 10, line 6 through 9, you testify that you're not aware of any other operators in Kansas who have voluntarily utilized GPR and magnetic surveys to search for an abandoned well, correct?
Correct.
How many Kansas oil and gas operators has Daylight spoken with about locating abandoned wells?
We spoke to some of the operators that were in the area. It is slipping in my mind are the one that acquired our Woodson County acreage and for our wells north of here, Lehman Oil and Gas. We spoke with them about their experience in it. I'm not sure who else the field personnel reached out to. We asked them to reach out and talk to various people.
Did you ever speak to any other operators who had a breakout underneath a building?
I have not found another situation like that.
Okay. We previously talked about the GPR survey, and that was conducted by GSI, correct?
GSI did, yes. They conducted it.
And why was staff not notified of that survey prior to it being conducted?
Or that they were not notified.
Okay. On page 12,
I was under the impression that they were notified. We had discussed the timing of it in multiple meetings with them. I thought that they were notified of the scheduling of it.
okay. I don't know that this was part of any exhibits, but I'll share it just for clarification of the record. So this is an email from Troy to Rolando. And I believe you were CC'd on it. It was dated September 5th at 9:40 a.m. It says, Rolando, thank you for the update on Daylight's plan of action. Please notify the district office when activities identified in your email are to occur, so staff will have the opportunity to witness. You mentioned speaking with me and, was supportive of extending the September 29th, 2023 deadline. Did I read that correctly?
Yes.
And sorry, I was looking for something else, but I think the previous email from Rolando references using the GPR, correct? And that's from August 29th, 2023.
That appears correct.
Okay. And then the last email or the top emails from Londo has all of us CC'd on it. It says Troy, GPR activities were scheduled to begin today, September 5th, 2023 at 10 a.m. And that email was sent at 10:06 a.m., correct?
Yes.
So maybe a little bit of a timing issue as far as, being short on time, but staff wasn't notified of the GPR ahead of time, correct?
I'm not aware
At least
of any.
notified of when the GPR was going to be conducted ahead of time, correct?
I'm not aware of any.
Okay. On page 11, lines 8 through 10, you testified that Daylight has spent another $17,000 plugging the Johnson number 6 and Johnson number 7 wells, which had been improperly abandoned and cut off below the ground by a previous operator, correct?
That's correct.
And those two wells in particular were transferred and on Daylight's license, isn't that correct?
They were, yes.
Okay, so what or maybe why not did Daylight conduct due diligence when acquiring the lease?
The transfer of operatorship went from well, the way that this organization is structured, we have a private equity company that owns the wells. They had a previous operating company that operated the wells. When we transferred them internally, or transferred the ownership or operatorship to Daylight, we transferred what they had listed and did not have a separate due diligence.
Okay, so Daylight didn't go out and inspect these well locations before accepting them on the T1, then, correct? Which I get that's probably a little bit before your time, so that maybe it's not a fair question, but
I suspect that's the case.
okay. On page 12, lines 3 through 12, you acknowledge that Daylight would at least begin searching for this well by going through the floor to plug it, correct?
Yes.
And I know that staff today has kind of said that, or testified that, hey, it might be possible or very well possible to plug this well without having to go through the floor at all. Would that be preferable to Daylight?
It would be very preferable to go through another way without accessing through a floor.
Right. And if the well is able to be plugged without going through the floor, I mean, what kind of damages would there be?
If you were able to access without going through the floor, the impact of the building would be minimal.
Hopefully there won't be any at all, correct?
Agree.
On page 12, lines 17 through 19, you state that Daylight does recognize that groundwater monitoring and remediation is not a typical practice overseen by KCC staff, and as a result feels unfamiliar and novel to them, correct?
Yes.
Okay. And were you present for whenever Director Ryan Hoffman was testifying earlier?
Yes.
So you would have heard his testimony about KCC staff having 41 contamination sites throughout the state where staff has been conducting long-term monitoring and remediation.
Yes.
So does that change your testimony?
My information was based off of what I had learned from our discussions with our environmental consultant.
Okay. Who was your environmental consultant?
K.S.A.
Okay.
Kelsey Wheeler, yes.
All right. Have you ever discussed with staff what groundwater monitoring and remediation projects they oversee?
I have not.
One of your recommendations is for the pollution from the breakout well to be moved to K.S.A's voluntary cleanup and property redevelopment program, correct?
Yes.
And you are aware that K.C.C. or pollution related to K.C.C. oil and gas is not cannot be part of that project?
I saw your questions to Kelsey on that and her response, so I'm aware of that interaction.
Okay. On page 13, lines 15 through 16, you state that there's no evidence at all that would indicate the breakout ever released fluids below surface, correct?
Yes.
Daylight has not conducted any integrity tests on the conduit beneath the building, correct?
On the electrical conduit, is that what you're referring to?
No,
or-
the conduit, the whatever the well is, whatever type of well it is, and I mean,
we
I'm
have not
assuming the
identified
answer is-
a well.
right.
No.
So there's no way, since the well hasn't been identified, there's no way to conduct a integrity test on it, correct?
Correct.
And you would agree with me that older wells are not always cemented back to surface, correct?
That's true.
So it is possible that, whatever this conduit or well bore or whatever it is beneath the building doesn't have integrity. Is that correct?
I think that there were many methods that, or many scenarios that Kelsey had laid forth that would provide for an uncemented pathway.
Okay.
Including a potentially old well.
Right. On page 14, lines 4 through 6, you testify that GSI has concluded with a high degree of confidence through the groundwater monitoring program that the known release has not impacted groundwater within the table 1 interval, correct?
Yes.
And I know I discussed this with Kelsey, and I'm going to bring it up again with you. This is from her testimony, page 7, lines 8 through 11.
Okay.
Can you see this?
Yes.
Okay. Starting with line 8, it says, based upon the data gathered today, it cannot be determined with absolute certainty if the chloride concentrations in groundwater are from naturally occurring concentrations within the subject formations or from historic poor management practices in the area of oil production or a more recent release. Did I read that correctly?
Yes.
And as far as the chlorides go, I know that we've pulled up the data that's been taken. The chloride levels for, I think it's PMW-2 have constantly increased, correct?
Yes.
And the most recent chloride concentration taken from that well was 2,440 milligrams per liter, correct?
That is correct.
On page 15, lines 4 through 5, you testify that water can be protected without finding and plugging this well, correct?
Please repeat that. I'm sorry. I was looking for the quote.
I believe it's page 15, lines 4 through 5. At least that's what I have down here, so I hope it's right. You testify that water can be protected without finding and plugging this well, correct?
Yes.
How can table 1 be protected if there's no casing or cement present?
The current thought is that the injection well was the source of the fluid and the energy that was causing formation fluids to go into to the building. With the stopping of injection of fluid in the old housing 6 and monitoring the area, we can monitor to determine if contamination is being impacted, or if the table is being impacted through continued monitoring. If the contamination continues, if evidence shows that we have an impact, then further steps would have to be made.
So is Daylight suggesting that pollution has to happen first in order to do something with this well?
I'm suggesting that we have put in the monitoring wells and we should continue to monitor.
On page 17, line 6 through 7, you state that while an abandoned well is one possibility, there are many other possibilities that are equally likely, correct?
Yes.
What would you say is the most common way for oil and brine to be brought to surface?
So in the area or in conventional oil and gas activity through wells. In this area, in the immediate vicinity, we are on or we are very close to the what is it? I forgot the name of the well, actually. The Norman #1 well, which is the original well for the area that was drilled and discovered, and there's the oil museum that's in Neodeshe. That was discovered and drilled based off of oil seeps at the surface.
Would you say there are a lot more oil wells in eastern Kansas than oil seeps?
Yes, as technology has improved, but the original methodology for looking for it was following oil seeps, and that was the original development in this area.
And oil seeps is when oil is coming out of the side of a formation, right? And so you can see the oil coming out, and then
it's when oil comes to surface.
On page 18, lines 1 through 2, you say that the KCC keeps records of all wells drilled in the state and should have records of any well drilled after 1958, correct?
Yes.
So when a well is drilled, or well, I guess the question is, how many wells has Daylight drilled in Kansas?
I don't know that off the top of my head, but I mean, tens.
And I guess
we operated over 1,000 wells, but the actual ones that we drilled was in the tens, and all the drilling activity predated my time with Daylight.
Okay. But Daylight's familiar with that process, right? And what I'm getting at is when a well is drilled, forms are filled out by operators and submitted to the KCC, correct?
Yes.
So if an operator drills a well but doesn't fill out the forms and provide them to the KCC, then there may not necessarily be a well record, correct?
That's correct.
I think getting to the end of it, on page 21, lines 2 through 3, you state that it's the commission's primary duty to prevent waste, correct?
Yes.
And are you familiar with K.S.A. 55-602?
I am not.
Okay. Are you familiar with the attachments to Ryan Hoffman's testimony?
I can pull them up.
I think 55602 is exhibit RH1, page 204. Maybe
Mr.
this is-
Marsh, out of curiosity, I know I've got a hard stop at 5:15. How much
Okay.
longer
This
do you
might-
have for
This
cross?
is my last question.
Okay, because we've still got commissioner questions, we've got
Right.
redirect, and we've got closing statements.
And maybe I can't ask this question. I was just going to ask if there's anything in that statute that indicates that preventing waste has priority or takes precedence over protecting fresh and usable water.
Mr. Brock, do you have any objection?
I mean, it calls for a legal answer and it's case law anyways. It's not a statutory.
I'll sustain the objection.
Okay. No further questions then.
All right, commissioner questions at this point. Commissioner Keen, do you have any questions for this witness?
Yes, I do, Chair French. Your choice, I guess, Mr. Benjamin. Good afternoon or evening. Whether you're in Houston or
Hopefully
Kansas,
it's not good morning.
I think it's about the same thing. Tell me a little bit about Daylight. Let's start with that. How many states do you operate in?
We operate in 4 states.
And which are they?
Kansas, Oklahoma, Texas, and Louisiana.
All right. And I think you indicated this recently. Roughly how many wells do you operate?
In total, we have about 4,000 wellbores.
So what does that mean? You have a certain number of producers, certain number of injectors. What does that tell me?
Yeah, the majority, well, of the wellbores, I mean, we're a conventional oil and gas operating company. Most of our fields that we operate are older fields, not new developments. We're not in the shale plays or any of that. We're in older conventional areas. With that, we have usually very large well counts, a large percentage of wells that are idle wellbores. But we manage with the remaining wells. In some areas, we have active floods, whether it be water floods or CO2 floods. So we have injectors in those cases. In other areas, our injectors would be SWD wells. But the majority of our active wells, how I would categorize them, are producing wells.
Okay. How many wells do you have in Kansas?
I don't recall the total count, but it was over 1,000. Prior to, this was in what we operated in Woodson and Wilson County.
So you're predominantly operating in those 2 counties, if I understand it.
Yes.
Correct.
Yes.
And you say you have over 1,000 wells in those 2 counties?
In those 2 counties, yes.
Okay. Well, I'm looking at public information here. No mousetrapping whatsoever. I'm looking at the survey website, and it shows that for 2024 you had 295 wells.
So we sold in March of 2024. We sold our Woodson County acreage. I don't have the breakdown of the well count and the by area specifically. We sold our Woodson County acreage to Lehman in March of 2024, and then at the end of 2024. We sold our Wilson County production to Blue Jacket.
Okay. Again, I'm looking at the survey information here. It appears, did Daylight acquire most of the wells in Kansas roughly starting in 2018? Is that close to right?
We took over operatorship at that point in time. Our predecessor had acquired them before that.
Who was the predecessor?
The Phoenician Resources is the parent company, and they own the wells. The previous operator, it predated my time. I don't recall the name of the company.
Okay. Now let's talk about your field staff a bit. Your production foreman or production supervisor is who again?
Our production superintendent is Rob Tidwell, He was based or is based out of Lindsay, Oklahoma. The production foreman was Kelly. Oh gosh, I'm drawing a blank. I'm sorry.
Is Rolando Moreno still with the company?
He is. He is my health, safety, environmental regulatory manager.
Okay. When this surface breakout arose, I don't mean to go over these too quickly. If you want to give some further embellishment to anything I've asked you so far.
No, I'm good.
All right.
See if I can answer your question about the staff, but sorry.
Okay.
K.S.A, sorry. K.S.A is our production foreman in the area.
Okay. Currently, right.
And he, since we sold the operations in the area, he is still an employee of Daylight. He has moved to our Lindsay, Oklahoma operations.
Okay.
But he is on reserve to handle any of our remaining Kansas operations, and is available.
Okay. Okay. Ballpark here. Given the fact that you predominantly buy production, or you buy wells in lieu of drilling, what's the average age of your wells in Kansas? Any idea what that is?
I don't know off the top of my head, but it's decades old.
50 plus years in some cases.
Possibly, yeah.
Yeah. How close, in fact, are you to the number one Norman? Are you on the outskirts of Neoshe?
We are. This site is about a mile away from that location.
Interesting. The reason I ask you about the age of the wells is I'm wondering, of the wells that you have, how many of those were completed with alternate to cemented completions? You know what I mean by that? I mean, where the casing is cemented in from the bottom to the surface. How many of those would qualify?
I don't have that specific breakdown, but I do know our wells in this area though are aged back to the known wells that we have. Our first batch were drilled in the 50s, then in the 70s and 80s.
Okay,
in this immediate area.
So I'm
and then more recently.
Pardon me, I talked over you.
No, I'm sorry. That I was just saying that then until our most recent development, where we drilled wells on the old house and lease adjacent to this.
Okay. So I take it that you have a fair number of wells that are not cemented to the surface. Would that be fair to say, where the casing is not cemented to the surface?
That's probably fair.
You have a fair number of wells where you have to use production packers.
I don't know that breakdown.
You do use production packers?
Yes.
Okay.
In some areas.
Okay. Let's kind of focus us a little bit more. I guess the question I have is, and it kind of goes back to the testimony of Mr. Russell, the district director. Are you willing prospectively to explore with the KCC whether other alternative methods could be utilized to locate a potential abandoned well beyond those methods that have been utilized to date?
Yes.
Okay. I think because it's been the subject of so much conversation today, I get the issue and the problem about drilling through the floor. I think I get that. I'm not an engineer, but I think even as a business guy with a law degree, I can grasp that. Is the size of this building, Mr. Russell guesstimated it was 80 feet by 100. Is that ballpark correct?
Yeah, that's about right. I think our construction expert came up with a number that for the adding the 2 square footage about 8,900 square feet. So 80 by 100 would be 8,000. So
okay. So here's what I'm wondering here is, okay, so if going through the floor is problematic for a variety of reasons, not the least of which is the fact that the owner of the building doesn't want it to happen because of the scope of damage he perceives that would happen. Can't there be excavating of some sort to go on around the perimeter of the building to try to maybe even further precisely identify what the source of this pooling of oil and water is?
Our challenge, we dug the observation pit on the immediate south side, and that was a roughly 6-foot deep hole. Just outside of the building. It was on, I mean, we had to go through the driveway. In that we hand dug back up underneath the building a few feet. I mean, at most arm's length, I would say. We did not feel comfortable putting any person underneath what would be any type of structure or anything there. To explore underneath a building like that, you would have to build some sort of substructure engineered, like you would for shoring ditches and things like that. It gets to I think a pretty complicated process and things like that to me then goes back to you're talking about things that are the scope of the price of the building. The value of the building.
It strikes me that if you started at the point where the leak was, where the surface breakout was discovered, and you kind of move back from that, or is that what you did?
We put the observation pit just outside of the shop where that breakout had occurred, as close to that conduit as possible, and that's what we were trying to see. Was it located there?
Okay.
And we found no evidence of that would indicate well. We saw some staining, and we saw the staining that was right at the concrete soil interface.
Okay. Who handles your compliance work for Kansas with the KCC?
Who within our organization?
Yes, right.
Is that? Yeah. Okay. I guess if you're referring to the paperwork aspect of it, it's a combination of 2 personnel. We have the HSE manager who Rolanda Moreno, you mentioned before, and then we also have a regulatory admin that's based out of Kansas, Jennifer Peters, who does a lot of the actual filing of the paperwork and stuff for us.
Okay. If there was, hypothetically, respectively, an effort to try to explore with the KCC other alternatives than what have been explored so far, I guess who specifically would be the company's contact person with the KCC?
That would fall under my team's responsibility. Rolanda would be a good starting point.
And the reason I ask you that is, it strikes me that, and I'm not throwing stones in any direction here, but one of the problems that got us here today was an profound absence, in my opinion, of communication that could have been better. It could have been improved. And so I think prospectively, if it isn't improved, we probably won't go very far. But if it is, there may be some hope. That's the reason I ask. That's the sole reason I ask.
Understand.
Let me go back to, I don't mean for this to be unfair in any respect. Let's go back to some questions that were asked earlier of Brian Hoffman, the director of the Conservation Division. Mr. Benjamin, what are your company's long-term plans and goals in Kansas?
In the immediate future, we have sold of our producing assets that are in the area. We have retained our liabilities that we had. Well, we had retained some liabilities in Woodson County. And we retained the Johnson leased wells and the Olnhausen number 6 well because of this specific issue that we're here before you today on. Our long-term plan is to continue to maintain our operator license here and work with the commission on dealing with these issues for these specific things to continue on with that. But outside of that, we have no near-term plans to own any wells in the area. In the long term, we may see future investment where we do come back if conditions are right or if an opportunity presents itself and fits within our portfolio. But at the moment, we're not actively pursuing anything.
Generally, are your plans to operate and produce wells or to place them in a position where they can be sold?
With respect to Kansas?
Yes.
We have sold all of our production. So the remaining things that we have would be liabilities. They're not anything that anyone would buy. So it's on us to remain and see these through.
Okay.
We have extensive deeper roots just south in Oklahoma, and that's where we will continue to manage any operations. That'll be our base where we manage anything in the future from Kansas or for Kansas.
Okay. I believe that's the extent of my questions. Mr. Benjamin, I appreciate your indulgence and patience with my questions. No further questions of this witness, Mr. Chairman.
All right, Commissioner Keither, any questions?
Not right now. Commissioner Keen covered a base for me.
All right. Well, as I mentioned, I've got to stop here in a few minutes, but I'm going to squeeze in a question while I have the opportunity. Good afternoon, Mr. Benjamin. You are Vice President of Operations, correct?
Yes, sir.
Okay. What I want to ask about relates to your testimony talking about other potential parties that may be legally responsible indirectly. I assume that you hold insurance covering your drilling operations and liabilities associated with that, correct?
That is correct.
And what has been, I assume you have looked into the applicability of that insurance to this rather novel situation. Is that correct?
Yes, we have.
And what has been the opinion of your insurance folks, your legal counsel, as to the applicability of that insurance? Have you asked for an opinion from your insurance company?
We have not received an opinion yet on a determination.
Can you describe for me what might be the question or what might be the difficulty with there being coverage of this situation?
The question of coverage from insurance, I think, would fall under the fact that where this occurred was not on an active producing well location, anything that we had identified. That would be, I think, the what opens a question there.
Yeah.
It's in the vicinity of one of our leases and our expired lease and in offset active activity.
Yeah. I mean, it just seems to me an obvious question that needs to be explored because it's clearly or potentially a liability as a result of legitimate production exploration activities. And I mean, you do have a situation here down the road where there could be a liability for damage to property as you've laid out. And seems ripe for that to be an insurance type of situation. So I hope you understand, where I'm asking that question from. So
I believe I do.
just want to make sure that it has been explored. It sounds like from your answer, there is more exploration to be done on that as the facts of this case develop and you determine, what course of action you have to take. So, all right. I don't think I have anything more for you. Are there any other commissioner questions before we return to redirect? Commissioner Keen?
I appreciate your time constraints, Chair French, and I'll try to be brief, and I think everybody's kind of tired now anyway. What's your average daily oil production on all your leases in Kansas right now?
Today, nothing, because we don't have any more producers.
Okay.
But at the time of this leak, it was, I would say, less than a barrel a day per well.
Okay, very good. Thank you very much. Again, I appreciate your indulgence. That's it. Thank you, Chair French.
All right. Mr. Brock, go ahead with redirect, and I will just remind everybody, I have a pretty hard stop around 5:15 or 5:20. So if it's okay, if I disappear, Commissioner Keen, I'm going to hand the reins over to you to finish out the hearing. So that will be the plan, if Commissioner Keen accepts it. All right. Then we will go to Mr. Brock for redirect.
Earlier you testified that essentially Daylight knew of no other methods that could be used to search for the source of this breakout. Is that correct?
Yes.
So you felt that you had done all the research, asked all the questions, consulted with all the experts, and essentially hit a place where you didn't know where else to go from there. Is that right?
We through all the methodologies and stuff that we had investigated, we found no other plausible solutions or plausible methodologies that we felt would bear any fruit.
Today, there's been testimony that staff really wants to see some more ground penetrating radar, digging around the building, magnetometer searches. Had you heard about any of that before they testified to it today?
No.
And would you agree that even back at the beginning in August of 2023, was staff pretty insistent that the next step was to cut a hole in this floor of this commercial building?
They were very insistent that they've been consistent around we need to find the well and plug the well. And it was through our efforts and investigation, we feel the only remaining way to prove or disprove on a well location would be to go through the floor. So that's how we have drawn that conclusion.
And even during that time, wasn't a significant amount of that conversation around staff's contention that floor and the in-floor heating could be repaired if it were cut, that it wasn't as big a deal as it was being made out to be?
They indicated that in the meetings, yes.
And did you consult with other experts about cutting through the floor and the ability to repair in-floor heating system?
In our efforts here, we did an extensive search online, then tried finding resources that were there. We looked for in-floor heating vendors, reached out to multiple vendors. It was difficult even getting contact back from vendors, but the few that did get back with our team indicated that they had no confidence that this could be done, could be repaired. that they would warranty a repair. Let me restate that they would warranty a repair like this.
Do you feel, well, I guess I'm not going to ask if you feel, would Daylight welcome help to try to resolve this situation in ways that don't cause destruction to the building?
Absolutely.
I mean, is that in essence what you're asking the commission for today? That you need a solution that works? You need to be able to do something that's physically possible to do to resolve the situation that's acceptable to everyone?
Yes, I at this point we don't see a pathway to explore under the building without going through the floor. And if there were alternative methods, we would be open to considering.
And so just to be clear, it's not that this docket is a line in the sand, so to speak. It's, we don't know what else to do. Is that accurate?
Yes, that's correct.
I think all of my other questions have been covered. I know we're running short on time. I don't believe I have any more.
All right, thank you, Mr. Brock. Any need for additional commissioner questions or recross? I'm going to suggest that we probably don't unless somebody's really on fire. All right, let's move forward. Mr. Benjamin, we do thank you for your time and your testimony here today. Appreciate you joining us. You may step down at this time.
Thank you.
All
Chairman.
right, you're welcome. We're going to closing statements, but before I run, I want to handle one post-hearing issue, and that it does sound like the parties will need to set up briefing. I'm going to suggest that staff and operator get together and before close of business tomorrow, send an email to the pre-hearing officer, Mr. Myers, with a proposed briefing schedule. Does that work for you all?
Yes, that works for me.
That's fine.
Okay, thank you. With that, why don't we move to closing statements, beginning with Mr. Brock, and I will turn things over to Commissioner Keen to play out the rest of this. Thank you all. Mr. Brock, go ahead.
So I think I can be very brief with this. Out of all of the testimony, out of all the evidence, out of everything that's been discussed, the issue is that you don't have an operator before you who's trying to skirt compliance. You have an operator before you who is trying everything that they can think of to comply. And they need some help. They've hired a third party. The third party wasn't successful. They're proposing the KDHE to help. The staff is saying, we don't need their help. Well, frankly, Daylight doesn't care where its help comes from, but we need someone to come in and find a solution because we feel that we've exhausted all the alternatives. And that's all that's being asked here. But before this was filed with the involvement, it was staff's position that the next step was to cut this floor. I understand that's not the position that's being taken now, but that has been the dynamic up to this point, that's where we were. That was the hard deadline that was set. That's what forced this matter before the commission to try to take some action before, penalties began or another docket started or whatever the results would be, and it turned into something penal in nature. That's where Daylight was. This is one of those situations, I alluded to it in my opening statement, but this thing is a can of worms. This situation is unique. And if there was a concerted effort to solve it in a way that worked for both parties, if the commission could look at it and find a solution that's physically possible and protects fresh and usable water, and also protects this building, thereby preventing waste, that's the kind of solution that we need. Honestly, I think that's the only point that I wanted to make. You know, it isn't that Daylight's insisting on, you know, this has to be done via monitoring wells. That's just the best idea they have. It isn't that we have to submit this to a voluntary program with with KDHE through the VCPR. That's just the best idea that we have. And so we're proposing that. These are intended to be, you know, ideas, concessions, protections, you know, things that would assist, not an ultimatum. You know, we under no circumstances are suggesting that the KCC shouldn't have jurisdiction, but we need some help. We need a path forward. That's all that we're looking for. That concludes my closing remarks, and I appreciate the commission's time today.
Thank you very much, Mr. Brock. Closing statement, Mr. Marsh.
Thank you, Commissioner Keen. I'll try to be briefer. You know, it does seem like maybe breakdown of communication was an issue here, but I think part of that was brought on by Daylight, you know, basically saying, hey, this is what we've done. We feel like this is be good enough, so we're not going to do anything more. I think it's also important to circle back around to, you know, the petition that opened this docket. That petition was basically hey, does it constitute waste to locate and plug a well? And I think the answer is still no. And I think we can cover that in briefs. But, and I say my answer, I think staff's position is that the answer is no. And I think that the law is pretty clear on that. So with that being said, you know, it sounds like the next step is going to be briefs, but I don't know that there's anything that's been presented today that would indicate that this well shouldn't be located and plugged. So thank you for your time, commissioners, and appreciate it.
Thank you, Mr. Marsh. Well, I think before his departure, the chair pretty much settled between the two respective councils the proposal that you get together. Give us some clue about the briefing schedule that you propose, and to forward that to Mr. Myers tomorrow. With that, it appears to me that this all concludes the hearing in this docket. At this time, we're going to close the record and adjourn. I want to thank all of you for your participation in this hearing, and have a good evening. Take care.
Thank you.